Boom, 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 boom. Good morning, everyone. There's a few people here. Lovely to see you. Lovely to see you. Luck. Looking forward to hearing. Right, yeah. I mean, they're in there. They're in. I'll get it screwed up now. See you all tomorrow morning. She left you last night. Thank you, Wendy H. Wendy H became a member last night. I'm not sure why it's in here, but thanks again to Wendy H. I mean, she gifted like five and bought one for herself. So thank you again, Wendy. Good morning, Toxic. Hope you're well. I hope you're feeling better and hope Banshee's well as well. Give Banshee our love. Oh, Spidey's in. Young, how are you, love? Hope you're well, love. So, and you like the video this morning, love, yeah? Don't forget to hit the like button. See Spidey's Monday morning. She is on it. She's been slacking for the last few weeks, but she's on it now. So it's good. Joking, Spidey, don't hit me. There we are. Hi, hi, hi. Sarah P. Sarah P. Yes, good afternoon for me, but good morning for most people here. And welcome back to Sarah P. I love Sarah P being here. Uh, remember to use as well. You started using the Discord, Sarah. Just remember, keep using it. I love your takes. I love Spidey's takes. We need to utilize it a little bit more. Um, hi, Bunchy. I didn't know the Banshee was actually born in Ireland. I thought his family were just from there. Do you know what I mean? So, but yeah, that's always interesting. There she is, and Spidey, Sarah's there, and there my heart went boom boom. I bet my heart went boom boom, and everybody say, hey hey hey, hey 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 hey, hey hey. So I streamed last night. I'm a chat bust. I couldn't even see the chat last night. I had to get a chat on another bloody thing. Hang on, let me get Spidey's message up. Well, here she is. Here she is. JB. I've not seen Jamie for ages. Or it seems like I've not seen you for ages, Jamie. Um, I know you went on a date last night, apparently. Everyone's saying that you went on a date. Hopefully it went well for you. I hope you enjoyed it. I hope he treated you well. I'll just get Spidey's thing up here now, so we get that up. I'm excited to finally throw this trolley in the archives, yes. I just hope it's not like, how can I say, just hope. Do we get a verdict today? That's the question, isn't it? Let me get it up. The stream that is. Hoi, oi, dirty bitches. Right, here we go. Stream's there. The judge has been in quite early, so I've been watching this in the background for like half an hour. And the judges there, they're all setting up. Seen Scott this morning, and everything like that. So they're all there. The lawyers were looking. You can't see now, but there's an officer there. So yes, good. Uh, yeah, I think so as well. Toxic. I think there'll be a result today. I think so. Jamie says, "Lol, I don't know what anyone's talking about. Neither do I. I just was told that you went on a date." Because I was like, "Where's Jamie? She's not even on." They're like, "Oh, she's going on a date." I was like, "Oh, Jamie, whoa! If you can't behave, use protection." Oi, oi, Jamie. So that's all I know. Everyone's excited for you though. So just so people know, whoa, 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 Spidey's on it again. Whoa, 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 whoa. Right. Here we go. Oh, Susan.
Okay, understood. Cool. Yes, sir.
I just need clarification. Obviously, I am not legally allowed because of Halliburton to say they didn't call a particular witness. However, there is the reasonable doubt instruction that says that evidence reasonable doubt can be found from the evidence, conflicts in evidence, and the lack of evidence. I will be focusing on a lack of evidence, and I don't want to be held back from bringing up evidence, for example, like what Curcio said, that Riddick had a file that contained documents, that contained interviews with the students that exited the 700 and 500 building. There's a fine line between saying they didn't call him and me highlighting the things that we know that he would have done as the investigator. So I just wanted to make sure that's.
Yeah, listen, I mean, I think that's okay. There was testimony from the detective about, I believe he kept referring to FDLE as handling the investigation into the law enforcement response, and there was certainly testimony to that, so.
Who's that guy? Is that a detective or is that like a father to everybody? Spider, they have, I believe, they're just finalising jury instructions. Jury instructions is done. They're just finalising some slight tweaks, but I think we're ready to go at 1:30. Yeah, who is that guy? Why are they zooming in on him for?
And the other thing is, I certainly want to highlight the failures that came up during trial by higher ups.
Thanks, Jamie.
The failure of debriefings, the failure of.
Oh, hang on. Is it low? Hang on. It might be my end. I can hear it clearly. I can hear clearly now. The rain has gone. I will use my extension. Right.
The patching of the radio.
Right. That's going to be loud. So beware. Turn it down a little bit, maybe. I've put it on 600 now, volume. So I'm going to turn mine one down before I press play as well. Here we go. Here we go. Here we go. Here we go. Right.
Using an old radio system. All
Hope
these
that's better,
things,
Toxic.
I believe the evidence shows were a result of mistakes made by higher ups. And while that's not, I think, what they're addressing, I don't want that to be a problem.
Yeah, I mean, that was part of the testimony. So
Yeah.
each side can make arguments, reasonable inference as to whatever evidence, witnesses, or testimony they think it supports. I have no policies, but I would probably handle any objections in that regard the way I always do, which is remind the jurors the 2.7 closing argument instruction, which
Does it sound the same for you? I just put it to 600. Mine, I just had to put mine down to like 28%. Mine's loud as hell. Is it low for you then, guys? Let's just try and check this volume right. So I've got the volume at 600. The volume of the stream is high.
I'm going to tell them before we get going. What the lawyers say is not evidence. These arguments are meant to assist them in their determination of the facts, but they will be determining the facts of the case. And if we ever arrive at a point in time where the lawyers are saying one thing regarding the evidence, witnesses, or testimony, and their independent recollections of the trial evidence was something different, I want them to rely on their own recollections that, again, what the lawyers say are not evidence. But I think you're allowed to go on all those.
Thank you, Judge. And the final thing is I need some time after Ms. Gomes is done with her.
Yeah, I'll send them out for restroom break. That's not a problem. So, Ms. Gomes, if I have it right, you want me to give you a 5-minute warning after you've used 70 minutes. I'll give you another tap when you're at 75 minutes. I'm not going to stop you. So if you go over whatever balance of the 120 minutes is what would be left for Mr. Kilhoran's rebuttal. Is that correct?
Yes, Judge.
Mr. Kilhoran, I neglected to note, if I asked you Friday, I didn't write it down. Did you want a warning?
Yes, 2 minutes.
Well, hang on. I am.
And we'll get you a post-it note, Mr. Kilhoran, so you know how much time you have in total for your rebuttal argument.
Right.
And Mr. Iglarsh, you want a warning at 10 minutes? Okay. And each side has shown the other side whatever demonstrative aids or exhibits that they're going to be using during their closing argument?
I showed the timeline. The only things I didn't show were the things that are already in evidence that I'll be showing from evidence.
And I'll address both sides, but let me ask Ms. Gilms first, since you're going first. Are you going to display for the jury any evidence that the public cannot view?
Yes, I will. I would like the screens to be turned off for my entire closing. That way it's just easier instead of turning them on, turning them off. The only thing I'll need, in addition to having the screens off and the visuals will be audible in the Elmo. I don't mind if what's seen on Elmo is visible, but
Well, I think if the screens are off, they're off.
it's
So
just easier. I
is
think,
that
to
what you
leave
want?
off. Yes.
Okay. I mean, we're happy to turn, I've got Court Deputy Unique back there. We can have them on when it's appropriate, turn them off when it's appropriate. It's your closing argument. I'll do it however you want. You want them all off?
Yeah, Judge, we'll just keep them off.
Okay.
Judge, for me, there won't be anything sensitive, so I'd like them on.
Yep. So after Ms. Gomes's opening, closing argument, I'll send the jurors out for a quick restroom break. You can set up Mr. Igar's technology as you see fit. We can get all the screens back on. And then we'll bring the jurors back in. State, anything else you need me to address before we get going?
Yes, I just one other matter. I believe on Friday, when the defense rested, I know the court had policy with the defendant regarding the right to remain silent. I don't think there was a policy regarding witnesses being called by the defense and whether the defendant was satisfied with the witnesses that all the witnesses he wanted to call. So
Yeah, I typically don't do that, quite candidly. I mean, it's the fundamental decision about whether you want to testify or not, that belongs to the client. So I always talk to the clients about that. I think what you're asking more deals with trial strategy, and that's between him and his attorney. So.
Well, again, when it comes to case law and post-conviction, there is case law for the proposition that the defendant makes a claim that there were witnesses that were not called. You want to call, there's no explanation, it can be a problem.
All right, Mr. Igar, do you have any objection if I put your client under oath and ask him about that? If you do, I'll probably sustain the objection.
Yeah, I would object.
Okay, so respectfully, the state's request is denied. Anything else?
No, Judge, nothing from the state.
Okay. Defense, anything else you need me to address before we get going?
No, we're ready.
Okay.
Hi, Heidi. Hi, Suzanne. Yeah, do you know what I did, Toxic? I set it up already, and obviously I put the screen on, took myself off, and then it went to the other setting. I forgot to put it back on the setting. So thank you for that. Right, I am paranoid now. Why are you guys struggling with the volume? Suzanne's saying the mics. Mine is perfect, guys. Let's have a look. Let's have a gun. I want to get this perfect for us, guys. So, let me get YouTube up as well. Here we go. I'll address both sides. Yes, it's okay. Yeah, so let's just clarify. It's not my fault. I've got the volume on 600%.
Please
I think the
return.
judge is fine. It's just them.
May be seated. All the parties may be seated.
Right. So before we go any further, hello Lou. Thanks for your comments this morning, everybody. Jesus. Oh, excuse me. So morning, everyone. I hope the volume's gonna be okay. It's clear as day for me. So if it's not, it's the mics. I've got a 600% here. So yeah, welcome everyone. Hopefully we get a verdict today, and hopefully we get going. So here we go. We're going to be starting.
Welcome back. I hope you had a nice weekend. Ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. So with that being said, Ms. Gomes, when you are ready, you may proceed.
Thank you, Judge.
Ba 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 ba. Woo. Looking forward to this one.
please the court, counsel, members of the jury. On February 14th of 2018, Scot Peterson put on his police uniform, badge, and gun, and he arrived at his post at Marjory Stoneman Douglas High School. Not assigned to a district or a zone, just one school. As parents dropped their kids off that Valentine's Day, they would have had the opportunity to see Deputy Peterson on campus. A police officer for every mom, dad, grandparent to look at. And members of the jury, when those parents looked at that police officer as they waved goodbye to their children, they would have been absolutely correct to assume that that man's only priority was the safety of their child. You see, Deputy Peterson wasn't just on campus to catch kids with fake IDs, to work on the vaping problem that they were having. Deputy Peterson was extensively trained. Combat lifesaver, tactical handgun, defensive tactics, use of force, patrol rifles, national standards on how to respond in a crisis, and single officer response in an active shooting. Scot Peterson was there by contract, by job description, for the safety of those kids. But by the end of that Valentine's Day, parents would start to receive panicked texts from their children. Children inside the 1200 building that were huddled underneath desks, crammed in the corners of classrooms, whispering on their phone to mom and dad that something was wrong. And in the background, there would be gunfire. Members of the jury, by the end of the incident, 34 people would be shot. 17 of them would die. Children would remain trapped inside their classrooms while they were forced to watch their friends bleed out and die. The muffled screams of kids who would die right there amongst their peers. One of the victims, Anthony Borges, would lay in a puddle of his blood for 40 minutes, shot through the lungs, the legs, the torso, and Anthony Borges would wonder, why is nobody coming to help me? And members of the jury, parents would soon come to find out that help had refused to enter, that their very own deputy assigned to their children had chosen to run from the sounds of gunfire. Those parents would come to find out that there had been a specific moment that day at 2:23 p.m. when that deputy had been presented with a choice. At 2:23 p.m., Scot Peterson would arrive at the doors of the 1200 building, knowing at a very minimum that there was something wrong inside that building, knowing at a very minimum that there were the sounds of firecrackers or a suspicious sound. And then while standing at those doors, less than 10 feet from the doors, according to his own words, he would hear gunshots. And he would get on the radio and he would announce, shots fired, 12.
Right, I'm sorry, I'm getting pissed off already. Suzanne, you're 100% right. This is great intro to his cruise. What the hell is she, like, she's pretty, don't get me wrong, but what the hell is she on about? Jesus! And I like her a lot, but she's really winding me up now.
1200 building. And in that moment, while he stood at those doors, every student and every teacher on the third floor was still alive.
What? How do you know that?
In that moment, choose to go in or choose to run. And Scot Peterson chose to run.
No, that's
When the
pathetic.
defendant ran,
Shut the
he left
fuck up.
behind an unrestricted killer to spend the next 4 minutes and 15 seconds wandering the halls at his leisure. Because when Scot Peterson ran, he left children trapped inside of a building with a predator unchecked.
Ooh.
2:23 p.m. forward, that predator would fire 70 rounds from the moment that that man made the decision not to enter. Kara, Meadow, Peter, Joaquin, Kyle, Anthony, Jamie, Miss Stacy Lapel, Mr. Scott Beagle would all be shot on the third floor. Scot Peterson is charged with 11 counts. Count 11 is different than the rest, so we're going to set that aside. I'm going to talk to you about counts 1 through 10. Counts 1 through 10 are for the victims in this case. Counts 1 through 7 are for those who were under 18, the children, and counts 8, 9, and 10 are for the adults. Now, I say adult, but Meadow Pollock was 18, for all intents and purposes, a teenager in high school. The counts related to the children are called neglect of a child. The counts related to the adults, culpable negligence. As I mentioned, there were 34 total victims. So why has the state charged for only 10 of the victims? The timeline is the answer to that question. All right, I'm getting to the screens.
You get to try it on.
I need the actual screens for the jurors, not the online.
Is this going to be a PowerPoint? Mr. Savitsky, would that be the wireless feed?
It's on us, attorney 3.
Attorney 3. Got it.
You can all take a look at the images in front of you. We're going to start at 2:19.
Poor guy.
At
Hope gets justice
2:19
today.
PM, the shooter arrives on campus and the defendant is inside his office in Building 1. The shooter enters the 1200 building on the east side and prepares to start shooting. When that happens, the defendant is still in Building 1. Now, at this point, once the shooting begins, we know that everyone with the school radio, including the defendant, hears Monitor Medina come over the radio and announce that there are firecrackers or suspicious sounds coming from the 1200 building. We know that Coach Greenleaf, Coach Stabley, they hear the same thing. Coach Greenleaf walks up to the defendant and he says, "Hey, did you hear what just came over the radio?" And the defendant says, "Let's go check it out." Coach Greenleaf tells us that as he's on the golf cart heading towards the 1200 building, he hears sounds coming from the building. If you take a look at the image on your screen, we know that the men are on their way to the 1200 building. We can see the golf cart on the top left of the screen, the time 2:23:16. Campus monitor Anna Ramos testified that during this time, Coach Feist gets on the radio and he says, "Those don't sound like firecrackers." The defendant and Coach Greenleaf get dropped off right outside of the 1200 building, and we can see the time. And then as you see on the image of this screen, the 1200 building, the defendant is dropped off feet away from the east doors at the moment that the shooter has finished working his way down the first floor and is on the west end of the 1200 building. Coach Aaron Feist, who has broadcasted to everyone that those are not firecrackers, completely unarmed, runs directly into that building because of his concern for those children. Aaron Feist is about to be shot, and he will be the last person killed on the first floor. Members of the jury, this moment is critical for your consideration. The defendant on the east side of the 1200 building. The shooter on the west side of the 1200 building. The time is exactly 2:23:25. Aaron Feist, not visible on the image that you're about to see, will open the door to the stairwell and will be shot. And what may have been firecrackers before, now clearly will be broadcasted by the defendant. I think we've got shots fired, possible shots fired, 1200 building.
We have could be firecrackers. I think we got shots fired. Possible shots fired. 1200 building.
Coach Greenleaf, Coach Bonner, Coach Stabley, Maintenance Supervisor Ed Suarez, and every student that comes out of the 700 building due to that fire alarm and the defendant hear those shots. From that moment forward, no one on campus has any doubt that something is wrong. And the armed police officer just came over the radio and told us, gunshots, and it's the 1200 building. If you look at the image on your screen, the east side of the 1200 building, in that moment, the defendant is standing 10 feet from this building, according to his statement to Detective Curcio. And he now knows, pursuant to all of his training, every time the trigger is being pulled, another child is being shot. He stands there with the knowledge of a 28-year deputy assigned to protecting children, knowing that the #1 goal in that moment is move towards the sounds of gunfire. At a minimum, in that moment, the defendant can look through those windows we see on your screen. He can open the doors to that building. He can yell police. He can fire his weapon because, as Lieutenant Colonel Samaru told us, cause some kind of distraction. And as we see on the left side of the screen, the shooter will start to move through the second floor and the defendant retreats. And we see him running to the location that he'll remain. The shooter works his way down the second floor and fires 6 rounds for the defendant to hear. Rounds that teacher Cindy Helverson, the teacher who testified that she was approximately 30 feet behind him when he's in this fixed position, describes as barrages of gunfire. Time continues to pass. The shooter remains in that building. The time now is going to be 2:24:13 as the shooter enters the stairwell and begins climbing the stairs while the defendant is still in his position. Out in the open, if you take a look, no indication he's receiving gunfire when he comes on the radio again and says, we're talking about the 1200 building, the building off of Holmberg Road.
We're talking about the 1200 building. It's going to be the building off of Holmberg Road.
While the defendant stands there narrating, the children and the teachers on the 3rd floor are still alive, have not been shot. Scott Beagle, still alive. But the shooter, left unchecked, unabated, is about to arrive at the top of that stairwell, and he's about to arrive at the 3rd floor. Now you see the image on the screen. Before we hit play, before this moment that you see, the shooter has stepped into the hallway on the 3rd floor with his firearm visible. Unarmed teachers, Scott Beagle and Stacy Lapel, have the courage to stand in that hallway and try and get their kids into the classroom. They move as quickly as they can. Miss Lapel trying to get as many students as she can to safety. Meadow, Joaquin, Anthony, and Kara are running towards those classroom doors, seconds away from making it to safety when the gunshots start blasting and they are forced to turn around and head in the opposite direction. At the end of that hallway, furthest from the shooter, is Jamie and Peter, literally steps from escaping into the stairwell. As they run, Mr. Beagle standing in that hallway, he's hit. Scott Beagle is killed. Miss Stacy Lapel is shot. Kyle and Marion are shot but are still able to run and escape down the stairwell. Anthony is shot. Joaquin is shot but still alive. He runs to hide in an alcove near the restroom. Meadow and Kara have been shot but are still alive and are huddled together in an alcove in front of the classroom. You can see her pink backpack in the image. Jamie is running for her life and almost escapes through the doors when she is shot through the spine, immediately paralyzing her, causing her to collapse just outside of those doors on the stairwell landing. Peter, shot but still alive at the end of this hallway, and then right before I hit play, the shooter walks over to where we see Kara and Meadow and unloads into their bodies again. And then in this video, we will see the shooter walk to the bathroom alcove where Joaquin will be shot again and killed. And then at the end of this hallway where Peter has collapsed, he will be struck multiple more times, having been shot for a total of about 12 to 13 times. And you'll hear in this video, while the shooter is just making his way along the third floor. The defendant is still outside in his fixed position, narrating on his radio, repeating to us that he knows it's the 1200 building.
We're looking at the 1200 building. It's going to be the 300 building. It's going to be right off of Holmberg Road by the senior lot.
Now you'll notice instead of saying the 3-story building, he says the 300 building, a mistake that Tim Burton actually also made on the stand, but immediately clarifies the building off of Holmberg Road, the building by the senior parking lot. The 300 building is nowhere near any of this. At this point, this is the third transmission he's made. It's clear that it's the 1200 building. The shooter remains on the third floor while time continues to pass and he continues firing rounds. Now, at this moment, Marion and Kyle have managed to escape. And if you recall, Kyle was running when he comes into contact with Jeff Heinrich. Jeff Heinrich is the off-duty police officer who had been watering the lawn, no vest, no gun, ran towards the sound of gunshots because he said his police officer instinct just kicked in. Jeff Heinrich is stopped by Kyle, whose foot has been nearly blown off, and he's saying, I need an adult, I need an adult. So with the gunshot wound victim over by the football field, somebody comes over the radio and says, possible shots fired football field. And again, if any of us had any doubt as to the fact that the defendant knew it was the 1200 building, he clarifies immediately by getting on his radio and saying,
26, so we also heard it over by inside the 1200 building.
we also heard it over by inside the 1200 building. The shooter is still on the third floor and time continues to pass.
Right, I'm sorry. I'm sorry. I just need a minute. We'll get back to it. And if you want to watch it live, please go to Law Network. It's fine. But like, I am really pissed off with this. It's quite upsetting to hear some of the stuff that she's saying about what Nicholas Cruz did. So it's emotionally, I'm filling up on it and thinking, geez, all these kids. But the gall of this woman to say he was one person and how he could do it. I wish in a way that it was her father in this situation. Would she say the same things if it's her brother or something? I just feel it's very disgusting that I know it's not her, but it's the prosecution. But I think it's disgusting that we're here. I'm actually quite upset to listen to all this because I've never heard the full story of what happened. Nicholas Cruz is a fucking scumbag. Scot Peterson does not deserve this, and I'm sorry, but I'm not really happy about this. I'm really pissed about this at the minute. So I just want to get that out there. Just stop there for a second, compose myself. I will get back into it now, but I think I need to take that minute. Sorry.
Minutes later, while the defendant has remained in his same position, at 2:27:40, the shooter sets down his firearm and the killing finally stops. The time on the screen, 2:27:40.
Alex, do not approach the 12 or 1300 building. Stay at least 500 feet away at this point.
2:28, nearly 7 minutes after the shooting began, the shooter finally exits Building 12. And as the shooter is exiting Building 12, running directly down the line of sight of the defendant, which according to his attorney, his client is actively scanning, the defendant comes over the radio and repeats a variation of the instruction that he's been giving throughout this entire incident. Stay 500 feet back. This is after telling officers, stay away, set a perimeter, nobody come near. And in this moment, again, the defendant directing officers to position themselves to completely miss the shooter exiting that building. Directing officers not to respond to the building where 70 plus shots have been fired while he stood there. Directing officers not to render aid to the wounded. Directing officers to do the exact opposite of what is trained in these types of incidents. The shooter continues to run until he casually blends in with the children. And now the victims remain inside the building in desperate need of medical attention. Amongst the 11 deceased and 13 wounded on floor 1 are those that have been killed and shot on the 3rd floor. And alive, Anthony Borges laying in the hallway, and Stacy Lapel hiding her wounded arm from her children, trying to keep them calm in a moment of chaos. And then Scot Peterson, in his fixed position, having stood there for the entirety of what has just happened, comes over his radio and asks shot Kyle Lehman.
Jerry, does he know where the shooter is?
Deputy Peterson, having stood there while Kyle was shot, comes over and asks if he has any information. Finally, at 3:11 p.m., after a total of 48 minutes in his fixed position, the defendant finally moves. Members of the jury, the state did not charge the defendant with any of the deaths on the first floor because he wasn't outside of the building when those deaths occurred. But it was from the point that Aaron Feist was shot that the defendant knew people were dying.
Look how upset he is. Motherfucking bitch. Fuck.
It was from that point forward that he was the only hope for those victims, because he was the only hope to slow that shooter down. Jamie Guttenberg was steps away from escaping that hallway. Peter Wang was almost at those doors. Meadow, Joaquin, Anthony, and Kara were seconds away from finding safety inside of a classroom that they were running towards. So when defense counsel gets up here and he throws the number around 4 minutes and 15 seconds like it's nothing,
Off.
a few seconds was all that those children needed.
I agree,
4
Suzanne.
minutes and 15 seconds was an eternity. The timeline is important because the point where the defendant becomes aware of this danger is crucial for your determination today. You're going to be required to consider his omissions meaning not doing something, a failure to act when determining the word causation. You'll be required to consider his omissions, his failures. You'll be required to consider at what point was the defendant's inaction, at what point during that inaction did he know that his failure would cause additional injury and additional death. Now, the shooter did not kill anyone on the second floor, so there were no counts to charge for the second floor. But the moment that the shooter finished taking lives on floor 1, the defendant had the time period that the shooter spent climbing the stairs to take action. The defendant had the entire time period that the shooter spent firing rounds on the second floor to take action. The defendant had the entire time period that the shooter spent going from floor 2 to floor 3 to take action. And he had the entire time period that the shooter spent executing and wounding children on the third floor to take action. The time the shooter spent comfortably removing his firearm, setting it down, walking out into the open, in complete open view. And then the 40 plus minutes while teachers and students bled out, while officers were forced to respond to that building, assuming that the shooter was still inside. Mind you, those officers needing additional manpower while their fellow officer just stood by. And finally, when officers rendered aid to the children that could be saved and were forced to move the lifeless bodies of the children that could not. That was all time that the defendant needed to act. This is why we have charged Scot Peterson with only the deaths and the injuries on the third floor, because there is no excuse for his inaction for those deaths that occurred after 2:23 p.m. Now, the language that the state has used is failure to seek, confront, or engage the shooter. Before we move on, I want to set the record straight on what that means. It's abundantly clear that Scot Peterson did not seek the shooter. He was not seeking the shooter out because he didn't move. There was no seeking in his actions. So what does it mean to confront or engage the shooter? Defense counsel got up in his opening statement and he created this expectation that his client was supposed to kill the killer. He actually said, kill the killer. I'm not sure why he said it that way. Killing a shooter is in fact part of the definition of confronting and engaging. Many officers will tell you that that's the desired outcome. But there is so much more than that. The definition of what it means to confront or kill the shooter is in evidence. It was laid out for you clearly by Lieutenant Colonel Samaru, and black and white in the defendant's trainings. Although neutralizing the suspect can end a threat, there are alternatives that will get the suspect to stop killing victims. Forcing him to barricade himself, forcing him to flee the area, forcing him to surrender, break his concentration. To confront or engage the shooter just means to disrupt him, to force an outcome. These shooters are looking for soft targets. That's what the evidence showed us. Unarmed children in the freshman building. History and data, according to Lieutenant Samaru, tells us that these killers are zoned into what we call an OODA loop. If you remember, OODA was the acronym that Lieutenant Samaru gave us. Observe, orient, decide, action. That's the loop that they're in. If law enforcement even so much as enters the room, that disrupts a shooter's OODA loop. The training has explained to us that these shooters have one primary objective. They are not looking to deal with a confrontation. They are looking to take as many lives as they can as quickly as possible. Once the shooting begins, the objective is to decrease the number of casualties. Minimize the damage, were the exact words. As Lieutenant Colonel Samaru explained, we know that when a shooter of this type is confronted by any armed individual, and that's law enforcement or a carry concealed person, the shooting of innocent bystanders stops because an outcome is forced. Mere presence is your job. Let me repeat that. Lieutenant Colonel Samaru told us mere presence inside that building was his job. Your presence as an authoritative figure is enough to break that shooter's OODA loop. So what does it mean to confront or engage the shooter? It just means to force an outcome. Now, I have to make that clear because the state did not expect Scot Peterson to go on a suicide mission. Members of the jury, we want our law enforcement officers going home at the end of their shift. I did not expect Scot Peterson to blindly run into the line of fire. I understand that officers came in here and told you that risking their lives is part of their job. Sergeant Heinrich ran towards the sounds of gunshots because, quote, that's what we do. Detective Danny Polo ran in with his pistol telling us, quote, you have to put yourself in a different headspace. This is it. You're possibly getting shot. No one wants to do it. It's what we're paid to do. Lieutenant Cardinelli ran past officers who told him to stay back because the defendant ordered them to, because in his words, quote, I said, fuck you, and kept running. The lieutenant told us there was nothing that could have kept him from entering the 1200 building. Not the fear of being fired at, not the fear of the stress of the events, nothing. Sergeant Vanderings, who pushed officers to move quicker, to get as fast as he could to that shooter. Tim Burton, Richard Best, Detective Brett Schroy. And let me remind you, Detective Brett Schroy, whose own child was on that campus, and he made the decision to seek out the shooter instead of seeking out his own kid. Captain DeRosa, who told us that when he blew past the defendant, who stood there and pointed at the 1200 building, quote, I was more concerned with eliminating the threat than I was with my own safety. The officers that testified explained to you that that's a fact of their job. This job was voluntary. He wasn't forced to be there. He understood the risks. He was extensively trained for them. He was provided a rifle, a vest, a pistol. Kids don't have to go to school in armor because they didn't volunteer for that job. There are people voluntarily being paid to do that job. Captain Mazzy and Lieutenant Colonel Samaru told you in a critical incident of this form, there is no question as to what the priority of life is. Hostages, innocent civilians, police officers, and suspects, in that order. Now, that is what law enforcement tells law enforcement to do. I'm not a police officer. I will not stand here today and tell Scot Peterson what his priority of life needed to be on that day. That's not for me to determine. But what I can say, and what was expected, was for Scot Peterson to value the lives of those children as much as he clearly valued his own. When the defendant failed to force an outcome, he told you what his priority of life was. When Scot Peterson didn't as much as look into a window, he valued his life over Jamie Guttenberg's. When Scot Peterson didn't open the doors to the 1200 building, he didn't even look inside, he valued his life over Meadow Pollock's. When Scot Peterson didn't yell, "Police, police," it was his life over Scott Beagle's. When he chose not to cause a distraction, he chose his life over Anthony's, Stacy's, Kara, Kyle, Marion, Peter, and Joaquin. So I ask you to remember the definition of confront or engage. Because when defense counsel gets up here and makes his closing argument and says that we expected his client to kill the killer, keep in mind what the evidence actually said the definition is. Keep in mind the trainings and the instructions. And consider one point. When Scot Peterson ordered officers to stay 500 feet back, to set a perimeter, he was setting the priority of life for all of those responding officers who listened to him. Members of the jury, in order for the state to prove the charges against Scot Peterson, there are specific elements that we have to prove. Now, these jury instructions that you're going to be receiving, it's a thick packet, and it's your roadmap on what to do when you get back into the deliberation room. Neglect of a child and culpable negligence each have certain elements. I'm going to go over with you the elements to these crimes quickly so that when you go back into the jury room, you can go through it quicker. Your Honor, may I please use the Elmo? You're going to notice when I put the
Quickly, hello, Dave. Hello, Elizabeth Diane. Hello, Marcy. Love Marcy. I disagree with Marcy, but that's what we're all here for. I hate this closing, but Jesus, oh, excuse me, but we agree to disagree, Marcy. As always, lovely to see you.
elements of the crime in front of you, that there will be a lot of ors. It means that you can pick either or. You can pick that some of it applies, all of it applies. Let's take a look at it. Neglect of a child has 4 elements. And we're going to go one at a time. So starting with the first element, the defendant willfully or by culpable negligence failed or omitted to provide the child with the care, supervision, and services necessary to maintain the victim's physical or mental health, or failed to make a reasonable effort to protect the victim from abuse, neglect, or exploitation by another person. Now, you see that even in the top paragraph, there's an or. It's willfully or by culpable negligence, failed or omitted. The definition of willfully is obvious. You can use the plain understanding of what that means. It just means the intention to do something. Scot Peterson stood in his position for 48 minutes willfully. It was completely his will to stand there. It was his will to remain there. He made it very clear that he had no will or intention to enter the building. He willfully failed, omitted, or to provide care necessary for the physical health of those victims. Some of you may find that his actions are willful, and that's very obvious to you, but others may find that it's by culpable negligence. And the definition of culpable negligence is right below on this page. I will now define, and this will be read from the court, what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The course of conduct or the acts were retreating and then standing outside of that building when he knew that the trigger was being pulled and that children were dying. Because there is an or on this first element, some of you may find that it was willful. Some of you may find that it was by culpable negligence, or some of you may decide that it was the bottom one, failed to make reasonable effort. What you must all agree on is whether this first element is met. Now, it's our position that element number one, all of it applies, no matter which way you read it, because his actions were an obvious lack of effort and obvious failures. What evidence did the state bring you to prove this first element, that he willfully failed? Well, we brought you the surveillance video so that you'd be able to see what he did and didn't do. We brought you the survivors, Marion, Kyle, and Anthony, to tell you their injuries, the protection that they needed, and the fact that they did not receive it from Scot Peterson. We brought you the officers to show you what providing care and services actually looks like, what reasonable efforts look like. And we brought you the trainings, and more specifically, the training materials that Scot Peterson himself was taught on active shooters. Because the state has proven that the defendant failed or omitted to provide the services necessary for those children's physical health, because the state has proven that he did not make reasonable efforts to protect those children, you can check off this first element. The second element. In doing so, Scot Peterson caused great bodily harm or permanent disability or permanent disfigurement. Right underneath that, it says, neglect of a child may be based on repeated conduct or a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or substantial risk of death to a child. So in doing so, Scot Peterson caused these injuries. Now, in almost all neglect cases, the act in question, the causation is an omission, meaning not doing something that you should have done, to allow something to happen that was already happening or even caused by another person. To use examples to explain the term cause in the sense of child neglect can be pretty helpful. So an omission or a failure can be the cause of somebody else's injuries. An example of that is an adult that is at a pool with a child that cannot swim. The adult sees that child moving closer to the edge of the pool. That child jumps into the pool and begins to drown. The adult stands there and does nothing. Another example that we often use is a teacher in a classroom with students. A teacher's aide begins to physically harm one of the students. The teacher stands there, watches, and does nothing. In both of those examples, it's clear that the person in question did not directly cause the injury to the child that fell into the swimming pool or the child that's being beaten or injured by somebody else. However, it was their omission, their failure to act, that caused the child's additional injury or death. Causation is defined for you in these instructions as even just one single omission. In this case, we have omissions over several minutes. Every unanswered gunshot, another act of omission. and then the additional 40 minutes where no aid is rendered by the defendant. The timeline and the physical evidence, the casings, is the best evidence for this element of causation. How many shots did the defendant stand there to hear? Not the shots before he arrived. We know there was a total of over 135 shots that day. But for the defendant to specifically hear, the 2 to 3 shots that killed Aaron Fikes that he radioed in and told us, the 6 shots fired on the second floor, according to crime scene detective Suarez, the 61 shots fired on the third floor, according to Detective Crespo. Scot Peterson stood outside of the building for 70 gunshots, knowing that death or great bodily harm was happening inside that building. In addition, there's the prolonged pain and suffering for Anthony Borges specifically, who laid in his blood for 40 minutes until somebody finally rescued him. And let me remind you that the person that finally rescued Anthony Borges was Detective Danny Polo. Detective Danny Polo was the officer that testified with the face covering. I asked Detective Polo, did you hear the order to stay back 500 feet? He said, yes. I said, well, then why'd you go inside? Said, because we don't do that. That was dumb. Why would I do that? Those kids needed somebody inside, not 500 feet back. Because the state has proven that the defendant had the opportunity to act and did not, because his omissions were the cause, allowing the shooter to continue completely undisrupted, the state has proven the second element, and you can check off element number 2. Element number 3, Scot Peterson was a caregiver for the victims. The definition of caregiver is provided right underneath. Caregiver means a parent, adult household member, or any other person responsible for a child's welfare. The courts have actually explained that the phrase any other person responsible for a child's welfare has, quote, plain and obvious meaning. So was the defendant, who was the school resource officer responsible for the welfare of those children, a caregiver on this day? Yes. His only assignment every day was the welfare of those kids. The fact that the defendant was responsible for the welfare of the children at MSD is obvious based on the plain meaning, but also based on the school resource officer contract, which you all have in evidence, which you'll be able to take back with you. And quoting from that contract, according to the contract, his duties were to be at school during regular hours, right alongside the teachers and the principals, to assist in the prevention of juvenile delinquency, teach kids about law enforcement, develop positive relationships, help victims of crimes, and most importantly, protect and secure the school. You heard from school resource officers Gloria Crespo, Sergeant Heinrich, Lieutenant Cardinelli, Officer Burton. They all told you that as part of their role on campus, they asked, similar to teachers in the fact that they conduct administrative searches, meaning they can go through a kid's backpack. Unlike other law enforcement officers who need to get a warrant or have to be able to articulate it, they can just do what the teachers and the staff on campus do, and that they're there to protect the kids. Welfare of the children in all sense of the word. Now, I want to pause to point something out here. Scot Peterson was the only police officer on that day that was officially assigned, clearly delineated caregiver for the children at MSD. None of the other officers who arrived on scene had any caregiver obligation as it relates to this statute. Their jobs, those other police officers, is not to look over just one collective group of kids. They respond to calls, they're on the road, they're in a detective bureau. Scot Peterson was the only caregiver because his only job was to maintain the welfare of those kids. Because the state has proven through the school resource officer contract, through the school resource officer testimony, and the school administration testimony regarding the expectation of the defendant's role on campus, you can check off this third element. Finally, element number 4 is what we often refer to as an element that's not really in dispute. There will be a stipulation that's read to you about the ages of the victims, the cause of death, the manner of death, and then we brought in the medical examiners who also testified to the age of the victims. So due to the testimony from the medical examiners, as well as the stipulation of the parties, you can check off element number 4. Once you go through these elements for the 7 children, you can flip to the back of the jury instructions and you'll see the verdict form. And you can check guilty for all counts as it relates to neglect of a child. Then there's the additional counts of culpable negligence. Culpable negligence is very straightforward. There's only 2 elements to culpable negligence. The defendant exposed the victim to personal injury, and he did so through culpable negligence. The victims, again, in culpable negligence are Scott Beagle, Stacy Lapel, and 18-year-old Meadow Pollock.
Stop listening to her.
Means that the defendant
Stop
left
listening.
those victims vulnerable to attack. He exposed them to personal injury when he made the decision not to attempt to investigate the sounds of the gunshots, to stay 75 feet back when he made no effort to engage the shooter. The definition of culpable negligence will be found below here. And I bolded for you that culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care to raise the presumption of a conscious indifference to the consequences of which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare. You don't have to believe that the defendant had a conscious intent to harm in order to find him guilty of any of these 10 counts. The evidence shows that the defendant had a, quote, reckless disregard for human life as required by this count because he knew the dangers that lied ahead for Meadow, Scott Beagle, and Stacy Lapel when he fled from that building. He showed conscious indifference to the consequences that those victims were facing when the shooter was left inside with no one to stop him. He grossly and carelessly disregarded the safety and welfare of Meadow, Scott, and Stacy. Because the state has proven that the defendant had a duty, he knew what his duty was, and he refused to perform it, you can check off the 2 elements necessary to prove culpable negligence. Finally, we turn to count 11, the perjury count. Counts 1, 2, and 3 are very straightforward. They were proven through the testimony of Detective John Curcio when he told you that the statement was under oath and that he swore to tell the truth, nothing but the truth. We also heard that Detective Curcio was accompanied by Detective Jeffrey Curtis when he took this statement, and that while under oath, the following statements were made. Now, you'll be able to take a look at this and read the statements yourself when you go back into the jury room. I'm just going to highlight for you the essence, like the crux of what the statements are. And it's that there were only 2 to 3 shots that he heard and that he never saw any children fleeing from the 1200 building. And you'll have this with you in the jury room. You'll be able to read the statements in their entirety. Now, once you go through the elements 4 and elements 5 are the elements that you're really considering. The fact that he was under oath and that it was sworn to, that's clear. The defendant's statements directly contradict all of the evidence in this case. The surveillance inside the stairwell shows 5 students leaving from the east stairwell at 2:23:55. That's on the raw footage, the 6 hours of the surveillance, which if at any point you want to watch any particular part of the evidence, you can request that and we can make it available to you. Coach Greenleaf told you that those students that ran out of that building, Coach Greenleaf himself saw those students. He was standing directly next to the defendant, and you can see him waving to those students. We know from the spent casings and the crime scene how many shots were fired. We, of course, have all heard testimony now about how loud they were. Specifically, defense brought in a witness named Dylan. If you recall, Dylan recreated the tempo of the shots. Bang, 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 bang. And she described for you that she heard those shots actually while she was inside the 700 building, inside a classroom, inside a closet, and she was able to hear all of that while the defendant is standing outside, directly 70 feet in front of the 1200 building. The recordings that we heard on dispatch, and in one of those recordings, pay attention because you can hear the barrage of gunfire in the background. Once you review the elements as it relates to perjury, you can mark off the elements that you find have been proven, and you can go to the back on the verdict form and check your decision. Now, those are the elements to the crimes charged. Once you look through them and you match the element with the evidence, you can find that the state has proven each and every single one of them. I do want to take a moment here to address a couple points that have been raised throughout the trial by the defense. And I want to start with the radios. The defense brought in the supervisor at BSO Communications who oversees dispatch. Her name, if you recall, was Angela Mize, Supervisor Mize. She was very experienced, and she was the witness with the most knowledge on this topic. Angela Mize told us, quote, "Until the radios met their capacity that day, they were functioning." Why is that important? Because the defendant is using the radios as an excuse as to why, well, the defense attorney has raised the issue of the radios as an excuse as to possibly why the defendant couldn't enter the building that day. So when those radios did and did not work is key. According to every officer that testified, initially they could key up, even if it wasn't perfect. All of those witnesses that arrived after the fact or at the very last few shots explained that even they were able to initially key up or heard somebody else initially key up. The head of dispatch told us the radios were functioning normally until all of the other officers started to swarm that area. Were the radios a problem on that day? Absolutely. For the secondary and tertiary response teams. The initial response did not require a radio beyond exactly what Scot Peterson was able to use it for, which was to announce shots fired, give out the location, and then respond. The most irrational part about this entire radio argument is the claim that Scot Peterson needed real-time intelligence from the radio. Scot Peterson was the real-time intelligence. Scot Peterson stood there. He didn't know exactly precisely which classroom to go in. I agree with that, but guess what? It wouldn't have mattered, because if you recall, Lieutenant Cardinelli asked him, "Hey, my kid's in classroom 1, 2, 3, 4. Where's that classroom?" He had no idea. What would knowing the precise classroom have aided as far as entering into that building? All this talk about nobody patched the calls. Well, if you remember, Miss Oakley told us just 3 clicks of a mouse, and we asked her, could Scot Peterson have requested the patch? And she said Scot Peterson could have requested the patch himself. You'll notice that there's a theme in all of the reasons as to why the defendant couldn't go in the building that day. The calls weren't patched. Who could have asked for the patch? Scot Peterson. He wasn't wearing his vest. Whose job was it to wear his vest? Scot Peterson's. But there was an echo. Whose job was it to step out from that hallway if there's an echo? Scot Peterson's. But he was outgunned. Who was provided a rifle that he chose not to have on his person? Scot Peterson. And I'll make a note here, there is absolutely no evidence in the record that Scot Peterson believed he was under sniper fire. He never said sniper fire that day. He never said it in his interview with Detective Curcio. There was no round confirmation, the rounds hitting his feet or near the structures around him. There was no mention of him ever seeing anything outside of those windows. And if Scot Peterson actually thought that he was under sniper fire, he chose the dumbest place he could have stood. Directly in line of that sniper fire. What did the officers tell us? If you believe there's sniper fire, you hug the building. So keep in mind, Goolsby testified that he was able to make 5 to 7 transmissions before it crashed. DeVita told us that he remembers Jan Jordan being able to key up. And you have the full dispatch and evidence. We provided you with 10 minutes of the relevant portion, but you have the unedited full version. Go back, listen to it if it helps you in your determination, and you can hear the communication between officers. The communication problems grew as the police presence grew. And I'll point out, as it references to the issues with the radios before that day, prior to that day, every officer that testified said that as long as you stood outside, there was no problem. Where was Scot Peterson standing the entire time those kids were being killed? Outside. Officers that explained that they themselves experienced the radio problems while they were inside the 1200 building told you it wasn't a thought on their mind because they communicated verbally and because there were children that needed to be rescued. The radios had no bearing on his decision not to enter. His job in that moment was to move towards the sound of gunfire. Scot Peterson was boots on the ground with the most information out of anybody on that scene, and he chose to stand there like a dispatcher, narrating. To say that the man who was listening to the shots, killing children, needed real-time information from a radio is mind-boggling. So when you consider the radios, I ask you to keep in mind, at what point did the radios become a problem? And where on the priority list should it have fallen? Finally, the last issue that has to be addressed. Now, at this point in the closing, I can finally candidly speak directly to you. And I can tell you that the idea that Scot Peterson didn't hear gunshots or didn't know where they were coming from completely defies every piece of evidence in this case. The sounds of the gunfire, according to all of the witnesses, were extremely loud. Quote, the loudest sound I've ever heard in my life, from a defense witness. Multiple barrages of gunfire, pops from the 1200 building, loud bangs from the 1200 building. And from the witnesses who actually had the opportunity to perceive things at the same time or from the same location as Deputy Peterson, Coach Greenleaf, Coach Stabley, Teacher Cindy Helverson, always from the area of the 1200 building. Clearly gunshots at or near the 1200 building. I won't even address the concept of defense using terrified 15-year-old children to somehow bring validity to the claim that his client didn't know where the gunshots were coming from, children who were outside for mere seconds. I trust that you can see the difference in those two situations. You heard the term football fields and football fields throughout this trial. I don't really watch football, but I know that football fields and football fields is really big. The size of this entire campus is completely irrelevant when we're talking about one building, according to his own client. The size of this entire building, when describing the situation, is mixing things that don't need to be mixed, inside or outside of the 1200 building. Those were the defendant's words over dispatch and in his statement with Detective Curcio. I don't doubt that the shots that killed Aaron Feist were extremely loud. I don't doubt that they sounded like they were coming from the west side of the 1200 building or even directly outside of the 1200 building. But whenever the defendant spoke over dispatch, it was always in reference to the same building. And members of the jury, let me be very clear about one thing. Had the defendant walked over to the 1300 building and entered the 1300 building, looked around, saw no bodies, no blood, no smell of gunpowder, and walked out and walked to the 1200 building, we wouldn't be here today. Had the defendant made any reasonable efforts to seek out stimulus, we wouldn't be here today. All he had to do was open the door. What the attorneys say is not evidence. That's important, because no matter how many times Mark Eiglar says that the area in question was the entire campus, you have what's actually an evidence. The dispatch notes from 2:23, shots fired, 1200 building. 2:24:13, we're talking about the 1200 building. 2:25, we're looking at the 1200 building. 2:25, buy inside the 1200 building. 2:28, do not approach the 12 or 1300 building. And at 2:24:36, you can actually hear the barrages of gunfire in the background. So when he gets up here, and I have no doubt that he will say football fields and football fields in the entirety of the campus, remember what the evidence actually shows. In the interview with Detective Curcio, the defendant himself says, quote, "It was so clear and so loud at that point, I knew it was close to this building. Wasn't sure if it was in the building, was it outside the building, but I knew it was close." Quote, "So I'm right here while keeping an eye on the door to that building." Quote, "So that I can see both dimensions of that building." And on page 12 of 36, when you read the defendant's statement, you'll realize that he's consistently focusing on the 1200 building. And he makes it clear that he was contemplating only one shooter. Because when asked about other people mentioning the football field, he says, well, then I started wondering if he fled westbound at that point, because they're talking about people injured near the football field, which is quite a distance from the building, building 12. Please keep in mind when it comes to sound that Lieutenant Colonel Samaru told us the defendant specifically underwent training designed to recreate a situation where you cannot tell where the shots are coming from, where it's confusing, where there's an echo, and you have to use your senses to figure it out. The defendant underwent training that was literally tailored on how to respond to an active shooter when you are alone and it's a school. And I have no doubt that it isn't abundantly clear by now that single officer responses are taught and are necessary. You do not wait for two people. The defendant was taught, as all police officers in Broward County, likely in this entire country since Columbine, that you move towards the sounds of gunshots, and there is no other job that you should be doing in that moment. Get in, cause a distraction, and save lives. As I wrap up my closing remarks, my trial partners and I are very aware of the fact that this trial has been long. We thank you for the attention that you have paid our witnesses, and we thank you for the attention that you've shown both sides, all the witnesses. You
Sit
were
down.
each selected because the attorneys are
Sit down.
confident that you will be strong enough to reach a verdict. It can be uncomfortable to reach a verdict in any criminal case, but I will acknowledge it can be even more uncomfortable if when you look over at the defense table, you see someone that some of you may find to look older. And I say that with all due respect. He was only 54 when this happened. You may see someone that held a job that you possibly respect. The judge is going to read you an instruction that explains that your verdict should not be based on sympathy or pity. It's natural to think that what Scot Peterson must have heard that day while he stood outside was terrible. It's natural to think that although he never entered the 1200 building, he would later see photographs of the victims that died. And some of you might have sympathy for him. Similarly, some of you may feel sympathy for the victims or the parents who are now left behind without their children, who haven't been sitting in this courtroom every day directly across from you. Your role is going to require each of you to look at his actions pragmatically. What was he supposed to do? And what did he do? This entire case boils down to those two questions. You will not be asked to consider anything beyond your verdict, meaning you will not be given any instruction as to sentencing that he may or may not receive, and that is because you are not to consider sentencing when reaching your decision. You are making a factual finding as to the elements and whether they've been proven. That is your role today, and we trust that you will honor the oath that you took as jurors. On Valentine's Day 2018, Scot Peterson went to work that day like every other school resource officer in this country, and now every parent in this country, with the reality that a school shooting was possible. He was trained and he was armed. And when the moment came and he was called upon to act, he made a choice. At 2:23 p.m., Scot Peterson chose not to enter, knowing that those shots were being fired, and at every time the trigger was being pulled, one of his students was dying. He chose to retreat, and then he instructed all responding officers to stay back. His failures and his decisions resulted in the unimpeded killing of 10 individuals, unimpeded shooting of 10 individuals on the third floor. Because the defendant's inactions were inexcusable and his obstruction of the proper police response was inexcusable, the state is asking you to consider all of the facts and all of the evidence in this case, and to render the only verdict that is supported by those things. And that is a verdict finding Scot Peterson guilty as to all of the counts. Thank you for your time.
Such a waste. Such a waste of a woman.
Okay, Ms. Gomes, thank you very much. Ladies and gentlemen, I'm going to give you a quick restroom break, and then we're going to continue with the
Right. Let's chat. Let's chat for a little bit. As you can see, we're caught up anyway. Fucking hell, I can't stop sneezing. If they come back, we'll wait. Jesus, I can't stop. Can't stop sneezing. Marcy, don't think you're on your own, all right, Marcy? You've got a different view, but that's absolutely fine, Marcy. You know that. Madwood, hello. Appealing to Jura's emotions. Yes, but then Marcy has the complete opposite view. So everyone looks at it different, and that's why we're all potential jurors. I wholly agree, Mad. Says exact same things to me. I don't like it when people agree with Mad. The whole trial's been appealing to, yeah. So it is a Cruz trial, not a Peterson trial, 100%. But I'm just disgusted by that. I just don't like that. What a waste of a woman that was. You know, she's so attractive, but her mouth is so potty. It's only shit coming out of it. I did not like that. I know some people do like it, but I personally didn't like her speech. I just think that. Oh, I think it was Suzanne said if that was no closing for Nicholas Cruz, it'd be a fantastic closing, but not for this guy. A lot of stuff she said, I was just, oh, don't. You said about the police officer, you know, his son was in there. Yeah, he was texting him. He was texting the son all the time, so he actually wasn't being that diligent, was he? Or saw Heidi agree. It's like, I hate to say it, but she nailed the closing. Yeah, you're with Marcy. Yeah, you're with Marcy, Heidi. Marcy thinks exactly the same. So, this is why it's interesting. I don't think, for me personally, I don't think she nailed it. I would have sat there going, well, this is Cruz, um, Nicholas Cruz trial. Also, this was on cool. I mean, look, it seems everyone's agreeing. I thought it was really bad. I didn't, but this is what I mean. It plays differently to other people. So I hated that closing. It played to my heartstrings, but I could only focus on Nicholas Cruz. Nicholas Cruz. That's all I could think about. Nicholas Cruz. And I've just thought, then, well, how's one guy going to do all this? So I didn't. And that's the reason I didn't like it. Maybe if I knew Nicholas Cruz, but it might be different. prosecutor could be good at her job, but we don't have to agree with what she's saying. Yeah, I mean, that's fair. I don't think personally it was a good closing. That's just my view. Um, and again, it might be because I don't know the Nicholas Cruz stuff that well, so I just imagine Nicholas Cruz at all times during that. So um, it just made me angry to consider why they brought Scott Peterson up. That they should not never put him on trial is what I got out of it. Um, not guilty, no counts. Yeah, fair enough, Dave. Not sure he will be, but I agree with you. Fingers crossed. So most people thought there was a good closing. I didn't personally, but this is the beauty of it. We all have different views, different perspectives. So it's great. I love Marcy. So Marcy spoke of mine, which is brilliant. Um, so yeah, that's where we're at the minute. I love you. I love you too. I love you too, whoever that is. Obviously, I think most of us, I'm definitely probably going to be a little bit more biased towards this closing. So, um, no, I agree, Suzanne, and that's what I mean. I don't think it was a good closing because that just reaffirmed to me that he shouldn't be on trial as a juror. So I'm angry that why are you wasting my time? Is what I got from it. So she didn't play with my emotions in terms of Scott Peterson at all because I don't think he should be on trial. Disagree with what they're doing. You appreciate the skill lawyering. Madwell, you thought it was good as well. That's fair. I just don't think it was good lawyering. But again, personal preference. And I could be on my own on that one. And I like that woman, so I would be more inclined to be like, oh, she was great. But no, I just didn't like it. Bum, bum, bum. She's still sexy though. Bum, 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 bum. Anyway, that's enough of that. We'll reconvene when the defense are here. So, Spidey mentioned about the trial. I'm not doing that trial now. If you wanted to watch the trial for the thing, yeah. Oh, public speaking, she was fantastic. Public speaking wise, you got to be really good to be up there to do that. What's MLS streaming? MLS is streaming something, the one that we were gonna do, but I'm not streaming it now. The Border Patrol guy. So what I want from you guys in the chat is there might be another live trial this week, so I don't want to start you know if there's another live trial, I'll stream it. Um, I know what to expect the outcome to be, but my heart feels bad for him. I can't imagine feeling blamed for all of this. 100%, Marcy. You got a heart gold, so we all know that. Maybe a guilty on count 11, but also ick. Yeah, I'm not sure what he's going to get. To be quite honest, it depends on what they think. But it's a proof in the pudding here, guys, that we all think differently about even things like the closing. We all think differently. So it only takes one juror. Um, Either way, really. In here, she's wrapping up. S- So as I just said, so MLS is doing that Border Patrol trial. So what I want to do is I don't want to put myself out there and like do a Mark Jensen again. So what I propose is that we wait for the next live trial and do that. But in the meantime, we can cover some other trials. So if you want to watch the Border Patrol, I encourage you to go over to the MLS channel and watch it there after all this, obviously. But I was thinking of streaming, right? So my choices so far would be Daryl Brooks, um, um, Aaron Hernandez. Who else? We need 2 more choices or 3 more choices. Who do we do? We don't stream it we'll stream it every day until the next trial, and then when there's another gap, we'll continue streaming it. So we could do 2 days in 1 day, if that makes sense. Um, Johnny Depp Revisited, that's on a Saturday, Dave. That's what I'm doing that one for, all Saturdays. Um, if you don't know Marcy, she's one of the sweetest and fairest people I've encountered. She absolutely is. She absolutely is. One of the sweetest people that you'll ever meet. I wish Marcy was here more often. She's the most level-headed person I know. She's a complete opposite of Mad World, essentially. You wanted it based on sympathy for, yeah, Johnny didn't know. Dara Brooks is a wild streamer. Well, Heidi said that. So I just what kind of trials do you guys want? Dara Brooks was a wild ride, and we all like a wild ride, don't we, Heidi? So I'm happy to go with Dara Brooks. As I say, I'm only going to be streaming him when we're not doing a trial. So say, um, we got okay, Brooks trial. Spider Girl hasn't seen the Brooks trial. Um, see, I know Dave, you said the ice cream man, but to be honest, that was so recent. I don't really want to do that right now. Um, but maybe in the future, Dave. So it is on the proviso that you guys understand that it is until the next trial. Then after that trial, there might be a couple of days we can do this trial in between. So maybe it's Brooks. So I'm not gonna play it all the way through for like 11 days or anything. I'm gonna be playing it 2 days in one probably, um, throughout. And if a trial comes, I'm not gonna give up on a trial. I just don't wanna go up against MLS. I know there's like Farrell, Jamie, Erin, C Swept, EU, and maybe a few others here, that or Kim maybe wants to watch stuff with him. I don't wanna do, you know, the same. We are gonna be clashing in the future on different trials, but on this one, how I was 50-50 on it anyway, so I don't know, um, I don't know. I don't need to do it. I think MLS is doing it, so, I can step back from this one. Um, Train wreck for sure. Hope so, Marcy. So what's Marcy say? This is an emotional case. The jury may feel like us, may feel is accused unfairly. Crucial culprit. Hopefully, yeah. Hopefully, Marcy. Um, I only saw part of it when Raggy. Right. So I think fingers crossed, Marcy. Yeah. How about Kevin Winslow trial? Football player, his daddy was Kevin Winslow. Oh, okay. Mark is no slouch. You're right. You're right. And also, I know that I'm going to be biased towards him as well. So I think you would take that. If you think he smashed it, you got to step back and go, hang on, did he actually smash it? And that's why he step back from the prosecution. Actually, I did not like that finish, um, but I liked her. So but was I too harsh on her? I don't think I was, but um, yeah, yeah. I mean, I think it was the same one. I I think, Dave, I know I'm with you. I like the football element of it, but I think we're going to do Brooks. I see enough people here saying Brooks. So um, let's do Brooks, and we'll do one of the Kyle and Winslow ones again, Dave. Let's do Brooks then. Um, Mad World is right that we do Dara Brooks. Is that all right? I'm going to check with Mad World first before we do it. Yeah, hopefully you're all in on that. It's just because uh, and it's one of those tries you can just pop in when you can. If you're not here around, don't worry about it. I've heard a lot about Dara Brooks, but I've never seen it. So I've seen some clips which are wild. Mad World's ignoring me. Mad World, we have for Dara Brooks. Um, Hang on, that's a good question. That's a good question. How long was the trial? I could look at law and crime, law network thingy playlist. Um, I think it was 13 days for some reason. It was 13 days, I believe, but it 13 days, but I'm not playing 13 days of it. Do you know what I mean? I got. Let me just check because we're getting different people saying different things. Ba-da-bum-bum-bum. Here we go, Dara Brooks, right, let's... It is 13 days. 13 days. Right, right. Right, okay. Winslow's large penis locked him up for a while. I don't know anything about that, mate. Right, don't know, Dan, when you know the outcome, yeah, that's fair. The reason I'm doing this because we don't have a trial, Madwell. I'm only doing this. Uh, Hang on. We'll just get this clear. I'm hoping to do 2 days in one, and I'm only doing this until the very next trial. It might be 3 days time we get another trial, so we'll only be doing three. I'm not streaming this in its entirety. Um, I'm not going to be doing it all in its entirely. Clearly seem longer. Um, yeah, that is a bad sign. There's always a trial, but there's no trial at the minute though. That's a problem. That's the problem I have is there's no trial. That is my problem. Ah, do you know what? Right, let's discuss afterwards because we're never going to get an answer here properly.
Present, we are outside the presence of the jury. State, anything you need me to address before we bring the jury back in and resume with the closing arguments?
Yes, sir. One thing, the defense has the board to, regarding reasonable doubt, and the state doesn't object to the board.
Is that it right now?
No, I think it's over.
Can I see it?
Over one. It's not the law, and also it creates burdens that don't exist.
Figure up a little higher. All right, state, you object to this.
Yes, sir.
All right, and the basis for your objection is?
It's not the law, and it also creates burdens that don't exist.
Mr. Agash, your position on the state's objection to you putting something in front of the jury that is not the verbatim definition of burden of proof. Go ahead, sir.
Everything here is accurate, that possibly guilty, maybe guilty, probably is not enough, that they have to find proof beyond a reasonable doubt. Everything here is factually and legally accurate.
State, let me ask you this. Wouldn't he be allowed to say those words? It wouldn't be objectionable if he said those words, correct? It's a valid
I think
argument.
it would still actually be objectionable.
You think it's objectionable to even say the words?
I mean, we don't have those burdens. It's just what the law is, and you can prove a reasonable doubt. Beyond an extremely reasonable doubt. I mean, those are giving all these categories. I can even speak to them. Confuse the jury when it comes to the law and reasonable doubt.
All right. Over the state's objection, I'll let the defense put it up as a demonstrative aid. You all are going to have the last word on this. If Mr. Killoran wants to address it with the jury as to what I'm going to read to him in the jury instructions, I, of course, am going to read again to them that I'm going to instruct them on what the law is. But over this state's objection, I'll let the defense go forward with that. State, anything else before we get going?
No, sir.
Defense, anything else before we get going?
No, we're ready to.
All right, so presuming Mr. Agash takes his allotted time or something close to the allotted time, we would arrive at the lunch break. So after that, I'll send the jurors to lunch. I'll give them the normal 1 hour, 15-minute lunch break. Mr. Kilburn, when we hear your rebuttal argument after that, there's exactly 60 minutes remaining. 60 minutes. Okay, please bring the jury back in.
Jurors entering.
Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, once you're back in those seats, you may be seated. All the parties may be seated. Ladies and gentlemen, those of you using the notepads, I'll give you a moment to get the notepads back out. All right, ladies and gentlemen, welcome back. When we took our quick restroom break, you had just heard the state's closing argument. At this point, we're going to turn to the defense closing argument. Mr. Igars, when you are ready, you may proceed.
Thank you, Your Honor.
He knew where the shooter or shooters were located. That's not what the evidence showed. Saying it's so don't make it so. So let's just jump right into his transmissions. His transmissions corroborate what he told Detective Curcio 2 days after the shooting, when he wasn't a suspect, when there was no internal affairs complaint, when he was just a witness to a homicide. And he told Detective Curcio, I didn't know precisely where the shooter or shooters were located. In real time, if he knew where the shooter or shooters were located, why is he saying at 2:29:02, Perry, Deputy Perry, we learned that from his testimony, does he, the injured Kyle Lamons who was with him, does he know where the shooter is? Why is he asking that if he knew? If he knew precisely that the shooter or shooters were located inside the 1200 building and not by, inside, or around the area, why right before that is he asking at 2:28, do not approach the 12 or 1300 building? If it's just the 1200 building, that's something different. Why at 2:45:25, something that was not even on her board, not on the state's board, because they don't want you to know that over 18 minutes later, he's still saying between the 12 and 1300 building is the last time we heard shots. 24 witnesses came in here one by one and told you they couldn't tell from the sounds precisely what area we're talking about. The best you can do is narrow it down to that general area around the 1200 building. Their entire case hinges upon this erroneous belief that he knew that there were kids in that 1200 building being shot by this monster. And that wasn't proven because it didn't happen. Now, I want to take a step back and remind you why we're here. It can get lost as the prosecution continues to point their finger at a 32-year veteran, honorable, decorated, award-winning. Everyone who testified talked about how wonderful of a human being he was. Out of 3,200 kids on that campus, they didn't find one to come in here and say something derogatory about him. Well, he was lazy, he didn't assist us. Not one teacher, not one faculty member, not one. Because he truly was extraordinary. 32 years. And then 4 minutes and 15 seconds, he becomes a felon. We're here because of that monster. That's why we're here. He chose to commit one of the most abhorrent acts ever He changed all of our lives. 17 people killed, 14 were children, 17 injured. He did it. And one of the carnage, the extended carnage, is that a man is sitting over here fighting for his liberty.
Objection, Your Honor.
Yeah, that's sustained. Go ahead, sir.
This is a criminal case. This is not an administrative hearing. Let's talk about, Judge, you can take it down. Let's talk numbers, because that is not in dispute, just so we have the parameters. The shooter was inside the 1200 building for 6 minutes and 36 seconds. For approximately the first 2 minutes, my client wasn't even at the scene. That's very important because the state still had testimony from people on the first floor to appeal to sympathy, obviously.
Objection, Judge. That's attack on the prosecution.
That's overruled. Again, ladies and gentlemen, these closing arguments are meant to assist you in your determination of the facts. But you're going to decide what the facts of the case are. What the lawyers say is not evidence. Go ahead, sir.
He wasn't even at the scene on the first floor until he hears the shots of Aaron Feist. Aaron Feist was shot at 2:23:25. That is not in dispute. 2:23:25. 1 second later, my client gets on his police radio and announces, be advised, we have possible, could be firecrackers. Understand that the 4 minutes and 15 seconds, the time that he has to do something, begins with him trying to sort out, wait, I thought we were talking about firecrackers. So at first, click, 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 seconds running down, possible, could be firecrackers. I think we have shots fired, possible shots fired, 1200 building. He's giving his location, and he's telling people to respond to that area. He doesn't say inside the 1200 building. And the Peterson rule from now on with all law enforcement is going to be to get on the radio and say, when I say 1200 building, let me make very clear, I'm not saying inside, I'm saying the area around. You see, I'm not really sure. It's ludicrous to suggest that when he says 1200 building, that what he means is definitively inside the 1200 building. That's not what he's saying. And he never definitively and clearly says inside the 1200 building. His first reaction is 1200 building because he's literally standing 10 feet from the 1200 building. Now they could condemn him all he wants that he doesn't walk up and open up the door, but the shots rang out as he was 10 feet from the door. Him and Calvin Greenleaf were standing there. They were approaching, and then the shots rang out. And it was shocking, and it was jarring for everyone. No, he didn't say, hold on 1 second. Let me walk a few feet, open up the door and look in, because that's not how things went down. He immediately felt that he was in jeopardy. So did Calvin Greenleaf. They didn't know where the shots were coming from. And we're going to go ahead and play now what happened. What you're going to notice was he doesn't immediately run to shelter. 2:25, the shots ring out. You will see him on the screen again at 2:23:44. Another 18 seconds later, he remains, give me 1 second, he remains right by the 1200 building. Thinking of himself? No. Thinking of the kids in that building? Yes, because he doesn't run for cover. He stands there out in the open with Calvin Greenleaf, fearing that there could be sniper fire, random people running around with guns, bullets from any direction. You understood he wasn't the only one who said that. Every single cop is trained to believe that all that is possible. So to his credit, he stands there with no vest on. Yeah, that's the reason why we brought it up. He didn't say, hold on 1 second. Let me go run to my vehicle, put on my vest, and get my rifle. He stands there, vulnerable as you can be, risking his life, and gets on the radio and yells shots fired, because every second does matter. He stands there and he yells shots fired. We're going to see the delay in how long it took. A good 18 seconds before he gets back to a position of cover. That's 18 seconds he could have been hit by fire. And he stood there and not only gets on his radio and announces shots fired, but gets on his school radio and orders a code red. We'll talk more about that in a moment. Let's take a look.
Mr. Savitsky, this is attorney 3. Could it be disrupted by the wireless?
I think Mad World, you described it, he's annoying, but he is effective. So, and when he turned around to that prosecutor, the foxy one, who was like, really? That was funny.
So we just started at 2:23:25 after Aaron Feist was shot. Medina drives away. And you don't see Scott or Calvin Greenleaf until, take a look, 2:23:44. Pause it for a second. Go back just a little bit. The other thing I want you to see is, it's not just Calvin Greenleaf who's pointing. Oh yeah, stop it right there. Look who's pointing. He's yelling. My client's concern right away is, get back, get back. And remember when Ms. Remy testified, Remy, one of the teachers, she heard my client say, get back, get back. His concern is for the kids in that building. That's him gesturing, get back. Both Calvin Greenleaf and my client saying, get back into the 700 building. Why? If the shots are contained within the 1200 building, and my client somehow knows that, those kids are not in danger. No sniper fire, no harm, no nothing. He gets them back in there because he is extremely concerned that now this whole hot zone becomes an area where he and everybody else could be harmed. He doesn't know that there's one shooter. Nobody knows that. We have the luxury in this courtroom of hindsight. Hindsight's 2020. Monday morning quarterbacking, there's phrases for it. And when you're in the hot zone like my client was, going through adrenaline dumps like we heard about, and the things that people were experiencing, the stress of that situation, my client is concerned about the kids. Look, he's got his hands up and he's gesturing. Keep going, please. Pause for a moment. So we know up to this point, he risks his life by standing there for 18 seconds and reporting shots fired, possible shots fired, firecrackers. I think we have shots fired, possible shots fired, 1200 building. He's also on his school radio ordering a code red. We know that because Anna Ramos came in here via Zoom, and she couldn't have been more credible, believable, and honest. She was extremely grateful to Scott for ordering the code red because it saved lives. Imagine if he didn't order the code red, you got more kids exposed and outside of their classrooms as a result of him ordering the code red, him doing that, which was corroborated by Jeffrey Morford. He also heard his voice. It saved lives. Imagine, and he would have been justified in saying, oh my gosh, there's possible shots fired. I'm going to take a few minutes and run to my car to get a vest. Everyone else did. Every other cop put on a vest and had their gun. Their long rifle. Not a pistol, but a long rifle. He didn't. He stays there exposed. And look, he's standing in the open because these radios stink. The state's missing the point. The radio problem existed way before this shooting. At this school, we heard testimony from numerous people that Scott always had problems with his BSO radio. Constantly. You had to literally leave the building to get reception. He's risking his life without a vest, not knowing where the shots next are going to be coming from, to ensure that those critical dispatch announcements get out there. So instead of thanking Scott for doing that, We're prosecuting him. We're prosecuting him. He could have stayed behind the wall and risked his transmissions not getting out with those radios. They don't want you to believe that there was a problem with the radios until somehow later into the shooting. That was not supported by the evidence, just the opposite. We had numerous people testify that in Parkland especially, those radios were horrible. They were antiquated. Ms. Mize talked about 25 to 30 years. Outdated technology before the shooting ever started, and certainly when the shooting did. And Scot risking his life standing there. Now, we do know he later takes a low position of cover and he's looking, but right at the beginning to get out those critical announcements, Scot is risking his life to stand out there. That is uncontroverted. There's no other reason why he's putting himself in that harm. We're all set. We're all done. I want to take a breather and thank you. I'm going to get hot in just a moment again too, but I got to take just a breather for a second. I asked all of you during jury selection a lot of things. One of them would be, would you hold it against my client if I fought like heck for him? You know, where I just was passionate and I cross-examined witnesses and even got to the point where sometimes even the judge would have to sustain objections, even though the judge doesn't favor one side or another. He's going to tell you that. Would you hold it against my client if I became very zealous and passionate? You all said you wouldn't. That was one of the many promises that you made to us that led to you making the cut from the hundreds and hundreds that we interviewed. Why else are you here? Because you all swore that you could follow certain cherished legal principles that protect not just Scot Peterson, but every single one of us if we're ever accused of any offense, including a speeding ticket. And that starts with the presumption of innocence. Remember, I had Scot stand up. You can look over at Scot again, too, if you want, like I did in jury selection. Like, look at him. Does he remind you of an ex-boyfriend that bothers you? Does he remind you of a cop who maybe harassed you or gave you a ticket? You all said, no, I'm cool with it. And I will presume or believe that he is innocent. And I challenged you. And a lot of the jurors went bye-bye, potential jurors. Because I said, really? You can truly presume or believe he didn't do something to be here after 4 years of them filing an information on a computer, a charging document on a computer? You sure? Well, I guess, yeah, you make a point, Mr. Eiglash. I mean, he probably did something. Okay, bye-bye, thank you. Maybe there's a DUI case down the hall with your name on it. That's fine. But this case required people to look over and presume or believe that he's innocent. And I challenged you. I said, well, have you ever seen anyone on the side of the road being arrested? Or on television, on the news, you see somebody arrested. How many of you actually say, why are they arresting that sweet, innocent person? Very few of us.
Judge, at this point, I'm going to object to fact-finding evidence. This is not relevant to the facts that were heard throughout trial.
No, it's overruled. Closing argument. Go ahead.
So you guys said, no, we can presume and believe that he is innocent. And the only time that would change is if you heard sufficient evidence from the prosecution beyond and to the exclusion of every reasonable doubt. Not maybe he's guilty, not probably he's guilty, not 100% I think he may be guilty. It's the highest burden under the law. We're not dealing with money in this arena, folks. So you all swore that you would hold them to that burden. You also swore that you wouldn't have us prove anything, that you understood that we literally could sit there and do nothing. I knew we wouldn't do nothing. We called plenty of witnesses. And I asked a lot of questions, and their responses on cross-examination, that's evidence, and we're going to go through all that. But you all swore that you could follow the law. We knew what the evidence was. You heard that we had taken depositions of all these witnesses. We knew it line by line. So all we needed was a fair jury. That's all we were praying for. And we got it in you. And so on behalf of Scot, I thank you very much for that. You also swore that you understood that we're not here for an administrative hearing. Meaning, let's determine if he violated his training.
Now, I suggest to you as we go through the evidence, he did everything he could and he didn't do anything wrong at all regarding his training. But in the worst case scenario, even if you found, well, maybe he should have done this, I don't know. We heard from some people who said he didn't do this. That's what a suspension from work would be. That would be a termination or, hey, let me have your resignation. What they've accused him here is criminal acts. That what he did that day with all of the efforts, with so far him immediately announcing that shots are fired, because that's where we are in this case so far, and ordering a code red on a school radio, risking his life, standing out in the open with no vest for 18 seconds, that somehow that's criminal. That's what we're here for. So let's review the evidence, and I'll repeat what I said in opening, and I strongly believe it now, and I think the evidence shows it. Scot Peterson was sacrificed.
Objection, Your Honor. Sacrificed by whom?
Yeah,
Please,
that's,
I'm going to object to the speaking objections too. I'm not leaving
okay,
it.
your objection is overruled. Your objection is overruled. Ladies and gentlemen, this is closing argument. Go ahead, sir.
He was sacrificed. He was thrown under the bus, and it continues right now. What is not in controversy, so let's try to narrow down focus, is this was a horrible tragedy. The parents who lost children experienced, to me, one of the, probably the worst thing a parent can go through. As a father of 3 kids, I cannot imagine what they went through. And some of the feelings that you're entitled to have would be frustration, because we're all citizens here in South Florida. So you wouldn't be human if you didn't have, as a result of what that monster did, feelings of frustration, anger, sadness, compassion, and demand for change. All those are very normal. But none of those feelings have any place when you're evaluating whether Scot is guilty of the offenses that they've alleged. One minute and 6 seconds. That's the time that my client had from the time that Aaron Feist is shot to the time that that monster gets to the 3rd floor and begins shooting and killing the people that he's accused of neglecting. 1 minute and 6 seconds. It took a team of 12 SWAT members over 30 minutes to clear the 1st, 2nd floor and get up to the 3rd floor. And somehow it's pure fiction to suggest that Scot, even if he knew, and we'll focus on it, he did not know, but even if he knew that somehow he could have made a difference. That is pure fiction. So how did this start? Let's talk about what's uncontroverted. My client gave a statement. It's there. We've highlighted it for you so you know. And then I asked Detective Curcio, so was this corroborated? Yes. Was this corroborated? Yes. This turned out to be true? Yes. This turned out to be true. Everything was, there was nothing. Well, hold on. No, it turned out that wasn't true. So let's go through it. First, it was Valentine's Day, ironically. A day of love, a celebration of love. And that's when this monster chose to make it about hate. My client was in his office, as the statement reveals. He was intently working on his computer, researching the statute for when you possess a counterfeit or fake driver's license, because he had a student who possessed one. He wasn't going to arrest her. He was meeting with the father to explain to him and her how serious of an offense this was. When Greenleaf comes in and says, hey, possible fire, did you hear, whatever, my client doesn't say yes because he's busy working. He didn't hear. His radio's charging in his office, and he jumps up and he says, let's go. Let's change the facts. Let's say my client said, wait, what? Firecrackers? You go deal with it. That could even be gunfire. You go deal with it. I don't want to deal with it. I'm going to stay here in the safety of my 100 building. I don't want to go all the way down there. By the way, it's far. It's like a football field or two to get all the way down there. I don't want to deal with that. I'm going to stay here.
Okay, that would be neglectful, I think, right? We start to get to neglect, not criminal neglect, because there's two different standards. We'll talk about that. But all right, no, he immediately gets up, let's go. And then you see the video, you've seen the videos, he gets up, he starts to go out. They don't run just yet because firecrackers, that was not uncommon, particularly on Valentine's Day. No one really took it that seriously. But the minute the fire alarm goes off, that's something different. You immediately see Scott not walking, but running with Kelvin Greenleaf until they're picked up by Medina. Andrew Medina. Remember his name, folks? Remember when Kelvin Greenleaf testified? He made a face, and I caught it. I said, what was that face for? He talked about how Andrew Medina watched as that monster pulls up, gets out of a vehicle, walks all the way towards the 1200 building. We know how far this campus is. We know we're talking about 45 acres. How long of a walk it was to get to that building. And Medina doesn't stop him. Medina doesn't do anything. He watches as he's carrying his weapons of destruction all the way into the 1200 building. And he heard shots, and he knew what he was up to. And Andrew Medina said nothing to my client or Kelvin Greenleaf. I'm not saying Andrew Medina should be facing criminal charges. That's not for me to decide. I've learned not to be that person who points their finger, because I know there might be another version. I don't know. But he didn't share any of that information with Scott. If Scott knew from Andrew Medina that there was a person who Andrew Medina knew as Nicholas Cruz, they knew his history. They knew him. That crazy Cruz, they knew him. If Andrew Medina said, yeah, I saw that guy, he's wearing a burgundy ROTC shirt, black pants. He had the description. Remember, he gave that description to Burton when Officer Burton shows up at the scene. Medina knew it. He doesn't tell Scott. This case is done with if Medina tells him, by the way, he's inside the 1200 building, and I saw him with a bag, and I heard shots right thereafter. We're done. That didn't happen.
Yes, sir. Go ahead, sir.
So then he gets to the building
Certainly passionate anyway.
and he acts heroically by reporting what he knows. And understand this was very, very shocking because all officers talked about nothing like this had ever happened. Ever. Nothing. No training. We'll get to that in a moment. Nothing prepared them for this. To sit in the calmness of a courtroom that's chilled and mellow and try to go back and Monday morning quarterback is unfair and unjust. The situation out there was much different. I'd like to go through their testimony, one by one, witness by witness, and discuss with you what each one said. And it will be clear to you, at no point you go, okay, so now we know. Now we know. And when I say we know, we're talking about the critical issue that my client knew in real time that shots were coming from inside the 1200 building, and more importantly, that kids were being killed. That's the idea that they're suggesting here. That's what they're alleging. That a man who everyone said loved those kids, had a great relationship with those kids. He spent years dedicated to the protection and welfare of those children. He cared about them immensely. And they're saying, I'm just going to sit here and do nothing. Leaving out, of course, we didn't hear one word from the prosecutor that we'll get to it, that during that time he's sending Assistant Principal Morford to the office to watch surveillance footage to find out where the shooter or shooters are located. Why would he have done that if he knew where the shooter or shooters were located? All right, let's just if I can get the,
The wireless.
yes, please.
Feels a bit more real now, doesn't it?
Just give me 1 second, this is not.
Yeah,
working.
take your time. Mr. Savitsky, you want to help him out? Please, thank you.
Change the batteries. and stuff.
That shot of Scott was like, whoa.
Okay. So let's start off. Again, you start off before the state calls their first witness with the presumption of innocence. Remember when the judge asked you what your verdict would be? While you were being asked in jury selection, not guilty, not guilty, not guilty. Okay, so the first witness comes on.
It's on the wireless. I don't know if you got to do the talk.
First witness was Daniel Gilbert. Daniel Gilbert was a student on the first floor. My client wasn't there yet. They played some videos that were hard to watch because all the kids were very tense. I can understand why they wanted to introduce that, but that offered zero value at all to the issue of whether my client knew that there was a shooter or shooters in that building. That's what we're talking about here. That's the issue, the primary issue here. So nothing. She talked about nothing that had to do with that. Next one was Ivy Shamus. She was a teacher in room 1214 on the first floor of the 1200 building. My client wasn't even there yet at all. Not sure why they called her, but I'm sure they had some value and I thought there was some value to her, but nothing to do on the major issue in this case. Next one was Ronald Lother. They introduced him, had him introduce the videos in the case. Okay, that's no firsthand knowledge of anything. And now Sergeant Heinrich. Let's talk about him. He had no problem being the first of many witnesses who the state would call to say, you're supposed to go towards the gunfire. Let's make this real easy. I've said it over and over again. We don't disagree. Cops know it. Common sense dictates it. If you know that there is a shooter in a particular location shooting kids and or adults, you go in there and you kill them. That is not in dispute. The issue is whether he knew, and the evidence fails to show it. He heard shots. He was on the campus, and he heard more shots than my client because he was there on campus when the shooter began his rampage on the first floor. So he heard all 140 shots, or had access to them. Because another issue is we heard from so many witnesses that they only heard like 4 to 5 shots. Oh, I only heard a few shots. No one came in here and testified to hearing either all 140, or if they were just there for a brief period of time, all 70 shots. Nobody heard that. Whether it be because of auditory exclusion, whether it be because of this being a hurricane-proofed building, whether it be because everybody was stressed, whether it be because the shooter's moving around in a 73-yard long building. 73 yards, 3/4 of a football field. I don't think any of the state witnesses understood, because they weren't there to hear the shots, most of them, what my client was confronted with and what over 24 people who testified were confronted with, that you couldn't tell because of the pronounced reverberation and echo in that entire area, every place, where precisely the shots were coming from. 73 yards long. And just so we're clear, the first shots that my client hears, it's uncontroverted. We're going to get to him for a second, but it's uncontroverted that was when Coach Aaron Feist was shot. I got to bring this up because Aaron Feist was shot over 73 yards away. My client's on the east side of the building. Aaron Feist was shot on the west side. So we are literally talking about Aaron Feist thought he was around here, outside of the 700 building. Cruz was inside, the door was open, and very tragically and unfortunately, Cruz shoots outside, and his body, with the door open, falls outside. It makes total sense, and even the prosecutor conceded in her closing argument, that it makes total sense that it would sound like the shots are coming from outside because the door was open and the gun is pointing west in an opposite direction of where my client is, all the way here at the 700 building. The clock's ticking at 4 minutes and 15 seconds when he hears shots from outside of the 700 building, the 1200 building. The door was open. Jeff Heinrich heard all the shots. He was there for all 140. And he told us that he heard 5 to 6 shots. By the way, he works for Coral Springs. We're going to make that distinction a lot during this closing argument. He heard 5 to 6 shots. He thought they were fireworks. He's familiar with guns. He couldn't tell if it was inside or outside. Then he heard another round of gunfire. Shots were, quote, loud and banging off of things. This is their witness. This is their witness. So far, nobody has said anything that helps their case on the issue. And you've got him coming up and saying it's loud and banging. The best he could narrow it down, his words, somewhere around the 1200 to 1300 building, somewhere in that area, which is precisely, at best, where my client narrows it down. Do not approach the 12 or 1300 building. 245, 25. Between the 12 and 1300 building is the last time we heard shots. Heinrich's belief from the west side is identical to my client's belief all the way 3/4 of a football field on the east side. Identical. So I asked him, where could the shots have been coming from based upon the sound that you heard? It included but wasn't limited to on the top of any of those buildings. And again, the 1300 building is also the same size as the 1200 building approximately. We're talking about 73 yards long. So you got the 1300 building. You got the 1300 building, which is the same size as the 1200 building. You got the courtyard area, which we heard was about 20 yards. So you're talking about at least 2 football fields as a possibility, and the surrounding areas. That's Jeff Heinrich's belief, their witness, their first witness that had to deal with the major issue of this case, of sounds. Okay, all right. He calls 911 and tells his dispatch of his real-time intelligence. This is the first time that we learn that their dispatch is not the same as BSO's. I know I just repeated that over and over again, some of the same themes, to ensure that my very intelligent jurors and detailed, because that's what we were looking for. I told you I needed detailed jurors, would understand that 911 cellular calls went to Coral Springs. BSO didn't get any of those calls at all. So Heinrich calls in his real-time intelligence. None of that makes it to my client, who's waiting anxiously for information. He has every reason to believe at any given moment, BSO is going to come on and say, okay, it's in the 1200 building. Or hey, go to the 1300 building. Okay, it never came. How could you not be extremely disturbed by that? That's not my client's fault. He's thinking any moment, like any normal call, there's going to be some real-time intelligence. Wherever this person is, there are witnesses. And there turned out to be many who called in with specific instructions on where the shooter's located. Remember that one dispatch that Coral Springs got? Classroom 1213. People down in that classroom. If my client gets that information, he's in. We're done. They never gave him that real-time intelligence. The prosecutor tells you that the best information, the best real-time intelligence is from my client? Oh, no. The best information came from kids who were staring at this monster, and they're watching him commit atrocities like we've never seen. They know precisely where he's located. They know what floor. They know what classroom. And none of that information went to my client. I know I'm raising my voice, folks. Every now and then I'm going to realize it, bring it down. But how do you not get passionate about that? Sergeant Heinrich sees Aaron Feist down by the west side. My client doesn't see that. He couldn't see it. He knows right outside the 1200 building, Aaron Feist was down. And what does he do? He takes a tactical position of cover. Every officer that responded to that scene, whether it be the 36-year veterans or those with less experience, all did exactly what they're trained. They take tactical positions of cover, because only in cheesy movies does the cop just walk around without a bulletproof vest and somehow walks like he's 10 foot tall and bulletproof. It doesn't work that way. Everybody took a position of cover. And the prosecutor in her chart conveniently calls it, even though everyone calls it a tactical position of cover, her words were, he retreats. There was another offensive expression here. Remains in a fixed position. Fixed position. Did you hear any witness call a fixed position? It was a tactical position of cover, because if he gets shot, he's of no use to anyone as the first responder to that scene. He needed to stay alive. That's what every cop did. So Heinrich, the best defense witness that we could have, that they called. He never went into that building. I'm not blaming him for it. He's the first of many officers who had more information than him that took positions of cover and never went in there, which is why the most appropriate theme is he was sacrificed. He was thrown under the bus. Because why are they singling him out? Why? I'm not saying anybody should be arrested for this at all. Everyone should just learn from this experience and grow from it and be debriefed from it. We'll get to that, which they never did. But to be sacrificed, let's take the first guy on the scene, the 32-year veteran who's done everything he could, and let's sacrifice him, because maybe they won't look at all the failures that the brass have been involved with for years. Next one, Brian Staubley. Scott was extremely professional. He heard one shot. He talked about the pronounced echo in the hallway, 700 to 800 hallways, exactly where my client was. And then you heard Mr. Killoran try to say, oh gosh, well, that's a problem because that's where Scott was. Yeah, but didn't that echo just end at the hallway? So if he was standing over here for the couple seconds that he was trying at the beginning to do that, as opposed to be back here, then maybe there wasn't an echo. There was such a pronounced echo everywhere in that area. We know that when we talk about our witnesses, who I'm going to talk about in a moment. Staubley believed that he was in danger standing in that area. So understand something. We have never said that my client didn't consider that one of the possibilities, one of the many possibilities, was that the shooter or shooters could have been somewhere in, around, on top of, shooting out of the 1200 building. But what was also his words is every time, remember when the prosecutor said, did you hear when he said inside the 1200 building? He kept leaving out by inside the 1200 building, because that's his exact words. By inside. By inside. It's over by inside the 1200 building. The prosecutor says by inside. That's not how he said it. You heard him say it. By inside. It's exactly what Burton believed. By inside. But understand, because the campus is so large, that encompasses a huge area that we're talking about. So Staubley was told by Scott
get out of the area because Scott was trying to protect Staubley's life. He thought he was in danger. And even though Staubley thought, well, it might be coming from the 1200 building, he never then turns to Scott and says, hey, I think it might be coming from inside the 1200 building. What Staubley did tell you, very credibly, is it appeared to Staubley, quote, that Scott was trying to figure out where the shots were coming from. That's his testimony in real time. One of many people Kelvin Greenleaf will get to. It's exactly what they thought, that Scott was doing everything he could in real time to figure out where those shots were coming from. They act like they were there, but those prosecutors weren't there. Defer to those who were. Next one was Kyle Lamons, who suffered a horrific injury. Horrific. He didn't offer anything regarding whether my client knew where the shots were coming from. Next one was Ed Suarez. He was by the cafeteria. He heard firecrackers, and he said it was somewhere behind him. That's the most specific he could be. Somewhere behind him. Yeah, the 1200 building was behind him, so you go, aha, Suarez knew it was 1200. Anywhere behind him, remember, just like Staubley, Stoneman, the best people could do is narrow down some geographical area. Nobody could say it was inside the 1200 building.
The objection sustained. Again, ladies and gentlemen, what the lawyers say is not evidence. Okay, I want you to rely on your memory of the evidence and the witnesses and the testimony. If the lawyers say anything and you remember it differently, I want you to rely on your own recollection of what the evidence was. Go ahead, sir.
Ed Suarez, you could check your notes. Ed Suarez made it very clear. He couldn't say it was coming from inside the 1200 building. I questioned him on cross-examination. Could you say with certainty that you thought the shots were coming from inside the 1200 building? And he could not say yes to that. He did say, though, this is important, he heard Scot Peterson on the school radio saying, please stop talking over each other. So one of the things that Scott's doing is, in real time, amongst many other things, keeping the kids from the 700 building back into their classrooms, monitoring 2 radios, which we heard from one of the school resource officers, how that can be very, very difficult. Listening to both and speaking on both and dealing with the stress. He's also telling people, hey, one at a time on the school radio. Whose benefit was that for? For Scott's? Or was that meant to help the people on the scene who were trying to help everybody there? Next was Anthony Borges. He suffered massive injuries. And ultimately, again, this is all on the monster, the shooter. But here's what's interesting. Through him, through the state's case, this interesting concept that none of us would have thought occurred. And that is that kids on the 3rd floor did not hear shots from the 2nd or 1st floor. Understand that before the fire alarm went off, which was caused by all the shooting that monster was doing, there were a lot of shots being fired. No one on the 3rd floor heard those shots. And then he goes on the 2nd floor, this monster does. He shoots out of room 1234, and he shoots out the other, it was 1214, the other direction. No one heard those shots. And you know why? You know how we know that? You saw the video, remember, on the 3rd floor of all the kids walking out onto the 3rd floor? They're calm as calm could be. No teacher would let their children walk into the 3rd floor if they thought they were dealing with gunfire. And Borges tells us that. No, I didn't hear any gunfire. And then when do they hear it? Cruz is right there shooting on the 3rd floor. Next witness was Nicholas Mazzi. He arrived on the west end of the 1200 building. He's with Carl Springs. Every time you say Carl Springs officer, fill in the blank, now you're talking about a different playbook. They have all the real-time intelligence. They know from their dispatch where the shooter is located, that it's just one, that kids are being shot and or killed. They know all that. We established all that. BSO, from all the deputies we called, they didn't know that. So if some of these people look like heroes, it's kind of like someone bragging about getting a great grade on a test, but they had all the answers. You're not smart. You didn't get a good score. Well, you had all the information. You knew it. We didn't. You didn't share it with us. So he testified that he sees Feist dead. He knew it was from inside the building, but he admitted it's because I had the real-time intelligence before he went in. I asked him, did you know whether Coral Springs had ever relayed that information to BSO? He didn't know. And the tragedy is that these well-meaning Coral Springs officers didn't then turn to the BSO officers on the scene and say, here's what we know, because they assumed competence from the higher-ups that either the radios were patched or that the information coming in to Coral Springs would be provided to BSO deputies. That didn't happen. Is that Scott's fault too? How dare they not take responsibility for what they didn't do and what they did? Again, my client has that real-time intelligence. One of their Coral Springs officers says, by the way, there's somebody who got killed in room 1213. My client's in. And if he doesn't go in, well, now you've got some really good evidence that my client's putting himself first and didn't go in. But we have none of that evidence. So we're going through the state's case. Still not guilty. No evidence that he knows precisely where the shooter's located. Next witness is Marian Kavachenko. He got hit in his leg. And what we got from him is that a teacher hit Rospierski. He's standing right there. He's trying desperately to seek shelter in Rospierski's classroom. And he sees Rospierski getting out his keys. And Rospierski didn't have the keys to open up his classroom door. Now, whose fault is that? Is that my client's fault? So Rospierski, instead of being able to shelter his kids, has to yell, "Run!" That's what we heard. And in the most offensive scenario ever, even though my client ordered a code red to protect all these kids and get them inside the classroom, and all the teachers on that floor, they had their keys, they were able to get the kids inside, but Rospierski left his keys out. So what is so offensive is the state turns around and they charge him criminally with the death and the harm that came from students that Rospierski were not able to allow to be sheltered in his classroom.
Objection, Justice. The third party.
The objection's overruled. Again, ladies and gentlemen, these closing arguments are meant to assist you in your determination of the facts. What the lawyers say is not evidence. You are going to decide what the facts are. Sir, you may proceed.
They couldn't get shelter.
That, I don't like that. The judge should tell her to shut up now.
And also remember with him that when he left the building and he started running, remember his testimony? He still felt he was the target as the shooter was sniper firing out the west side teacher's lounge, and he felt that he wasn't safe. Again, adding to the whole scenario that everywhere around that campus area of the 1300 building, football field, that whole area is a hot zone. He didn't feel safe. Armand Borgi, he was a student on the 3rd floor. He testified that he saw Scott with his gun drawn. My client doesn't do anything? Imagine if my client didn't even pull out his weapon and he's just standing there like this. I'll just wait till SWAT comes, which is essentially what they're saying he did. No, he has his gun out, and I'll get to Burton, but Burton had him demonstrate that he sees my client in a low ready position, scanning, looking around, not, let me just stare at the 1200 building because that's where I know it's all happening. He's looking. Remember how many people said he was scanning and looking everywhere? That's what they're trained to do. In fact, Armand Borgi specifically told you that when he saw my client looking, quote, west towards the football field. West towards the football field. Not glued on the 1200 building, because that's the only place he knows that the shots are coming from. Ashley Hazeltine. She came from Hertzville's class, room 710. She heard what she thought was banging noises. She thought, she's the one student that they got to testify to say that it might have been from the 1200 building. But understand what her testimony was. She didn't say, shots are coming from the 1200 building. Her first thought was, the roof must be collapsing from up there. Remember that? And then she looked, she goes, oh, I didn't see the roof collapse, so I just assumed it was a 1200 building. Okay. Okay. That's her testimony. She did tell you that she would play the echo game right in the very area that my client was at. Remember the echo game before the shooting? Because there's a pronounced echo right there where my client took a tactical position of cover. Here's the question. When they had her testify, the issue became apparent. They found one student, just one, to testify that she thought the shots were initially a building, top of the building exploding, and then I figured it must have been coming from 1200 building. Remember when I asked Detective Curcio? And I asked him, by the way, about the other students that came out of the 700 building and neighboring 500 building. I asked because we see on that video, you've all seen the video many times, of all the students that are rushing out of the 700 building. We can't see all of them from the way the video is, positioned, but we do know that every student was not exempt. Every student had to exit their classrooms. It was a fire drill. And so remember when I asked Mr. Bonner, how many students would you estimate are in the 700 building and the neighboring 500 building? Remember what the estimate was? I know you wrote it down. 600 to 1,000. That was his testimony. Because again, you got a school of 3,300 kids. You got just in those two buildings. I just want to focus on just those two buildings for a second. You know that there are other buildings where maybe those students might have heard shots too, and we could find out where they thought the shots were coming from. But let's just focus on, because that's a lot to work with. 600 to 1,000. Remember I asked Detective Curcio, so did you speak to each of the students who came out, the 600 to 1,000? He said, no, that would have been for the lead investigator, Keith Riddick. Okay. So where are those statements? Where did they hear shots from? We want to know. It's in a file. Keith Riddick has it in a file somewhere. Remember when he said that? Has it in a file. Okay. I think it's a fair assumption that Keith Riddick isn't, the lead investigator in this case, isn't keeping information from the prosecutors.
Objection, Judge. That's Halliburton.
Yeah, that's sustained. Ladies and gentlemen, I don't want you to be concerned about witnesses you didn't hear from. I want you to decide the case based on witnesses you did hear from. Go ahead, sir.
We do know that Keith Riddick investigated the students who came out of the 700 and 500 building, 600 to 1,000. And from that, the state called one, her, that's it. What you deserve to hear is...
Objection, Halliburton. All of those witnesses were listed.
Yeah, that's sustained.
Judge,
Yes, sir.
we can go sidebar.
No, sir, you may not. Do you have any response to my ruling? We're not going to talk about witnesses that were equally available to both sides. Go ahead, sir.
But they weren't. That's what I want to say.
Sir, the objection is sustained. Go ahead.
The witnesses you did hear from, which we'll get to in the defense case, made it extremely clear that they couldn't tell where the shots were coming from. Carl Springs Officer Best, who came in here and pointed his fingers at my client and tried to make himself out to be some kind of hero. First and foremost, he had all the information that my client didn't have. He knew what was going out over dispatch. He knew where the shooter or shooters were located, and he stood by my client's side. Judge, if we can turn that on. Oh, I guess I have to turn this off.
The judge winds me up as well, Shelley. He's not been very. He's been quite biased throughout the trial.
Looks like his hands are on his hip. My client's there on his radio, you can see. And Best is literally standing by his side. He comes in here and he points his finger at my client, yet he doesn't go into the building at all. He's standing right there. 30 minutes or so, he's standing by his side. Let's give him the benefit of the doubt. Let's say he didn't know precisely where the shots were coming from. But again, to show you how hypocritical this is and how my client was sacrificed. Why is my client being prosecuted when he's standing right next to him and doesn't go in to offer any aid to any of these kids who are bleeding out, who doesn't do anything? He's standing right next to him.
Objection, Judge, that's a misstatement of the facts.
The objection's overruled, but again, ladies and gentlemen, you're going to decide what the facts of the case are. Go ahead, sir.
What Officer Best did tell you was that I ran towards Peterson. I regretted it because I was a sitting duck because the shooter was on a higher ground. So even Best, even though he stayed in that position with my client, he felt uncomfortable in that area. Nobody felt safe, which is why my client doesn't then come out from the concrete walls to stand any further unless he's trying to make some transmissions on his defective, malfunctioning radio to ensure, for the benefit of others, that that information gets out. But Best is right there by his side. He said, quote, nobody was in a safe position. And also, Peterson told me shots were fired on the second or third floor. I was blown away because at that point, we hadn't heard yet that my client had ordered Morford to go to the Building 100 to review the surveillance video. We know my client couldn't tell where the shooter was located because nobody could when you look through the windows of the building. So that would have been quite some time later when my client's getting real-time intelligence, or what he thought was real-time intelligence, from Jeffrey Morford, who's telling him over school radio over a 30-minute period, okay, wait, second floor, no, third floor. It went on and on and on. And so they tried to make it seem that my client knew where the shooter was located and was just sitting there. That didn't happen. Okay, let's go back to, turn that off. Next witness. Oh, don't. The next witness, whose face will come up in just a moment, is BSO Sergeant Richard Vandereems. He responded after the gunfire, so he wasn't there for that. Okay. He read the CAD notes. Remember? He read the CAD notes that my client in real time didn't have access to because he immediately is there on the scene. But the CAD notes, whatever those are, gave him some information that my client didn't have. And he ultimately helped clear on the east side. And he also talked about the radio issues, and he also never spoke to my client about anything. So he doesn't advance their theory that my client knew with certainty that shots were coming from inside the 1200 building. And next one is Tim Burton. If he doesn't prove that this is a selective prosecution, that my client was sacrificed and thrown under the bus.
Yeah, that's sustained. Can we go sidebar real quick?
It's quite annoying with all the. I'm the same as Mad World now. I'm Team Mad World. It's really annoying with all the. I hope that when it comes to that guy doing his rebuttal at the end, the Mark just objects to everything. Oh, objection. Even if it's no, it's not even object. He shouldn't object to it. It's annoying. I know the Mark pushes the edges, but come on. It's getting a bit too much now. Especially most of them have been overruled as well, so it's not like he's doing it on purpose every single time. And I thought he was allowed to speak about anything, and he's supposed to lie and stuff. Porter, East to judge after the fact, huh? Awful noise. Sorry, I have to pause these, though. Oops.
He's in the closest parking area, he said. He's behind a car, the closest one to the 1200 building. He's right there. He said that my client is literally in talking distance. They could hear each other. They didn't have to use radios, they could hear each other. And he asks my client, hey, what do you got? Instead of saying, by the way, here's what I got. I think Burton just assumed that my client knew all of this. He said, hey, what do we got? My client tells him 3 things. Remember, I'm sure you wrote it down. 3 things. Number 1, I don't know where the shots are coming from. He makes that very clear. But why would my client say that to a fellow officer? He's setting up some alibi because he thinks he's going to be prosecuted 4 years later? He doesn't know. In fact, Tim Burton, who knows my client very well, has utmost respect for him. They're both school resource officers. Said that it absolutely looked like my client was believable and credible and not making this up in real time. He didn't know where the shooter or shooters were located. Number 2, he tells him that he hadn't heard shots in a while. And that was true because Burton, since he got on the scene, they hadn't heard any shots. Shots had stopped. So my client didn't know where the shots were coming from, and he hadn't heard shots in a while. And third and most significantly, remember what he said? Hey, Burton, watch your back. Watch your back. Now, what's very important about that, and Burton understood that to mean is that there's only one meaning there. His back was to the parking lot. On direct, it was a little questionable. I think that I needed to clear it up on cross-examination. And it made it very clear that he was facing my client. My client was to the left. He kept an eye on my client for about 20 to 30 minutes while he stayed in a position of cover. His back was to the parking lot, this huge parking lot area. We're talking football field large. And my client saying, watch your back. If my client knew, as they allege, that the shots were coming from inside the 1200 building and everywhere else is safe, why is he telling Tim Burton to watch his back? Now, he wasn't right. It turns out now we know there wasn't a shooter or shooters roaming the parking lot. But in real time, that's what he believed. So easy after the fact, when you know what that monster did and where he was, to say, oh, you should have done this, should have done that. In real time, the things that he's saying matter. And Tim Burton stays for 20 to 30 minutes watching my client, and he never goes into the 1200 building. Never went in. Next was Stacy Lapel. Again, this is all in the state's case. State's case. Where's the admission where my client says, I knew it, and you know what? I just didn't feel like going in. But did you know that there were kids that were going to be harmed? Sure. But I got 1 foot out of retirement. I'm 1 step away. I'm not going to do anything. That's a different set of facts. None of that happened. Let's keep going with their witnesses. Stacy Lapel, she was a teacher on the 3rd floor of the 1200 building. She's there inside the hot zone of the hot zone. She said, quote, the sounds that she heard that were ultimately gunfire, the sounds that she heard, it sounded like, quote, it was coming from outside. Where specifically, I asked? Somewhere between the 700 and 1200 building. This is an honest teacher credible beyond all measure, who's inside the building where the shots are ringing out on the first floor, second floor. And she's thinking that these shots are coming from outside of the 1200 building. This whole hearing-based prosecution is flawed and offensive, quite frankly. Next one. Coral Springs detective Brett Schroer. He made contact with Scott at 2:41. So the shooting stopped about 2:27:35. And then we're talking now some 15 minutes later or so, 14 to 15 minutes later. He said Scott was on his school radio and relaying intelligence, information of the shooter's location from Morford. That's what he's seeing. So the suggestion that he's doing nothing in real time, which wasn't even mentioned in their closing argument, he's actively trying to get information. If there's no more real-time intelligence, there's no blood, there's no windows with bullets that he can see, there's none of the things that Samaru suggested he should look for. He's now turning to his school radio and BSO radio, hoping at any given moment BSO is going to tell him where to go. He gets nothing from that radio. And he's on the school radio trying to assist. What we learned was 10 to 15 officers standing around waiting for his next word, who are standing either by the 1200 building or right there by the 700 building, just waiting for Scott to say, okay, the shooter's here. More importantly, he never gives any of the intelligence that he has, the information he has, to Scott. I'm not blaming him. All the Coral Springs officers, I think, erroneously thought that BSO's radios were patched or that they just knew the information somehow. Next one. Danny Polo. Who is this guy? Miguel Suarez. Yeah, I barely recognized him because I didn't ask him any questions. He was a BSO crime scene detective. He took photos of bullet-riddled windows. You know what? There is this. I didn't ask him questions, but there is some significance. If it was he or one of the other crime scene technicians, but we did learn that, for example, Judge, if I can have this on, I will turn this off for 1 moment. That monster was shooting at windows. And this classroom in particular, 1234, out that window, if you keep going, you can look at the chart, it would head right in Scott's direction. You'll be able to look at it when you take the evidence back. So if Scott is thinking, they might be firing at me like most of the witnesses thought potentially, again, it's supported by Miguel Suarez and other crime scene technicians' testimony that bullets are hitting windows. I mean, that corroborates the sound evidence that my client's hearing. And so the next one is Danny Polo, aka the Masked Ninja. He responded way after the shots were fired. He heard from 2 deputies on Holmberg Road. We don't know which deputies those were, but he knew from speaking to them that the shooting took place in the 1200 building. Okay, great. So you knew something my client didn't know. And so he went in there and went to save lives. Great. Had my client had that information, he would have been right by your side, Danny. Next one was BSO crime scene technician Danny Kristen. Had no questions for him. He processed the first floor hallway, shell casings. Scott wasn't even there when all those shots were fired. No value. Next one is BSO crime scene technician or Detective Gloria Crespo. She collected 61 shell casings. She took pictures. She also was an SRO. See how they tried to get her, talk about how she, did acts that could make her like a caregiver, which we'll talk about, which is preposterous, but there's no value to that.
and certainly nothing to suggest that my client knew that the shots were coming from the 1200 building through her testimony. So far we keep going. The reason why I put everyone's picture in here and I'm going through their testimony is to remind you that at no time so far should you have an abiding conviction of guilt that this gentleman knew that there are shots coming from inside the building and that children, that adults are being killed. He didn't know that. So let's keep going. Edmund DeRosa, Carl Springs captain. He arrived next to Peterson with 2 other officers at 2:41. That was long after Cruz was gone, but nobody knew that. When I say nobody, no one like my client and BSO officers. They all thought, well after the shooter left, that our shooter or shooters still on campus. He's told us that he assumed that the radios were patched. He claimed that he missed the radio transmission about 3 victims down in the 1216, classroom 1216. He did tell us it was extremely stressful. And here's a captain, okay? He didn't know where the shooter was, he said. He took cover behind a concrete pillar. Why do you do that? Because that's how we're trained. This is a captain telling you he did exactly what my client did. A concrete pillar. He said, quote, Scott seemed frustrated and stressed like everyone else. He said he never shared any of the real-time intelligence. He was concerned in the moment, even as he's hiding behind the concrete pillar, that he could be shot at any moment. And he said that my client announced that we're dealing with a 1200 building or somewhere on campus, which is consistently what my client's real-time intelligence was. 1200 building or somewhere else on campus. Next one was the medical examiner, Dr. Marlon Osborne. I had no questions for him, but even as the state tried to suggest, with these people who had passed, well, they lived for, a longer period of time. So if my client somehow in 1 minute and 6 seconds could know where to go, he could have gotten in there and saved somebody. Remember the testimony, first of all, we first learned it, and I forget which witness it was, will come to me, who said, I don't mean to be crass, but when you go into the building, you're actually stepping over bodies. Because your primary object, your goal, is to get to the shooter. So this notion that somehow my client would have saved anyone's life if he somehow could have figured out where to go is without merit. But his testimony was that, unfortunately, Jamie Guttenberg didn't survive very long. Next one was Dr. Boyko, medical examiner. I had no questions for him. He doesn't assist at all with this case on the issue that we're talking about. Oh boy, here we go. Here we go, folks. BSO Lieutenant Colonel Samuel Samaru. He somehow came in here and said Scott didn't follow training. But then when I pressured him on cross, well, hold on. I never went to the scene. I never spoke with your client. I never spoke with really anybody. And his training, the things that he does, has nothing to do with what occurred that day. But your client somehow violated training. Lieutenant Colonel, like they brought it out, like up there at the top. What we learned was that he was not being honest and straightforward. Remember the softball question I asked him? I mean, all of our witnesses and most witnesses said, yeah, if your client is repeatedly trying to lock down, get the school locked down, gentlemen. He's constantly locking down the school. Most reasonable people understand that you want the school locked down because school is letting out for the day. Parents and students and siblings of students and friends are going to flood onto the campus. My client doesn't want any of those people on the campus. Why else would he be doing that other than to save lives? Samaru just couldn't admit the value to that. His keeping students and siblings and parents away helped save lives. We know that Cruz was shooting for 2 minutes out the teacher's lounge. And if there's more people on campus, there are more deaths.
It's black and white. In hindsight, if he knew that there was a shooter inside the 1200 building, he may have said, okay, let's lock it down, keep parents, kids out, but everybody storm the 1200 building. That's what he would have said if he knew it. He didn't know in real time. So him locking down the school helped prevent parents from coming on. In fact, it was Burton who said it was eerie. It was like a ghost town. Thank you, Scot Peterson. Thank you. Because remember how the shooter looked? He wasn't a big bad monster dressed like something unusual. He blended in. So the last thing you wanted were more students, more siblings of students coming on to the school, either on the football field or in the parking lot, wandering around so that you can't figure out who's a shooter and who's a student and who's a parent. But Samaru couldn't admit that to you folks. He couldn't do it. Very disturbing. What's his vested interest? He's the training guy. And what we learned was his training had almost little to do with what they were going through that day. We learned from Deputy Perry that most of his trainings didn't last more than 5 minutes, and that they were all contained within a building, typically even on a floor of a building, where there's tape up, and everybody knows the shooter's there somewhere. You just have to find him in the few little corridor areas or the couple of rooms. That's not what they experienced here. Not one single witness testified that we were talking about, in our training, multiple football fields in either direction as to where the shooter or shooters may be located. To this minute, we all are still unclear on what you're supposed to do. If you listen to Samaru, remember what he said? Well, if your client thought it might have been the 1300 building, which we know that he did, because it's right there in his recording, then, well, he should have started there. Really? Well, let's play that out for a second. My client goes from the 700 building and then starts to run football fields away to the 1300 building. Now, I'm going to say this with love. He was in definitely decent shape.
Objection, Judge. None of those facts are in
Yeah, that's sustained. Go ahead, sir.
You can consider his age, which the prosecutor told you what it was, and you could consider what it would be like for him to start running to the 1300 building. But let's say he did that. So I asked Samaru, should he start with going to the top because he thinks maybe there might be somebody up there shooting? Does he start on the third floor? Does he start on the first floor? Does he start on the east side of the 13th floor? Does he west side? Does he go to the north? It's preposterous, like literally looking for a needle in a haystack. But Samaru said, you start on the first floor. Okay, let's play that out for a second. So he runs all the way there, and meanwhile, let's say he gets there, and now the shooter or shooters that he's concerned about in the parking lot jump up. Remember, he told Burton, watch your back. And they start shooting people. Even Remy talked about how she didn't feel safe in the 700 building because she thought people might come into her classroom. So let's say that happened. Now he's out of position. He's all the way down in the 1300 building, eagerly waiting for someone to give him some real-time intelligence. But no, he left his position. He's running, even though there could be fire coming from any direction. He could be dead at any given moment because he has no idea where the shooters are located. He's supposed to go to the 1300 building. Now he's completely out of play. People are dead, and they say, why did you leave your position of cover? You should have waited for real-time intelligence. He was damned no matter what. He couldn't win. Facts don't matter when you're sacrificed. To Samaru, to suggest with a straight face he should have just run to the 1300 building? Preposterous. Next witness was Dr. Terrell Tops, medical examiner. No value to the issue at hand. And next was Kelvin Greenleaf. He's the one who told us that Andrew Medina said nothing to either one of them. And that could have changed everything. Just tell us that you know that Cruz went into that building and started shooting. Just tell us. Greenleaf was
extremely upset, rightfully so. He only heard 4 to 5 shots, not 70. He heard 4 to 5. That's it. Most people heard very few shots. He thought it was a 1200 building. He thought it was a 1200 building, but he said he never shared that with Scott. He said that it was a very long process when he went to the video room. Long. In fact, Morford said it wasn't 5 to 10 minutes. It was much longer than that. It was a long process. He also said that he saw Scott scanning back and forth, looking left and right to try to find where the shooter or shooters were located. Here's another person, just like Stobley, who said that it looked to them as they're standing there like my client was looking and scanning and trying to find out in real time where the shooter or shooters are located. You know, the very thing that they're claiming he wasn't doing. He didn't try to seek out. He didn't do anything. And his exact words, ladies and gentlemen, hopefully you wrote this down. Let me remind you what he said. His exact words, quote, I don't think, regarding where the shooter or shooters were located, he said, quote, I don't think Peterson knew what was going on. Because he didn't. Because they failed him. They didn't give him the real-time intelligence. He couldn't tell from the sounds. There was nothing that he could see visually. Carl Springs never shared the real-time intelligence. But to him, we get out of their state witness, he didn't know what was going on. He didn't know. Former campus monitor Elliot Bonner, he saw Feist down on the west side, something my client couldn't see. On direct, he said he thought it was coming from the 1200 building. Then on cross, remember? I think it was around the 1200 building. And then again, his final word when confronted with his statement was, I'm not sure. But he never tried to call Peterson and give him any real-time intelligence. Would have been helpful to my client to know that somebody was shot. Anybody. He doesn't know at that point. Feist is down. They know it. My client doesn't. Next witness by Zoom, Dr. Wendolyn Sneed, a medical examiner. She offered nothing on the issue. Next one, Dr. Rebecca McDougall. No questions. Talked about Scott Beagle and Kara Logren's death. They tried to suggest through the questioning, well, how long did they survive? No, it was a quick, rapid death, unfortunately. So again, nobody could have saved them. Next witness was Sunrise Lieutenant Craig Cardinal. He first arrives and he sees BSO officers in a position of cover who's saying, don't go in that building because he was shooting from that building. Interesting who they talked to know it was that building. But apparently there are deputies who know that information and are telling them that. My client, there's no evidence that he knows that information. Now, he went in because his son was there, whole different level. And he also is from he's from Sunrise. And he had information that my client did not. He said that he saw my client and how he was acting. Oh my gosh, there was genuine concern, genuine dismay, because they were bringing out for the first time bodies from the building. And that my client was freaking out. A normal human response to that. His kids have been shot. And their final witness, we're at the final witness. At no point did they prove this case beyond a reasonable doubt. We're at the final witness who only raised more reasonable doubts. He's the lead detective in the Cruz case. He discussed the role of the lead detective. He kept referring to Keith Riddick. Every time I asked him, well, who did this? Who did that? Keith Riddick. Why? Because Keith Riddick is the lead detective in this case. When he arrived to the scene, he had, quote, no idea what was going on in the school. He said, I tried to get intelligence. He helped us with the times to make sure that Vice was shot at 2:23:25, that Scott announces immediately at 2:23:26, 1 second later, which caused all the cops to come. If it wasn't for my client immediately announcing at 2:23:26, all the response from at least BSO would not have happened. Thank you for doing that, Scott. And in his statement, they charged him with perjury. Perjury. Based upon this, Judge, if I can get the element. By the way, I'm talking about perjury, but I'm looking right up above too. This is important. This is not an interview that my client thinks will ever result ever with him being charged criminally or even under investigation. They just brought him in because, hey, you were a witness. We need to, it's not a debriefing either. That's a separate thing. He says debriefing would be very detailed. And what's the next thing? What's the next thing? What's the next thing? We want to know everything, everything. This is just some questions. But even in that, he says that he heard shots. Question, okay, could you tell what floor it was coming from? I thought it was outside. It was so loud. All right. And so close. I thought it was probably outside. I didn't even think it was even inside the building because it was so clear and loud. This mirrors what every witness that we called to the stand said. It was so clear and loud. Nobody thought it was inside, except for a few random people that we've already mentioned. I knew it was close to this building, but I wasn't even sure if it was in the building. Was it outside the building? But I knew it was close. And by the way, remember he said that he did this interview in a chronological order, okay? So, and what happened next, right? We got a little bit of that. So, next line over here, we're getting to the one where it said, okay, all right. When you get closer and you hear those, this is the perjury count right here. It's the only time he asks him about shots. Remember? I said, you ever ask him, how many total shots did you hear from beginning to end? Nope, never asked that. Didn't you think that that was going to be the money shot? Meaning the right question to ask if you're going to charge him with intentionally lowering the number of shots? And by the way, my client does say, first he says up here that there could be firecrackers. I think we have shots fired. And then again he reports that there are shots fired. Here, right here. At 2:26:40, he again says, I hear shots fired, shots fired. So he's hearing additional shots fired. He's reporting it here. He knows this is recorded. Why would he tell an officer he only heard the initial shots when it's right here recorded? It's because the cop is asking me about, as you get close to the building, how many shots did you hear? This is the question. Okay, all right. Once you get closer and you hear those guys, what are you talking about? Remember he said, I don't know. It should be on some recording somewhere. Okay, well, here you are sitting. I'm giving my closing argument. We still don't even know what he's talking about. So either he's talking about some guys, or it's some mistake in the transcript. So you then are being asked by the state, who didn't clarify what that means when I raised it, to rely upon a transcript that's not even accurate to convict my client of perjury. But look at the context. All right, okay, once you get closer, so he's setting it up. Once you get closer, he's referring closer to the building. Once you get closer and you hear those guys, whatever that means, how many rounds do you think you heard? And he says, it wasn't many, 2 or 3. He's dead on accurate because Aaron Feist, which is the first shots he hears, was shot twice. And what's left out of the charging document is this next line. Okay, all right, what happens from there? I stop immediately, right on my BSO radio, shots fired, shots fired. Does that not make it clear the context in which he's asking these questions? It's crystal clear. If we can see it, how come they can't see it? And then the other one was about not seeing kids come out of the building. First of all, who are these 5 kids? There's been no testimony that ever these 5 kids ran towards my client. There's a big pillar and a big metal fence. He definitely would have missed them. In that moment, at 2:23:55, he's worried about kids getting into the building. He's on both radios. He's hearing what could be possibly shots fired. Greenleaf sees the kids. My client doesn't. So what? What is he? Why would he lie about that? In a situation when there wasn't the chance that he was going to get arrested or even questioned. It makes no sense that perjury count is consistent with meritless charges being brought against my client. So that was the state's case. That's it. That's it. That's it. Where is the proof beyond a reasonable doubt that my client, who's still asking at 2:29, still wondering, Perry, does he know where the shooter is? And still at 2:45, between the 12 and 1300 building is the last time we heard shots. It's right there. It's there. It's clear as day. So we didn't have to call any witnesses. And it would have been really, really strong if I just said, you know what, Scott? Even though we have all these defense witnesses, let's not call anyone. They didn't meet their burden. They didn't prove this case. And at the risk of you thinking that somehow we have any burden at all, we decided to put on witnesses. And now you know why. We needed to call those witnesses so you learned about the pronounced echo and all the kids and adults, faculty, staff, teachers who did not know where the shots were coming from. Let's review that. I mean, none of those witnesses were addressed by the prosecutor in her closing. I'm assuming that my zealous advocate, who I admire, will come up here and say something about it. I guess she did say, why would...
Yeah, Mr. Igosh, that's sustained. Let's not talk about the lawyers. Let's talk about the facts, evidence, and testimony in the case. Go ahead, sir.
The prosecutor said to you, why would they call kids to relive a disturbing experience? Well, because they're accusing my client of knowing where the shots are coming from. That's pretty relevant. Pretty relevant. You would want to hear from kids. Having kids come in and relive a horrible experience and talk about injury when we're conceding and saying that's not even an issue, well, it cuts both ways. So here's the defense case. And every defense witness was beyond reproach. Everybody was credible.
Objection, Judge Counsel is vouching.
Yeah, that's sustained.
You all can determine. There were no conflicts in their testimony. You looked at them in the eyes, and we started with Melanie Hertzfeld. What was interesting was she testified in the state's case because we had to accommodate her. So before they even rested their case, you started to learn, wait a second, it's not as clear as they're suggesting. Melanie Hertzfeld, whose classroom is literally facing the 1200 building on the first floor, she hears shots fired. And she thought they were fireworks, and she said those sounds are coming from the football field. From the football field. She's in building 700, and she's hearing shots fired from the football field outside. If that was the only witness we put forward saying that, you would immediately say, yeah, how can they rely upon a sound-based prosecution under those circumstances? But there was more, as you heard. Anna Ramos, he ordered the code red. Do you guys understand the significance of that? How in real time, he doesn't just order the shots. Hey, shots fired. He goes to a school radio, standing out there for an additional 18 seconds without his vest, further jeopardizing his life to ensure that these kids are locked down. That's uncontroverted. He didn't neglect these kids. He made them his priority. Michael Kratz, Deputy Michael Kratz, 36 years in law enforcement. He heard Scott announce possible shots fired. That's why he came to the scene. And when he got to the scene, he heard 4 to 5 gunshots. He was so convinced that the shots were coming from the football field that he gets on his BSO radio to let everybody know, shots fired at the football field. When he makes that announcement, what's key is Cruz had not even begun his sniper firing out of the teacher's lounge on the west side. He was in the middle of the hallway of the 3rd floor, still contained in the building. Yet he thought, as he's by the football field, that the shots were coming from the football field and that the shooter or shooters were literally 30 to 40 feet in front of him. How do you reconcile that? Cops aren't trained, by the way, in having some special ability to know where shots are coming from. When they leave the mall and they're not sure exactly where they parked their car and they hit their alarm, they can't more quickly get to their vehicle faster than any of us non-police officers. They don't train them for that. And in this instance, he believed the shots were coming from the football field and put it out over the radio. So imagine that, when my client's trying to figure out in real time, okay, wait, I think it's 1200 building, maybe 1300 building, maybe parking lot, and all of a sudden he's hearing on his BSO radio, shots fired from the football field. Wait, shots fired. Oh, wait. Are there more shooters? Did the shooter leave? Are there others? He's trying to figure all this out in real time. And in response, he's saying, all right, 26, referring to Kratz's announcement, also heard it, it's over by inside the 1200 building. Not inside the 1200 building like the prosecutor kept saying. By inside the 1200 building. By, both are on his mind. By, exactly what Burton thought, by the parking lot area, all the areas around that, including the 1300 building, or inside. All that's in play. And yes, if we could turn back the clock, if he could turn back the clock, he would have picked a place, and maybe he gets lucky and he goes into the 1200 building, and we're not here. But you can't go back and prosecute him for what we know now. Kratz, like all the officers, took the time to get his vest, to get his rifle. He said his radio was staticky and not working properly. He was also worried about sniper fire. He wasn't the only one considering it. And no one who was worried about sniper fire is trained to get on the radio. By the way, I'm worried about sniper fire. Oh, and I'm also worried about 15 other things. This isn't therapy. You don't give your thoughts about what you're thinking so that somehow you could use it in your defense when you're prosecuted years later. It doesn't work that way. He took a position of cover behind a car, just like my client did, took a position of cover. And he saw Coral Springs officers taking positions of cover. You know, the officers who had all that real-time intelligence, they were taking cover too. Next witness was Lieutenant Michael DeVita. He knew Scott for 10 years as an excellent award-winning officer. He's the one who testified that within 2 years, in 2016, so 2 years before this happened, he won Deputy of the Year in Parkland. The year before that, he was School Resource Officer of the Year. So from all that, even though he jumped in the middle of fights with kids to break it up without backup, we heard all about that. He investigated, he had more arrests than anybody, we heard that. This guy was active, involved, courageous, heroic, and all of a sudden, what, he turns into a coward? Doesn't care about kids anymore? That's their theory. But he said that the radios weren't working due to throttling. He responded with Captain Jan Jordan, and that DeVita complained to supervisors about the radios for quite some time, and they did nothing. Nothing. My client didn't pick the radios that he had to use. And understand the radios would have then afforded him the opportunity to get some extra information to come in that he wasn't getting.
You heard about officers having real-time intelligence, like, oh, I see bullet holes here on the west side. You know, my client's on the east side, so we can't see that. People trying to key up, and they couldn't get that information out to them. They couldn't get out that Aaron Feist was down. You look, and that nowhere on his transcription through dispatch do you see that coming to Scott. He said he had no idea where the shooters were. He also believed in the +1 rule, that if you think that there's one shooter, assume that there's two. If you think there's five, think that there might be six. They didn't know. He didn't know. He saw Scott on his school radio diligently trying to obtain information from Morford. He wasn't passive. He's actively trying to get that real-time intelligence. And he's the one, by the way, who said there were 12 to 15 people by the 700 building and the 1200 building waiting for my client to give them the real-time intelligence that he's getting over a school radio. He was the guy. That was his job. We're supposed to stop and abandon Morford at any moment. He didn't know it's going to take 30 minutes. He thinks at any moment they're going to be able to look, rewind the tape, boom, there's a shooter. He tells them, and everybody knows to go. But another failed scenario, another set of facts that didn't bode well for Scott. He didn't get that information, and it was through no fault of his. And worse, it was old information because they didn't rewind it properly. Oh, wait, I got to bring up one thing. During his cross-examination, it was my friend, Mr. Killoran, who questioned him. Well, why didn't he go to the video room? He brought that up, that my client should have somehow, if the radios weren't working properly, he should have left the hot zone, which would have been ideal, because now he's no longer worried about sniper firing, people wandering around with guns, God knows what. He should go run a football field or two away to the 100 building, wait for about a half hour, find out, where the shooter's located, and then run all the way back like an American ninja, all the way to the 700-800 corridor to then relay information. That suggestion is ridiculous. He stayed in the hot zone, to his credit, to try to relay the information that he was getting in real time from Jeffrey Morford. Suzanne Campbell, the first of several teachers who testified, or one of several teachers testified. She was inside the 700 building. She heard loud noise pops. She thought that fireworks were being thrown at us, the first of many people who talked about how they believed this was very personal, that it was coming at them. She said she thought the building was going to collapse. Not there's shots coming from inside the 1200 building, but she thought the building was going to collapse. Her building. She said it was so loud and echoey, it was bouncing off the buildings. One thing you can relate to, I was trying to come up with a metaphor, like what would this be like? And this is a good example, I think. Hopefully it resonates. You're allowed to use your common sense and life experiences, okay? You're driving along and you hear a siren. You know you're supposed to take action, but you don't know where the siren's coming from.
Yeah, that's his thing.
If a person's driving along and they hear a siren, and that person doesn't know where the siren's coming from, you think, well, you know what, my hunch is that it's going to be up there in the intersection. Or, oh no, it's behind me. Okay, now, that's the thing with sounds, loud sounds. But now you add an echo, like Susan Campbell talked about, and it's impossible. Next witness. And these are defense witnesses. Imagine if we just rested our case. You never would have heard this information. But we chose to call these witnesses. And Tyler Jabot was extraordinary. He was an 11th grader in the 700 building. He evacuated. And he saw Scott looking, quote, towards the football field. Another person who sees my client looking west, corroborating that Deputy Kratz, who had said football field. And he said he heard 3 to 4 shots. They could have been firecrackers. He was about 30 to 40 feet from Scott when he heard the shots. Think of how close he is. He said he didn't know where the shots were coming from. He thought it was from the west side stairwell of the 700 building. He thought from that direction. And then when questioned, he said, well, I also thought it could have been from the senior parking lot. I mean, all over the place. He didn't know.
He said it echoes quite a bit due to the concrete. Assistant Principal Jeffrey Morford. He heard Scott order a code red. I asked Curcio, I think it was Curcio and a few others, how many people had school radios? How many? 30, 40, 50, 60? Who had a school radio? How many of those people heard Scott order a code red? So that's not even an issue. I'll leave it as a question mark because we don't know. Lack of evidence. It would be great if we had that information. And then that's not in dispute. But he heard Scott order the code red for the benefit of the children, including, but not limited to, the very ones he's accused of neglecting. He said that it's not uncommon to miss announcements or transmissions on the school radio. He also said that he heard Max Rosario. Give me 1 second, Mr. Speaker. How much time do I have?
10 minutes.
Okay. I'm going to have to rush through this, okay? Jeffrey Morford. Judge, can I have additional time? Pause for some time? I just need.
You may not.
Okay.
Go ahead.
Well, I'm going to have to talk quickly then, folks, okay? Jeffrey Morford. He was in there for a long time in that room. My client was diligent in trying to get the information out. There was no hesitation in what he was doing. Melanie Weber was in the 11th grade, Hertzfield's class. She heard gunshots. She thought they were firecrackers, echoing and reverberating. Sounds were coming from the soccer field, which we later known as also learned is the football field. She also thought it was all the way over there. She didn't even hear Kratz's announcement over the radio and thought they were coming from the soccer field, the football field. And then on redirect, she said sounds were coming from everywhere. Everywhere. Brian Miller, 36 years with the SO. He responded because of Scott's transmissions. He heard several shots, thought they were coming from the football field, reverberating. Deputy Kratz, he heard the announcement, the radios malfunctioned. He said that he was never debriefed, and that brought up the issue of Colonel Poland, the highest ranking person on the scene, never debriefed him, others, my client, even though the active shooter policy that we put into evidence says that that shall be done in a timely manner. It was never done. Maximo Rosario, he was 30 feet from the 1200 building. He was even closer than Scott, who was 75 feet, according to Curcio. He heard 5 to 6 shots, thought it was firecrackers, although he's familiar with gunfire because he owns a permit. He couldn't tell where the shots were coming from. The senior lot is huge, 500 cars. And he saw Scott in a position of cover on his radio doing something. Ruby Harris, she thought that the shots were coming from, she was between the 7 and 1200 building, right there, somewhere in the senior lot. Somewhere in the senior lot. Coincidentally, her sister, who has the same DNA, who was in the same area, who was on the grass, right there with her, she heard the shots and thought it was at the football field. 2 women who live in the same house, right on the same grass, thought it was in 2 completely different places. Sergeant Goolsby, that was Perry Harris, Sergeant Goolsby, he heard shots. He thought they could be on the west of the football field, ground level between the 12 and 1300 building. He got no intel. He was never debriefed. He never knew the kids were shot in that building. Got to keep rushing. Cindy Helverson, huge echo in that area. She couldn't tell whether it was inside or outside. By the way, none of these witnesses ever said that they thought the shots were coming from inside the 1200. None.
That objection is overruled. Again, ladies and gentlemen, you all will decide what the facts of the case are.
Not
Go ahead.
one of these defense witnesses ever told you that they thought the shots were coming from inside that building. Again, Cindy Helverson, she couldn't narrow it down. She definitely didn't think the shots were coming from inside. Dylan Redshaw, she thought it was a bomb. She said the sound was all around me, that she immediately turned towards the football field. Angela Mize, she talked about how offensive it was that these systems weren't patched. They should have been patched. Rennie was great because
she had a student come back and say that he had heard shots, not shots, but firecrackers inside the 1200 building. And so she has that information, just like my client does, firecrackers in the 1200 building. But when she hears the shots, she doesn't think they're coming from inside. She immediately thinks that, and here's Scott, you know, get back, by the way. She thinks that it was coming from the grassy area between the 700 and the 1200 building. Josh Stoneman. He thought it was anywhere in front of him. He was at the north side of the campus, anywhere. This is a 45-acre campus. Anywhere. He couldn't narrow it down. Samantha Oakley said she was ready, willing, and able to patch the radios. All she needed was either Coral Springs or someone from BSO, her own agency, to say, go ahead and do it. Boop, boop, boop. Takes 3 seconds. Nothing. Nobody asked her to do it. And Alexander Wind, he said he thought that he was 30 feet from the building. He thought that a bomb was exploding in the area. He never thought it was in the 1200 building. He said there's a huge echo in that area. Arthur Perry, the final witness, who the state cross-examined and made him look like he did something wrong when he was just so close to that building. Remember that photo? It's in evidence. I don't have time to pull it up. My plan was to show you. He's in a position of cover with Captain Jan Jordan. The 1200 building's right there. He sees kids coming out of the building. He sees Fife's body on the floor. He sees bullet holes. He sees people going in, and he still told you why he didn't think it had anything to do with the 1200 building. You know when he learned it was the 1200 building and the kids were injured in there? 7 p.m. that night when he had left the scene and he was watching Fox News. That's when he learned. And my client's supposed to know that when he's on the scene. Ladies and gentlemen, I'm virtually out of time. This notion of him being a caregiver is ludicrous. He's supposed to read Miranda to kids as a law enforcement officer and then say, by the way, don't answer that question because I'm your caregiver. This could affect you in the future. He's not a caregiver. He's a police officer, and he's assigned to the school pursuant to that contract, but he is not there to make sure that their bellies are full and that they are hydrated properly. That idea is ludicrous. Now you're going to see the charging document and understand that when you have your the options, that not guilty is the only way to go in this case. And what not guilty means is not proven. You didn't prove this case beyond and to the exclusion of every reasonable doubt. The burden of proof is on the state, and if you think, well, maybe he knew where the shots were coming from, or possibly, or probably, or it's highly likely. The only time you ever find anyone guilty is when they prove the case beyond and to the exclusion of every reasonable doubt. That's why I tell you that your decision is very easy. This is a 5-minute not guilty. You do not owe anybody, again, you can take as long as you want, but you do not owe anybody any extra time in that room. You sit there and say, they never proved their case. Not guilty hopefully means that you believe he's innocent, but it also just means not proven. Ladies and gentlemen, I conclude by telling you that this is the most difficult time because the prosecutor gets up here and he's going to tell you things. Just ask yourself what I would say in response and use your own common sense. Understand that sympathy plays no role. Understand this is a very easy decision and we're all counting on you to make a wise and legal decision. And I also want you to remember the victims. Just remember them. Understand that Nicholas Cruz is the one responsible and that we do not do justice for the victims by doing an injustice against Scot Peterson.
Yeah, that's sustained. That is
Ladies
an
and gentlemen.
inappropriate remark, sir. Yeah, that request is granted. Ladies and gentlemen, I want you to completely disregard the last sentence that the attorney just said to you. Go ahead, sir, your final word.
I will conclude by telling you that the case is now in your hands, and every minute that this is open without a not guilty verdict is a miscarriage of justice. You know what the evidence is. You know what it's not. And the only verdict that speaks the truth in this case, and I've got to address, oh my goodness, him not testifying. You all promised you wouldn't hold it against him. One scenario was if they rested their case and they didn't prove it, you wouldn't hold it against him. We're counting on you. Wanting to hear from him, you can talk to him if you want, anytime after this case, but needing to hear from him, you all said you wouldn't hold it against him, and he could take advice from an attorney, and if they didn't meet their burden, he wouldn't need to take that stand. We saw
what that pit bull prosecutor did with Perry. Nobody should have to go through that. No one. The only verdict that speaks justice in this case, ladies and gentlemen, is not guilty on every single count, because he truly is innocent and did everything he could that day. On behalf of Scott, I thank all of you. Thank you.
Oh God, that's over. It was good, but Jesus, it's a long period. 2 hours is just too long, I think. And not just in this case, but in any case. Jesus. They've still got an hour left. So imagine they're taking a break now.
Until we reach the end of the trial, we're almost there. If you leave those notepads in the chairs, they'll be waiting for you when you come back. I will see you at the jury room at 2:15. 2:15 at the jury room. Have a nice lunch.
Okay, so they're going for lunch now. What's that? 2:52. What's 2:15? That was a lot, Shelley. I don't mind it, don't get me wrong, but we've still got another hour left now. We've got that guy for an hour now. Do you know what I mean? It's a bit like, oh, come on. We don't need all this for all that. But I mean that for both sides now, not just the prosecution. I mean that both sides. It should have been capped. Like hour and a half max total. Just my opinion. I can take that off. So 2:15, so that's. Oh shit, hang on.
But quite candidly, I think the case law says in making these types of determinations, I'm supposed to determine whether I thought you used your time wisely or not. So
Okay,
I'm not inclined to give you any more time.
Judge, I didn't get a chance to pull up, which I have here, the jury instructions and go through.
So that was, you knew how much time you had, sir. You used every minute of the 2 hours, plus I gave you some additional time because of the technical difficulties, how you chose to use your allotted time. That's in your purview, sir, but just because you didn't use it in a efficient manner, I guess now, doesn't require me to give you more time, and I'm not gonna give you more time.
Okay, so I'll need at some point access to the records now to say.
No, it's not now, sir. I need to send everyone a letter. It will probably be after the jury's instructed and the jury's deliberating. I'll give you access to the record, you can proffer whatever you like. Okay? Anything else?
Does the court want to hear first what it is in terms of making the court's decision?
Mr. Aguilar, I just listened to you for 2 hours and you didn't talk about the elements of the case. You've asked the jury to make a decision that they're not even going to be asked to make. Just my opinion, sir, but I'm supposed to decide whether you used your time wisely or not. I feel that you did not. So no, sir, I'm not going to. Not at
Okay,
this
so I'll
point.
proffer later what I
Yep.
was going to get to. Thank you.
After the jury's deliberating. Okay, so we'll be in recess till 2:15. I hope everyone has a nice lunch. See you then.
Is it actually 2 hours and 20? That was quite testy, wasn't it? Well, hang on, let's watch that again. We missed a bit of that. Let's watch that
I'll be
again.
waiting for you when you come back. I will see you at the jury room at 2:15. 2:15 at the jury room. Have a nice lunch.
Got my lunch dinner here. I'm not eating dinner at the same time, so excuse me.
Okay, we're
Let's
outside the
listen to
presence
it.
of the jury. State anything you need me to address before the lunch break? Defense, anything you need me to address before the lunch break?
Yes, sir.
Yes, sir.
I'm requesting additional time. I want to proffer to the court what is in my slideshow that I did not get to discuss. If-
Sir, I'll let you do that after the lunch break. I'll let you proffer whatever you want. But how much additional time are you requesting?
20 minutes.
20 minutes. Okay, state your position on that request. I mean, Mr. Agarsh, I'll let you proffer whatever you want, but quite candidly, I think the case law says in making these types of determinations, I'm supposed to determine whether I thought you used your time wisely or not. So
Okay.
I'm not inclined to give you any more time.
Because I didn't get a chance to pull up, which I have here, the jury instructions and go through.
So that was, you knew how much time you had, sir. You used every minute of the 2 hours, plus I gave you some additional time because of the technical difficulties, how you chose to use your allotted time. That's in your purview, sir, but just because you didn't use it in an efficient manner, I guess now, doesn't require me to give you more time, and I'm not going to give you more time.
Okay, so I'll need at some point access to the records now to say.
No, it's not now, sir. I need to send everyone a
But
letter. It will probably be after the jury's instructed and the jury's deliberating. I'll give you access to the record. You can proffer whatever you like. Okay? Anything else?
Does the court want to hear first what it is in terms of making the court's decision?
Mr. Aguilar, I just listened to you for 2 hours and you didn't talk about the elements of the case. You've asked the jury to make a decision that they're not even going to be asked to make. Just my opinion, sir, but I'm supposed to decide whether you used your time wisely or not. I feel that you did not. So no, sir, I'm not going to. Not at
Okay,
this
so I'll
point.
proffer later when I.
Yep.
see what's gonna get to. Thank you.
After the jury's deliberating. Okay, so we'll be in recess till 2:15. I hope everyone has a nice lunch. See you then.
I was just saying, Dave, you're a plonker. No, I'm joking. I can't believe I was muted. What a prick I am. So I was just saying, you said 2 hours 20. Shelley said it's 1 o'clock. So then that means it was an hour 20 to go. But now there's 2 time zones, so he could be right. So we can't hear you. Well, you fucking can now, Mad World. Sweet. What a dick I am, though. I didn't want to. I muted myself because I was eating. What plonker? Hang on. I kept saying, go, pack, go. Go, pack, go. Right. We have 1 hour left. So I presume it's an hour and a quarter for lunch because I don't think I'm going to do 2 and a quarter. You're up lunch for you. This is dinner for me. It's 18:02 here in the UK. Get on back on mute for fuck's sake. I can't even fucking win yet. Cheeky bitch. I know, small bus. Oh, um, what do I do now then? Because I'm here, but I do want to finish eating my lunch, but I'm not going to go anywhere, so I'm going to be here. Like, so it'll take me a couple of minutes to eat it. That's all. So, no, I swallowed it. You, Dave. Don't start now. Don't start now. I'm trying to entertain Dave. Come on, Dave. You're going to turn me into a Bears fan if you don't. Don't start behaving, Dave. So, are we doing? What are we doing, boss? Are we doing um an episode of Depp then tonight? Mad World, are we? Spidey, are you available if we do it? Where's Spidey? Spidey, are you here? Okay, okie dokie, okie dokie dokie. So we've got 1 more hour. Well, we've got 2 more hours to go. They'll be back in an hour, and then the state to go an hour. Do you know what? I don't. Let's have a look. Where's Spider Girl gone? Spider Girl, where are you? Don't be shy. Um. Right. Let me just see now where I am here. Oh, excuse me. Rumba. Let me go my playlist to see. Ba-da-rumba. Ba-ba-rumba. Ba-ba-ba. Ba-da-ba. Ba-da-ba-ba-ba-ba-ba. Where is Spider Girl? Here she is, here she is. Spider Girl. Spider Girl. Right, here we are. Let's view. What the is this? What? Oh wow. Spider Girl, that you're a genius. I was just thinking about Amy now. Where's Amy? I don't know where Amy is. I was thinking, where is she? Because she's never misses this trial, but she's not here today, and it's not like her to miss this day. So Spider Girl has, I don't know if the girl's a genius or if she's a geek or what, but I don't have the MLS trial on my Law and Crime network. She probably is, but she normally pops in though. Do you know what I mean? She probably pops in and says hello or whatever. I hope she pops in a bit anyway to see. But I didn't know there was another law. There's like 2 laws and crime networks. Jeez, I didn't know. Luckily, Spider found it for me. She's a hero for doing it. Yeah, absolute hero. Um, oh, Danny boy, dee 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 dee. Dee-dee-dee-dee, oh, 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 in my heart, I will never walk alone. You'll never walk alone. Oh, so long with hope in my arms, I will never walk alone. That's the bum 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 ba-dum, 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 bum, ba-dum, bum, bum. What are they? It's like a circus. Bum, bum, ba-da, ba-da, ba, ba, ba-da, ba, ba, ba-da, ba-da, ba, 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 bum, ba, ba-da, ba-da, ba, 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 ba-ba-da, bum, 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 bum. Some 17. Ooh, it's gonna be quite tight. Cue the bagpipes. Yeah, I know. Yeah, bagpipes are good. Bagpipes are good. It's a skill to play it, you know. Some people think, oh, bagpipes is easy. Poof. It's years in the making to play, bagpipes. Still, 13 people not guilty. I wonder if he'll be not guilty throughout, as in all of his cases. Heidi said, like, maybe for one of the things that he might be found guilty for it. Sorry as well, Marcy, to hear about um the issues with your debit cards. That's a right pain as well. With my heart. So, oh, opa, oh, come back with no in my heart, and you never walk alone. You'll never walk alone. It's all right, Marcy. It's lovely to have you here, Marcy. It's lovely to see you back on the stream, as always. You can see, I still don't get any respect of Mad World, Spider Girl, and stuff like that, but nothing changes. Do you know what I mean? It's all good though. Um, I can't wait for this trial to be over though. Do you know what I mean? I've had enough of this trial now. I've enjoyed it up to a certain amount, but bum bum. Oh, hello. Bum bum. Bum bum bum. Bum 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 bum. Bum bum bum. Bum bum bum. Bum 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 bum. So I need to prepare stuff now for this. So if I estimate that we got another hour, say there's another 2 hours after that, then just in case, that would then be my time, 8:15, which is about 3:15 Eastern. Then, well, say 3:30 then. 8:30, 9, 10, 11, 12. Nah, I can't do depth then. If just getting a bit too much then if I do depth. Because depth is a 7.5 hour one, which I obviously would be able to cut it down to about probably 5 hours with breaks and doing a 1.25. But 10, 11, 12. Well, maybe if we start at 8, maybe I'll do it. But anything after 8 o'clock my time, 3 o'clock Eastern, we're not doing it. I mean, I can do without another late night. I got the gym tomorrow morning. I have to go to. I need to set up the stream for tomorrow as well, which will now be Johnny, 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 Johnny Deppy, Deppy, Johnny. I can't call him Johnny anymore. I'm Depp. JD what's it? AH. JD JD and AH. JD and AH. Oh yeah, Marcy, because your team. Well, no, there's no team, but you favoured Amber, didn't you? Ooh, that was long. What was long? What was long, Toxic? Oh, well, you just catch it up with. It was it's just too much. Do you know what I mean? Oh, hey, Meki Teki, how are you, Meki Teki? I said hi to you earlier on. I'm not sure if you saw it. I was trying to be a little bit engrossed in everything. You team Amber, yeah. I think in this stream, I think your team Amber. I think everyone else is team Depp, and I'm like in the middle. I'm slightly towards Depp at the minute. Aldridge sentence, I believe, is that Aldridge one? Hang on, Shelley put it down here. He pleaded guilty to 5 counts of murder and 46 counts of attempted murder. So he's sentenced, but we were allowed to. Well, I mean, you could watch as an individual, but you can't watch it. I couldn't record it, and it says that you'd be contempt of court if you streamed it, so I didn't stream it. So I don't know what you got. Shelley will know though. I'm often an outlier. That's good though. That's a good way to be though. Do you know what I mean? Marcy, that's always a good way to be. Also, it's nice to have different views on it. Looking for a good mind screw. Listen to the 4 hour long JDAH argument. Oh, I mean, the trial itself is a mind screw already. So um. Also, I think everyone expects me to know everything. It's like, guys, I've never watched this before. Like, I didn't even know we start off both of them suing each other, and then yeah, there's so many things I don't know about this trial that people expect me to know. I'm like, I know zero about this trial. I liked that. Oh, what's his name now? I like the witness of Deppard on day 2. His friend, the artist. I liked him a lot. Liked him a lot. I don't remember his name now. Oh, it's on the tip of my tongue as well, but don't remember it. But he was amazing. Um, Day 3 though, the the first witness, everyone loved her. I did not like her. Um, she was who was she? I don't remember who she was now. But everyone seemed to love her on this stream, and I was on my own. I did not like her. I thought she was lying a lot. Okay, life. Well, I mean, he pled guilty, so I presumed he would be. Do you know what I mean? Ba-da-ba. And Spider Girl's not here. I mean, Spider Girl must be sleeping because she's everywhere every day of the week. Like, normally Spider Girl knows what I'm thinking before I'm thinking it. So she must be sleeping right now. Happy days, archived. Happy days. It's weird. So that there's the state trooper or whatever it's called. Obviously, um, oh, what's it called? Let's get it. Na 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 na. Da da bum bum ba 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 bum ba 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 ba. Oh, what's this about? Du- 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 du. Right, let's get ready, let's get ready, let's get ready to rumble. Let's see what the trial is. Oh, Ronald Burgos Aviles, Border Patrol. Um, that one's a trial going on now, obviously with this one and the rapper one. If you want to watch that Toxic, I encourage you to watch it with the MLS Law Show. I know he's showing it at the minute. What are you listening to? Let's get ready, let's get ready, let's get ready to rumble. I don't know what song was playing passing, to be quite honest with you. Fair enough. Yeah, fair enough. What was the death penalty? What, love? How's it going, love? You alright? Seven Nations Army. Mhm. Yeah. Hey, mhm. I don't even know what song that is, though. Seven Nations Army, to be quite honest with you. Du-du-du-du-du-du. Du-ru-ba-ba-ba. Du-rum-bum. I hum a lot, though. That's the problem. Right. Hey, love. I'm having lunch break now. Going to be working on still, but listening. You still are. You listening? Thanks, love. Um, Dave's doing well. He's got a lot of viewers, isn't he, on MLS? You've got loads. You've got 180 odd there. So I encourage people to obviously go over there and support him if you want to watch that trial, or maybe watch it after this trial. Um, I'm only going to be playing the Johnny Depp one, so I don't think there'll be much interest in that. But yeah, you're not modding, are you? I love. Hang on. What I'll do now is because we got that off. Let's put this. I'm not gonna play it. I'm only gonna put it on so you know where to go, guys. Um, let's get, let's get, let's get ready to rumble. Let's get ready to rumble. Ready, steady, and rumble. Everybody rumble. Da-ba-ba-ba-ba-ba. So, stop screen presents. Share screen. That one there, yeah. Share. Weather's nice. Weather's nice.
Of circumstantial evidence, so it went off the rails after half an hour. But
Now there was some. It was interesting because
Here goes Jamie,
the parts that I
David,
heard, I wasn't able to catch
and
it all.
Baker.
The parts that I heard was am I good?
no, it's mine. It's mine.
Okay.
Just so I
The
can chat.
the parts that I heard was that the state is going to say, "Oh, there's no blood on his clothes. There's no blood in the car. There's like a lot of like."
I'm gonna post this in here after this trial. If you want to go over and watch this at 1.25 speed or something, or 1.5 speed, you can do. This is the MLS channel that I'm not streaming anymore. So, but feel free. Jamie's there, Broken Baker's there, and MLS Law's there. I saw on MLS Law's channel.
Missing evidence, and it was interesting that the state was highlighting all the weaknesses of their case. And so I thought, well, this is going to be kind of an interesting case. It might be, a lot of back and forth. What do they really have? And then the defense came up and literally gave a 3-minute and 16-second opening statement, which says basically, don't kill my guy. And that all that cell phone evidence, you're not going to be able to trust that. That was it. I was disappointed in the state's opening, and I'm hoping they have better cross and everything going forward.
Yeah, and it was just strange that the prosecution was saying, well, you need to rely a lot on the circumstantial evidence you see every day in your own life. I would have hammered on that and said, well, all of this is just speculation. They didn't show that they didn't find the knife. They didn't see him at the scene, and you can't trust this, and it's all circumstantial. You could hit on that, but they just did he's probably guilty. Don't kill him.
Young me comes on.
It was basically, yeah, he's probably guilty, but don't kill him. That was literally their opening statement. It was amazingly dumb. I don't know how else to say it. It was amazingly dumb.
Yeah, and it's again, if you don't have a defense, try to make a defense. I know I hate American lawyers because they speak way too long, but 3 minutes and what was it, 36 seconds? It's a bit short.
Yeah, and
I'm not doing this justice because it keeps playing up. So if you want to watch it, obviously go over and watch it, but come back to watch the closing. The final closing argument, come back for that. But yeah, go over there and support it, MLS. Hang on. What have we got there? Right, I need to take that. I need to get the stream back on, otherwise I'll forget. And I'll just stay here speaking. Share screen. Hey, love, you can tell them that we were streaming them, but we've stopped streaming them now, love. Do, 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 do. Right, so live. So here we are. We're back live now for that. So, all right. So get that up. No, not that one. The other one. Um. Okay. So you see, we got a young man, love, Shelley. She's in both shots. She's flying. That's not good. Yeah, no, Suzanne, it's absolutely fine. I don't expect no one to be here, Suzanne. Absolutely, enjoy your lunch. I just speak because mainly for people who watch it back, more than anything. I'm not doing this for you guys. I'm just trying to, yeah, for those, for those that are part of the rewatch crew and stuff, So if you're part of the rewatch crew, you can go over to MLS Law Show and watch it, and then if you're not, then want to watch Johnny Depp, you can stay here and watch Johnny Depp. I just lost half my viewers as well. I don't know why I lost half, but it is what it is. Nothing I can do about it. Ba-da-ba, ba-da-ba. I'm just looking at the chat of MLS Law and young Min is flying there. She's commenting like anything. So the 35 minutes, and then we should be back live. Well, another half an hour, we should be back live. And then another hour of closing by by the prosecution. I do think this judge is a bit biased. I think obviously Mark does push boundaries, but I do feel like this judge is biased. I think he's a bit too much sometimes. I don't see what he sees. I mean, doesn't he see that this isn't like as clean cut? I don't know. He believes obviously that there's enough evidence for it to go to a jury, but I don't know. It doesn't. This trial doesn't sit well with me. I'm glad it's finishing. Hopefully that it'll be done today. I'm not sure it will be done today though, because it is quite complex. With the various charges. So we'll see. So they're in lunch till 2:15. We should be finishing about 4 o'clock, I imagine, totally from there, and then go into deliberation. So we'll be staying on until, well, I don't know. I say we'll be staying on until, I don't know. We'll just have to see. Well, no, I'm staying on until either we get a result or they rest for the evening. And if they don't rest at 5, we might be asking some favors here for someone to ring up the court to see what the hell's going on. I'm gonna message Amy as well to see if she's okay. Um, right, what we're gonna do a tweet instead of a message. Right, here we go. Boom, boom. What have I got here then? Amy, where are you? Here we are. I'm not sure if she's much on Twitter. That's one thing. Just you're missing in action today. Mm. Yeah, that's done. Right, I still don't know where the hell Spidey is. Mm. Mhm. Let's have a gander. Right, we got keep it open till lunch. 100% not guilty so far. Right. Spider sleeping. Spider is 100% sleeping. Unless she's on Discord. If she's on Discord, maybe. Okay, that's fine. What's the 4G? No, it seems Spider Girl is sleeping, so we'll leave her alone. She does enough anyway for us. It was more I wanted to see if she wanted um to do depth this evening. Right, let me try this. Okay, there, okay, there. All right, then. What we have in here then? Let's check. That's a live one. Right. Just gonna set things up ready. I also need to get. Okay. Uh, no, it's not that one. Okay. I said to the stream, I was like, Spider Girl can normally read my mind before I can read her mind. Why the fuck were you not saying anything? I was like, I thought you were sleeping. I thought you were sleeping. I hope I didn't wake you. What's this, Shelley? Oh, hang on. Okay, okay. David Rake. We've been on the source, sir. David Rake, I think you've either fallen asleep on your keyboard or someone's playing a prank on you. But welcome, David Rake, first time viewer. Felonies against traffic closed. Good, as they should. Happy days. Um, right, Spidey, what we'll do, it depends on what time it's on tonight. And then what we'll do as well is we're doing two a day. So you're not expected, obviously, to be here for the whole time or anything. Just jump on when you can tomorrow. I'm probably gonna start at like 2 o'clock East, 9 o'clock Eastern. So don't come on for what? Come on whenever you can. Tomorrow I'm going to try and squeeze 2 days in. I did nap a little bit. I knew you had. I've been speaking about you. I've been We're Spidey, blah blah blah. Right, she's not on Discord. Right, she's not replying on Twitter. Right, she's not replying to you. I don't know where the hell you were. I keep expecting to see lawsuit filed by Mark against the state. Hopefully that. Hopefully. Oh, I don't know. The the next episode of Death, it's that same guy that we ended with, and it was so boring. And then there's a long one with a woman on it. I don't know who David Rake is. I don't know what happened to David. because he's one of those that's you put something on the keyboard and press enter. I'm sure he didn't want to do that, or he may have come in and gone, "Oh shit, this is shit," and off he went. But if you are here, David, very welcome to you. Where you from? Oh. Excuse me. That would mean we got a Dave and a David. Go, Pack, go. Go, Pack, go. Oh, I don't know. I'm sneezing a lot. I'm like, yeah, sneezing. There's another like 20 minutes before we see some people. Mm, I love that. I love these are the kind of messages I love. Do you know what I mean? Obviously, either Child's done it or he was leaning against the keyboard and then pressed enter. And I can imagine that he's also regretting that now. He's like, oh, fuck. Did not want that. And he's probably left because of it. So I love it. You get secondhand embarrassment or something. Oh, well, I mean, whatever we do tonight, we've got to figure something out because unless the judge sends the jury home and be like, no, you come back tomorrow morning and deliberate. And I don't think he's going to do that. But at the same time, if he's going to close at 5 and they finish at 4, there's not much point deliberating. But I just the thought of listening to that guy prosecutor as well. Oh, for an hour now. Oh, I might be half listening to him. We are family. Right, so we got that. Ba-da-ba-ba-da-ba-ba. Ba-da-ba-da-ba. I don't have anything interesting to say tonight. We had a great stream last night, but I didn't get to bed about 3:30 after everything. So up early, well, ish this morning on here. So discussed quite a bit last night. It was entertaining. I loved it. I enjoyed it. I enjoy when people just talk shit and we just speak to each other and stuff like that. No, nothing better. Nothing better. Yeah, nothing better. We sang a lot. We slagged some streamers off. Not really, only one. Um, I don't want to get in the habit of doing that, to be fair. It was just one stream I absolutely despise. But there's more I despise, but it's one I totally despise. So yeah, you be careful with that. Oh, excuse me. Oh, oh, that's amore. Bum, 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 bum. Da, 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 da. That's amore. That's amore. It's a nice evening, but it's like quite chilled as well. It's still warm outside, but not massively. Hey, Spidey, don't worry. You've been sleeping for most of it, so don't worry about it. It's all good. I've got nothing much to say anyway, so not after last night. Oh, we slugging you off last night as well, Spidey. No, we weren't. We weren't. Madwood was though. I wasn't. I messaged Heidi, see if she's okay. She's probably with a neighbour. Don't know. She's been a bit more quiet lately. Still got Gobby 2 years. We still got Heidi around here somewhere, but she's working, I believe, today. Or maybe she's not. Oh yeah, no, I think she's working today. Oh, mother. Oh, if I sleep after my lunch, I don't blame you. It was a bloody long. It's bloody long. Go and get your snack now. Otherwise, we got Grumpy Spider, and I don't want Grumpy Spider. Yeah, I want normal Spider. Well, no, normal as in you're not normal, but you know what I mean, though, innit? The usual Spider, weird Spider. We want back here. I haven't got much to say. Oh, Jesus! Stop yawning, you idiot. What I should have done was just taken a break from this. But I thought I would entertain you. Let me entertain you. But no one's talking in chat, so I can't entertain. Also, that was not a dig at chat. Please be quiet. I mean, I'm happy for you to be quiet. It's just more of a. That's why I'm a little bit quiet. Sometimes you need that, like, chat to be like, whoa, what are we chatting about? That's where Heidi and Amy come in handy because they talk shit. And so yeah, it suits them. But they're both busy. I get it. Ba-da-bum. Dee 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 dee. Oh dee 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 dee. Dee 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 dee. Dee 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 dee. Oh, okay, 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 okay. Dee 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 dee. Dee 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 dee. Hello, Nafisa. How are you? Yeah, you popped in. Oh, no one's here, Nafisa. Everyone's having lunch and stuff. So you popped in. They'll be back in about 10 minutes, quarter of an hour. But it's always nice to see you. Yeah, I saw you pop in. But my chat was all busted up, so I couldn't really see if you were chatting or anything. And yeah, pretty sure that was last night. Or was it Johnny Depp you came? Oh, all these nights are like molding into one for me. Do you know what I mean? But Lady Law was on last night. She was a fantastic guest. Really enjoyed having. Well, I mean, she's one of my favorite guests. Do you know what I mean? Me and Lady Long get on well, so um, I don't have it, Shelley. I'd have to watch it from another streamer somewhere. The webinar doesn't work. Oh, sorry, the other bit. We could, but I don't really want to because I'm not going to cover it. If that makes sense. apparently the defense one was only 3.5 minutes. Apparently everyone was really disappointed with the openings. But I encourage other people to do it. We'll be going back in about 10 minutes, so it's all good. We'll be over and done within 10 minutes, shall. Like to yes. I don't see the live. I was in the after party. Was it? Oh, you were out drinking last night, Shelley. You little minx, you like enjoying it. But also, Shelley, I know that you might enjoy that trial, but it's only MLS one, so just if when you get a chance, look at it. You know, um, I would, I know that you like your trials. I just don't want to compete. That's all. Not compete, but when you got one person covering it and half his viewers are also my viewers, it's like it's pointless. So might as well just let him do it, and we'll do the Johnny Depp one. Young, you off, love? See you later, then, love. If you're off, I hope you had a nice lunch. See you soon. We'll be on for a little bit tonight because hopefully we'll get a verdict this evening. So yeah, stream with Lady Law. I always like doing Lady Law, but we just chat crap. Like we don't really like. We had an hour and a quarter of technical issues. Oh, you just come back now, have you? Well, I just promoted MLS all through lunchtime, but you missed it all. You missed it all. I told you to say hello to them in chat for me. We streamed his stream for a little bit, but you didn't see it, so he never said anything. It's okay though. It's okay. It's okay, love. You see Amber's flip at the film? No, I didn't see. I don't watch stuff like that, so no, I didn't see it. Oh, never thought. Talking about her. That's who she is. Marcy is here as well. Marcy's here. I'm not sure if she's right here now, but she's watching tonight today with us, and she's Team Amber. So, um, no, I never saw that either. Oh, I don't know what you two need to do as well. Community. Where do I go to community here now? Go to the communities tab. Yes, follow us to that. Link. No, I don't want that. I want send you both a link. Copy. Paste. So Niffathat and Shelley, you two need to press this, and then Spider will help you out. That's the Discord for you two, Shelley and Niffathat. All you need to do is literally press that button, and Spider can talk you through it. Choose something so did after hiring a hey Spider, Marcy's here, so you're gonna have to behave now with your depth love because Marcy's team member, so we got a bit more balance in the chat now with Marcy, yeah. And Spider make sure that they Marcy and not Marcy, Shelley and the press that Discord button. Um, I'll try when I have more patience. I have to get a dog unstuck in 5 minutes. No, just you, Marcy. Hey, Spider Girl, nothing. Marcy's here now, so you're gonna have to behave, Spider Girl. Nothing, Marcy. Spider Girl keeps filling my head with misinformation about Amber and stuff. So I need balance here, Marcy. No worries, Shelley. It's all good. Um, Amber isn't lovely, but I think she had the right to write an article. No, Jamie. No. Hey, also, we just streamed you. We just saw you on stream. I was streaming you, MLS, and Baker. We're not shooting you at Marcy. You got a sensible head on you, so it's all good. And yeah, I posted in telling everyone Jamie to go and watch it with MLS this trial, and we streamed you for a little bit. We only streamed you for like 5 minutes, just so that everyone knew what channel he was and stuff. Um, but he had great viewers. He had about 881 or something viewers at the time, so which is good. But I just want to make sure everyone knew what the channel was because we're going to be streaming Johnny Depp from tomorrow onwards, the next trial. So I said I don't want to compete with David and you guys. So um, yeah. Marcy, Spider's gonna have to explain to you what that is. I don't have a clue. Um, so yeah, Jamie, any ideas when the next trial is that on law and crime? You because okay, well, you can explain to Marcy later on what Discord is. Two, three, four, five, six, seven. Okay, that's fine. That's that isn't bad. That's not bad. Saying that, where's my phone gone now? I've got notifications as well. Jamie Tate has another hour. No idea what that means, but hopefully Jamie knows. Oh, yeah, Tate, yeah. So the state have another hour, yeah. I was thinking who Tate was. I thought, is that her new boyfriend, Tate? He's got another hour left in him. Get on it, hopped on. What's that, Jamie? You could always come on for bits and pieces. Come on, what? Come on, Eileen. Something, Eileen. Ah-da-da-da-da-da-da-da-da. Da-da-da-da. Come on, Eileen. Ba, 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 come on. Yeah, thanks, Jamie. I know you will. It just has to be something that UK. Well, I mean, I could get a VPN, I suppose. I got VPN on my phone, but not on my. Um, no, I was going to. I just wanted everyone to know on stream. C-Swept. I just wanted everyone to know. I think some of the guys have gone over to watch the stream with David. I told everyone to go over now, come back by quarter past. I think like 7 people left, so I presume they went over to yours. Um, I've shown it on the stream. I put the link in for people to go and follow it. Hopefully, some people follow it after here. It just happens to be there were some people here that wanted to chat, so I just stayed here to chat and we streamed it for a little bit. Um, that's all. I normally do. I do try and pop in sometimes. While I was watching you, I was looking at young love. She was chatting away in there, and she's chatting here as well. Mm, mm. And I went in to Baker's as well this morning. I gave her a like, and then I saw you were on Baker's as well. Then afterwards, but I didn't see you that much. But then yeah, I saw you, Baker, and David earlier on. I think you were on a lunch break probably. Because you were chatting. Davies was going on about the defense opening was like 3.5 minutes long and was really poor and stuff like that. And it was all about basically not them trying to get the death penalty and rather, well, they basically given up on it and just don't want the death penalty and saying that the telephone communications like or phone datas were wrong or something. So yeah, I'll always promote. I promoted everyone quite big last night. I understand it has a slight impact on my channel, but as I said to everyone earlier on, that like if we're both streaming the same thing, like most people go and watch it with him anyway. So it's like I try not to compete. Um, where I can't, both openings were shit. Okay, I'm quite glad I didn't watch it then. So yeah, that's why we're doing Johnny Depp to try and get that out the way a bit quicker because I'm not going. So Saturday, I think I'm going to do a lone stream or not lone stream, like not a Depp stream, just a I don't know review or rant or something. I don't know. We'll see. Or get people on or something and just ask a question stream kind of thing. Because Spidey's not here, so I don't want to do it without her. It's her baby, so actually that's a good idea. How many? Oh, actually, how many? How many is there for this one? There is. mm, It's about 24 days. So that means if we can, even if we do all this week, what's it today? Monday. So that'll be 4 and 5, 6, 7, 8, 9, 10, 11. If I can get to day 11 this week, that's, we've done quite well then. Because I want to get through it a bit quicker. I don't want to miss um, college football. So that'll be 11. Have you seen Lefty at all, then, Jamie? 12, 11, 12, 13, 14, 15, 18, 19, 20, 21. That's end September, yeah. I need to shape up for these. I want to finish them by end of August. So I might do some Saturdays and Sundays with Johnny Depp now, if that's the case. 11. What's what? I don't know. People want me to say Bumblebee and 11 and stuff. I don't get it. I don't understand. Gotta shape up, boo, 'cause I need a man. And Amy's back in chat. Better shape up. Amy's back in chat. Goldby's back in chat. Amy's back in chat. Um, Amy, I messaged you on Twitter, Amy, because I was like, where is she? Because this is Amy's baby, this trial. I hope everything's okay for you, Amy. We miss you whenever you're not here, and it's a lot quieter without you. So it's lovely to see you back. Um, we've seen the first part of the state of being, the woman, then Mark's been, and then we got another hour left from the state, and then they go and deliberate. Um, I- Accents. I know it's the accent, but I don't. I think I say 11, but the same as everybody else. So I don't get it. He commented David's stream a while ago, but that was it. Yeah, it's weird. He's not been here today. I don't think we had a lefty something here today. I'm not sure if he's changed his name, but yeah, weird. And Amy's dancing. Oh, dancing. Let's go dancing. Dance, 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 dance. Um, oh, we all are. 11. I don't. I just say 11. I don't get it. We had Lefty's Wild Kingdom, so I presume that's him. Lefty's Wild Kingdom. That's probably tag it in now. Yeah. I just tagged him in there now. Lefty's Wild Kingdom. I'm not sure if it's him or not, but it's I've not seen him today. I think he's popped in for some reason. I don't know why. But yes, so Saturday I might do something a little bit different because Spidey's not here Saturday, so I might do a different stream just similar to last night. I thought last night was quite good. Unfortunately, it was unfortunate you had that date, Jamie, because I think you'd have enjoyed it. Um, you know, I'm sure you enjoyed your date as well, so it's all good. So yeah, we'll have some stuff going on Saturday. No Johnny Depp Saturday. Johnny Depp today and the rest of the week though. I'm gonna cram one out tonight. And I'm not talking about having a wank. I'm talking about I'm gonna cram a Johnny Depp one out tonight. Um, lol, I didn't have a date. What? Why did everyone say you got a date then? Everyone's like, yeah, Jamie's gone on a date now. I just thought you were on a date. Grease. Oh, da da da. Hey, Grease Lightning, go Grease Lightning. Ba da ba 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 ba. Grease Lightning, go Grease Lightning. And I don't really know anything. Someone said I got married. Oh, I didn't believe that. I mean, I just thought you were um going out on a date. I never thought what I'm bad at is names of songs, as in um it's just I don't remember the songs, but if it was in the background, I could sing it. Go Grease Lightning, da 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 da. Grease Lightning, go Grease Lightning, da 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 da. I can do that, but not actual song. Someone saw I get married. No, someone said my boyfriend was going to be mad. Well, there we are. Saw Lefty in the stream last night in the chat. Oh, well, it wasn't here. It wasn't here. That's for sure. Enough of that. Wasn't here. He was supposed to be bringing it, but dinner with someone, and I have no idea where it came from. But you guys just ran with it. I ran with it because I thought it was true. I thought you were going on a date with somebody. So I was like, cool. Might have had to chase him before you heated it up to eat your meal because of sounds. And you might have had to chase him before you heated it up to eat your meal because of Sal's chat. I don't get that. Oh, she had to eat a meal quickly before she got on with Sal's channel. I'm with you. I'm surprised Sal wasn't here last night because he loves Lady Law. I mean, we all do, but he loved. And I thought um, once he saw Miss Morgan, I thought he's gonna love Miss Morgan as well. You might have to, yeah, yes, that was my fault. C-Swift started the rumors. Oh, I didn't. I was just like, cool, that's good. Get in there, Jamie. Get your slice of it, innit? Get your date out of the way, then get in that bedroom. Let's get it on. Let's get it on. Jamie there. Let's get it on. They were talking about cannibalism and night James went out to dinner. Ah, right, okay, I'm with you. I saw some of the pictures. I saw some of the pictures of them. Amy, where you gone now, Amy? You gone quiet again? I don't like when Amy goes quiet. You might have a crate to it. Was that the one that looked like cum? The white one? Because I'm sure someone said, or maybe it was me saying that's what Jamie's getting tonight, and not the food. She's getting on. Jamie's gonna get it on. That's fine. I mean, you're just quiet. Y- You're gobby one. You're never gobby two's not here, so you have to be the gobby one now. You have to make sure the chat's on the go all the time. Because whenever you're not here, it goes quiet or it goes rude like this. People misinterpret my demented humor. They instead of her eating a human. Okay, okay. Okay, now that's definitely Sal's stream you're talking about because Sal loves that. I mean, maybe I will. Who knows? There we are. You go get that cum, Jamie. You go and get it. Good girl. Um, right, where am I there? Um, oh, Jamie, where have you gone then? I thought you're not on. Oh, right, okay. David's watching States opening. Are they done for the day then, Jamie? See, isn't funny. Cum dumpster over here. I mean, you just started your own nickname now. Cum dumpster. Jamie is a cum dumpster. Well, why do you do that, Jamie? You just basically created yourself a new nickname. Cum dumpster. The only good thing for you is I won't remember it. Otherwise, you'd be fucked. Clacky head. Here she is. All right, love.
There's actually a lot more involvement that juror had in the Parkland case than I believe was led on to either myself or Mr. Interaction with.
Right, I don't want to skip too much here because something's happened. Something's happened here.
The presence of the jury. State, anything you need me to address before we bring the jury in and conclude with your rebuttal argument?
Yes, Judge. So it has come to our attention that one of the jurors had an interaction with one of our victim advocates from the state, and they let us know about that interaction. But then when I asked how the two knew each other, there's actually a lot more involvement that juror had in the Parkland case than I believe was led on to either myself or Mr. Iglarsh. I spoke to Mr. Iglarsh about it. Essentially, that juror participated in penalty phase, showed up to the courtroom. It knows the victim advocates by name from our office, and approached her in public, gave her a big hug today during lunch. So, you know.
What number is that
I
juror?
don't recall her number. It might be 3.
Well, let me go sidebar real quick.
Fuckers, right, hang on.
3 would be out, and then that would move juror number 7 in as the last juror. Is that what you want me? Okay, so if I grant that request, juror number 3 would be out, and then that would move juror.
Hello, Jamie. Oh, here we go. Right, Suzanne, hang on. Problem with the juror.
Do you have any request as it relates to juror number 3 based on this?
Yes, Judge. In light of the announcement, and I'm extremely grateful for the state disclosing that immediately, this was a potential juror that I spent considerable time on, even saying, listen, you're a victim rights advocate, and I have concerns about letting you on this jury. Convince me essentially that you can be fair. And she went on and talked about how she had no connection to the case, and it's the opposite now. And there is a significant question as to whether she can be fair and impartial, whether she withheld information, potentially be a stealth juror. And I appreciate the state not opposing our request to have her removed and bring in the alternate.
Okay, so if I grant that request, juror number 3 would be out, and then that would move juror number 7 in as the last juror. Is that what you want me to do?
Yes, Your Honor.
State, any objection to that?
Okay.
Okay, so right now, the jury consists of juror number 1, Juror number 2, 4, 5, 6, and 7. The alternates remain 8, 9, and 10. Juror number 3, I'll grant the defense request to excuse her for cause, but I'll just keep her here and then dismiss her with the alternates at the conclusion of the arguments today, barring something else. State, any objection to proceeding in that manner?
No.
Defense, any objection to proceeding in that? No. State, you're otherwise ready to proceed?
Yes.
Mr. Kilburn, are you going to require the T?
So Nike has a slogan.
All right, let's go through this. So what happened was she's been a victim in the past, and also what happened is what I can understand happened is that juror number 3 had worked with some of the witnesses for victim impact, and she'd been at different cases, trials, and stuff, and she had a lot more involvement than she led on. So she basically lied um, on it. So yeah, and that's what happened there. They were just told today about it. I don't 100% know what happened, but that's what I'm led to believe. Hang on, I can go back again to listen to that part if you want. This is the part. This is the part again. Listen if you can to this.
Had an interaction with, one of
Right. Here we go. Right. So it's she had interaction with a witness basically. It's going to be played here so you can listen to it yourself now. But I don't skip it too forward. Then we'll catch up with the actual closing arguments. You hear it all now. I'm just letting it play because I don't want to skip it and you miss it. And knowing my luck, knowing my luck, I'll press it and then we'll miss it.
State, anything you need me to address before
Here we go.
we bring the jury in and conclude with your rebuttal argument?
Yes, Judge. So it has come to our attention that one of the jurors had an interaction with one of our victim advocates from the state, and they let us know about that interaction. But then when I asked how the two knew each other, there's actually a lot more involvement that juror had in the Parkland case than I believe was led on to either myself or Mr. Iglarsh. I spoke to Mr. Iglarsh about it. Essentially, that juror participated in penalty phase, showed up to the courtroom. It knows the victim advocates by name from our office, and approached her in public, gave her a big hug today during lunch. So, you know.
What number is that
I
juror?
don't recall her number. It might be 3.
Okay.
Let me go sidebar real quick.
So I'm not sure if you all caught that. Did you all catch that? So basically, victim number 3 had interaction with a victim advocate witness, and this juror also participated quite a bit with the Parkland case at the penalty phase, and also attended the courtroom during the Parkland trials and stuff like that. So she's aware of a lot of this case, and that's why they pulled in her, because she also knew the um, victim advocate witness by name. So yeah, it's not it's not gonna be called a mistrial because they've got the alternate, but that's it. I'm just gonna put some lights on, and also I'm gonna grab a quick coffee. I'll be back.
Jurors entering.
Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, welcome back. Come on in. You all may be seated. All the parties may be seated. Ladies and gentlemen, those of you using the notepads, I'll give you a moment to get the notepads back out. All right, ladies and gentlemen, welcome back. I hope you had a nice lunch break. Before the lunch break, we had heard the state's closing argument as well as the defense closing argument. All that remains is the state's rebuttal argument, which we are going to proceed with at this time. Mr. Kilman, when you are ready, you may proceed.
Thank you, Judge. Good afternoon, ladies and gentlemen. So Nike has a slogan. Their slogan is just do it. Having sat through this trial, just like you guys have for the last month or so, the thought that keeps popping up is just do it. Just do something. Just do anything. You're trained, as you heard from Lieutenant Colonel Samaru. Your mere presence as an officer can stop an active shooter. Your mere presence there will throw them off their plan. And in this case, Cruz's plan was to kill as many people as possible. Looking in the window, opening up the door. Opening up the door, you would have smelled the gunpowder, just as officers have testified. You would have seen the carnage. You would have had that information. That information that Scot Peterson chose not to gather. Instead, he chose to run away 75 feet from the building. I want you to think back, and I'm not going to show you all the videos because, frankly, I only have an hour, but I want you to think back to that video of all those children during the fire alarm coming out of the 700 building. And when shots are fired, and we heard from a whole bunch of them, when loud noises were heard, what did they do? They instinctively ran away from the 1200 building. The same building that Scot Peterson was outside of for 48 minutes. 48 minutes. You know, I downloaded a timer on my clock to play for you guys during my closing of 48 minutes where he stood in his fixed position. I decided not to go that route with the closing though. The defense said that the defendant had no clue where the shots were coming from. If that were true, he wouldn't have stayed where he was for 48 minutes. Where he saw, as I was saying before, those kids come out of the 700 building and run instinctively back. Well, what didn't you see? What didn't you hear about? Any kids coming out of the 1200 building at the same time. So we asked you in jury selection to use your common sense. Common sense dictates that if hundreds of kids are pouring out of the 700 building because of a fire alarm and not one kid is coming out of the east side doors of the 1200 building, something's wrong in the 1200 building. And what did Mr. Peterson choose to do? Run away. 75 feet. Didn't open the door, didn't look in the windows, didn't go BSO. Didn't take out his gun and shoot it into the ground. Something, anything to show his presence, his mere presence in the building, to throw off the killer from shooting innocent children. He had a Glock on his hip that day. Those kids on the 3rd floor had pencils. They were about as helpless as an infant. And what did the guy who calls them my kids do? He ran away. Because if those were actually his kids, let me tell you something. I don't think he would have ran away. I don't think he would have stayed in a fixed position for 48 minutes if those were actually my kids. You heard from the cop yesterday, whatever his name was, Perry. You heard him say, they're not my kids. They're not my school. That's a caregiver, because an SRO is a caregiver, who doesn't care. And you want to know who another SRO who was a caregiver back on February 14th of 2018, who didn't care? Scot Peterson. He chose his own life over every single person in that building. Those kids on the 3rd floor, those teachers on the 3rd floor, Mr. Beagle, he chose his life, even though he had this vast training. All of this evidence you get to take into the jury room, and you can look at anything you want. This yellow folder right here, which is States 13, is his training. This is the logs beginning in 99, and remember, he was a cop about a decade earlier. This is all of the training he had. He was an SRO basically his entire career. This is what he was trained to handle. And when the shots started, what did he do? He ran away. Now, this is the part of the closing that's called the rebut. And what does that mean? That means I get to rebut, try to convince you that what the defense attorney said before lunch is incorrect, and explain why. Now, this is an interesting rebuttal, because while I'm going to talk about what the defense attorney spoke about, I'm first going to talk about what he didn't talk about, which is, Judge, if I could use the Elmo, please. The elements of the crime. Ladies and gentlemen, this is why you've been here for 4 weeks, to see whether the state can prove beyond a reasonable doubt these elements. Now, Ms. Gomes in her opening went thoroughly through all of the elements, and I'm going to touch upon them just very briefly. Defense didn't mention it. They talked their fantasy.
This is a massive dig at the defense. So if you remember, the defense Mark asked for an additional 20 minutes because he said, I've not had a chance to go through all this paperwork yet, and didn't realize I'd run out of time. So can I have a bit more time to go through it? It's really important. And the judge said no. And now look what's happening. He's slating Mark and the defense because they didn't go through it. And he knows exactly what he's doing here. Bastard. But clever as well.
Story about what this and the football fields and all this. The state called witnesses to prove elements. We called the medical examiners to talk about the kids getting killed, because we have to prove an element. We had the stipulation signed to show that the kids were under the age of 18. Why? Because we had to. We had to. These weren't even mentioned. Not even mentioned. Now, what the defense did say is the state needs to prove everything beyond a reasonable doubt. That's not true. We need to prove the elements beyond a reasonable doubt. So for neglect of a child And I'm not going to read them through. You can read them yourself. You're going to get a copy when you go back to the jury room. Those are the 4 things that we need to prove for each person under the age of 18. For culpable negligence, these are the 2 that we have to prove beyond a reasonable doubt. Nowhere in there are you going to hear we need to prove that he knew precisely where the shots were. We don't need to prove that. Now, we can certainly show it, and that's going to be the next part of my rebuttal, but we don't need to prove it. We only need to prove this checklist, as you saw Ms. Gomes check off the elements. That's our entire job. And when the defense gets up here and says it's a 5-minute not guilty, we're not looking at the elements, ladies and gentlemen. When I'm done and I sit down, you're going to hear the jury instructions. And part of your job is you swore when you took the oath to be a juror is you're going to follow the instructions. Let me tell you, those instructions are a lot. If you can read them in 5 minutes, God bless you. But you all held up your hand. You all said that you will follow the law. This is the law. This is the law for culpable negligence. This is the law for perjury. When Scot Peterson lied to cover up the fact that he didn't do anything. It's not that he was on the hot seat with Curcio, with Detective Curcio. Detective Curcio was talking to him because he was the first responding officer. He needed to get information from him for his investigation into Nicholas Cruz. Defense asked, well, why would he lie? He lied because he didn't do anything. He lied because he had a responsibility as a caregiver to those kids to do something, and he didn't. Now, although it's not an element, I'm going to talk about common sense, how the defendant knew the shots were in the 1200. Well, let's start off with the fact that campus monitor Medina, whose only job is to observe and report, calls over suspicious person into the 1200. Now, to believe the defense, he didn't hear that radio. Just like his friend who helped him move, or not his friend, Arthur Perry, said, oh, he conveniently didn't hear pertinent calls either. But he didn't hear that. Suspicious kid in 1200. Firecrackers. Yet when he gets in with the car with Medina, he gets dropped off where? The 1200 building. And if you remember Kelvin Greenlee's testimony, when asked, was it possible there was a conversation between Peterson and Medina, he said it was possible. He didn't hear it. Watch the video. He's riding on the back like Batman, going up to the 1200 building where he hears noises, but he still continues on the way, even though he's an unarmed security specialist. Now, dropped off at the 1200 building. Then we can talk about the dispatch calls. And you can hear them. They're in evidence. How many times does Scot Peterson say 1200 building? By inside, near, he's saying the 1200 building. That is the building he is describing repeatedly. That is the building where the kids ran from, that he saw, back to the 700 building. That's the building that he, according to some of the defense witnesses, he's crouched pointing at. You heard from all the witnesses, he's scanning the area to the west, which, by the way, just happens to be where Nicholas Cruz ran out by himself minutes after any other kid came out. And he's the only one that ran that direction, but you guys can check out the videos for yourself. And looking to the north, where the 5 kids ran out. Now, I had this whole elaborate plan and rebuttal to show all you guys these videos, but you've been sitting here 4 weeks, you've seen the videos, and frankly, you have access to the videos in the back. But when you watch that video, and it's F12, I want you to notice something about one of those 5 kids running out. She has a balloon in her hand. It's Valentine's Day. When she's running out of the building, she doesn't drop the balloon. She's a kid. She runs with her balloon. So the defense to say that because of a couple pipes and a fence and a pillar, he can't see her, that is what they call malarkey. Okay? She has a balloon in her hand. He's had the strategic vantage point, according to the defense, to see her. And he conveniently doesn't see her. Because what would that be? Hey, where's the shooter? But if he asks that, guess what? He's got to go in. So it's not asked. Let's just presume something. This isn't reality, but just bear with me. Let's just say the state could no witness. We just put on the dispatch tape. We just put on the dispatch tape, and we just put in the statement that Peterson gave to Detective Curcio. Even those alone, just those two, would show he knew it was this 1200 building. Listen to the dispatch. He talks about the 1200 building. Besides saying his location 700 one time, it's the only building he mentions the entire time.
Judge, objection, misstatement of the facts.
The objection's overruled. Again, ladies and gentlemen, you all will determine what the facts of the case are. Go ahead, sir.
And what was his job, knowing that it's in the 1200? As Ms. Gomes said on the first part of closing, it wasn't to engage in a firefight. It wasn't to get into a gun battle. It was to make his mere presence known, to mess up the shooter's OODA loop. And that's what goes through, I guess, shooters' minds when they're trying to kill innocent children. And yet he chose not to do that. And let's just presume, based upon the defendant's statement, although you can hear in the back of the dispatch, other shots are being fired, let's just presume 2 or 3 shots. So there are reports of firecrackers from the 1200 building, and you hear 2 to 3 shots from a building you ran away. What does the training say to do? What does common sense say to do? What does the fact that you're a police officer say you do? You go and investigate. You don't go back and play on the radio for 48 minutes. You go and gather intelligence. You go and do your job. And he didn't do that. And that's if you consider just the dispatch and just the statement. Yet the state has shown so much more. You heard from the 2 people standing near the defendant, Mr. Greenleaf and Mr. Scott, that they knew instantly 1200 building. Scott waited inside 1200 building. Those are the 2 that had the same perception, the same vantage point as the defendant. The kids called running out of the 700, different vantage point, different perspective. The cops up on Holmberg Road, who, by the way, were told to stay back by Peterson, they're 100 yards plus away. They're there for mere seconds during the shooting. He's there for 4 minutes and 15 seconds. He hears 70 rounds. This is states 48. You heard from Detective Crespo. This is just a mere sample of the shell casings where he has the audacity to say here 2 to 3. You heard those videos from Danielle Gilbert and Ivy Seamus, the first 2 witnesses in this case. And once again, I'm not going to play the videos for you right now, but you can take them in the back and listen to yourself. How loud. This sounds like artillery shells. That he says 2 to 3 shots. Defense keeps saying that he had to know precisely where the shots were coming from. That's just simply not true. That's not what the training says. Why do you seek out a shooter? To find the shooter. And let's be honest, after you heard from Lieutenant Cardinale about what classroom his son was in, he didn't know the different classrooms anyway, even though he's been the SRO there 9 years. His job was to go investigate and make his presence known. And that simply did not happen. Now, one of the very important intricacies in this case is in regards to training. And it's in regards to when shots are being fired versus after shots are being fired. When shots are being fired, there is one and only one priority, and that is to seek out the sounds of the shots. Whether the person barricades themselves, kills themselves, flees, your job and only job is to go seek out that shooter. It's not to put that or lock down the intersection on homework. That's a secondary thing. You are to go in. Now, after the shots are over, you're trained to look for additional stimuli. You're taught to investigate as a police officer. You look for things such as blood, such as bodies, as callous as that sounds, such as smoke, such as shells on the ground, maybe, like 130 of them. You're trained to look in windows, as the defense witness Goolsby said when he got to the 1300 building, he looked in the windows. That's what you're supposed to do. You're supposed to be proactive. Even Stombaugh, who got on scene, and someone called out that they needed overwatch, and he drove around the sawgrass. Even he was proactive. Literally every cop, even Perry, who I couldn't get a truthful answer out of, did something. He scanned the area. He did nothing. So much so that even when it's all over, he doesn't go inside to help with the rescue efforts, to help with the medical treatment. You saw the records, you heard about it. Rescue task force, after a shooting's over, what do? Every shot that you hear could be another dead body, and you need to stop the bleeding. He doesn't go in. Once again, it's not an element we have to prove, but it's just common sense. He did jack. He did nothing. So he didn't go in. Why? To see the carnage, especially on the 3rd floor, that he allowed to have happen because he chose his own life over students in the freshman building, over 14, 15, 16-year-olds, over Meadow Pollock, who just turned 18, over Scott Beagle. Now, the defense went through all of the witnesses, and they asked some questions. Why were they called? I'm going to go over the state witnesses, just very briefly, I promise. First witness is Gilbert. Defense says, didn't show anything having to do with this case. I actually could not disagree more if you paid me. Because through her, you heard how loud that cannon was. That's how loud it was. That's not made up. That's not CGI. That's not audio from Hollywood. That was real life, how loud that was. Once again, feel free to listen to it. Same with the second witness, Ivy Seamus, her video. How loud that gun is on the inside. It's ridiculous how loud it is. That's why they were called. Heinrich. Heinrich is watering the baseball field. He hears firecrackers, draws his attention. What does he do? He runs unarmed, wearing basketball shorts to the building. Unarmed, no vest, nothing. His son goes to that school. He has kids. He knows something's wrong. Does not hesitate. Comes across Elliot Bonner, Vietnam vet, shot a gun for 3 years in Vietnam. Reversing, saying Feist is down. Does Heinrich turn around? He's not a caregiver for them. He has no obligation to those kids. Zero. Does he turn around? No. He keeps going forward, unarmed. And what does he do? He sees Kyle, and you heard from Kyle, and you saw that poor kid's leg. And what does he do? He helps Kyle. Because according to Jeff Heinrich, that's a catastrophic injury. That means that kid can die from that injury. And he provides treatment. And you heard him, he brings him along the fence, ultimately over to the dugout, to the office. Now, on their argument, they said Heinrich heard every single shot. I think they're forgetting that Heinrich went around and was in the baseball office, but I digress. Defense said he took a tactical position of cover. Yeah, for a couple seconds. And then even unarmed, he still had action, made action. And frankly, saved Kyle's life. Ryan Stobley. Ryan Stobley was a security monitor. You see Ryan Stobley on video. Once again, I'm not going to show it to you. You can watch in the back. All the shootings going on, he, because of his concern to protect these kids, walks out. And you can actually see him. Once again, it's on F13. You can see Stobley because he sees kids in the parking lot and he's waving them away. His concern is not for himself hiding. His concern is to try to help those kids. And what does he say? He says, shots from just a few minutes later. And also with Burton. When Burton arrives on scene, defense in their closing said he was facing the 1200 building. Now you can recall on your own what the testimony is, but I'll tell you that's wrong. Now when Burton got there, his friend told him the parking lot. So he turns around, exposing his back to the 1200 building. Thank God the shooter is gone, or else he could have gotten a bullet in his back from his friend for 7 years, who he called Scotty. Once again, priority of life to Mr. Peterson was Mr. Peterson, then everyone else. And you saw Burton, big dude. And Peterson tells him, don't know where the shots are coming from. Why? Why does he tell Tim Burton that? Because Tim Burton would have went in. And if Tim Burton goes in, guess who basically has to go with him? So instead, he says, check the parking lot. But use your common sense. By the time Burton gets there, Miller's already up on Holmberg. Other BSO officers are already up on Holmberg. They can see that whole parking lot from where they are. It's a total fiction. Total fiction. They hear about the +1 in training. They said, no, let's say parking lot. Because he wasn't going in no matter what. You heard from Miss Lapel, who got shot to get her students in that room, to protect the kids. You heard from Brett Schroy from Coral Springs. Defense says, oh, he doesn't give intel to the defendant. The defendant is the first deputy on scene. He is literally the real-time intelligence, literally. But he chose not to look in the windows, open the door, or do anything. You heard from crime scene and Detective Suarez. This is actually quite important. You heard from the detective. No fragments came out. No bullets came out the south side of the second floor. Defense concocts a story about a sniper. There were no bullets. There's no round confirmation. It didn't happen. You heard from Danny Polo in the mask. Went in to save lives. And the defendant had the audacity to say that if the defendant had the same information, he would have done the same. The defendant was there, supposed to gather real-time intelligence that didn't move for 48 minutes. Didn't even help with the rescue effort. Yet he's going to besmirch heroes like Danny Polo. Moving on. You heard from Gloria Crespo, crime scene. I can take out the shells. 70 shots on the third. I'm sorry, let me start back. 61 shots on the third floor. 61. And if you remember her testimony, 28 of them were from the east side. Why is that important? Because on the east side is where the defendant's near. 28. So even if they want to say, oh, it's 73 yards away, the building's 73 yards, well, you heard testimony that 28 of those shots were on the east side of the building. That's much closer to the defendant. You also heard that she's in charge of the school resource officers up in Deerfield. And she explained their responsibility, the mentorship, administrative searches, the differences between regular, standard road patrol cops and school resource officers. Her testimony highlights that they're caregivers. They're different than regular officers. You heard from DeRosa, who's constantly moving. And once again, I can show you a video from the camera angle of F-13 towards the end. Because remember, Peterson's there until 3:11. At about, I'll give you a time, you can write it down if you want to or not. But at about 3:01:59, you see DeRosa with a whole bunch of other cops searching the area, clearing the buildings. And what is Peterson doing at this time? Take a guess. Hasn't moved. You heard from the Emmys. Awful testimony. Needed to be put on to show the injuries. You heard from Sandler. And on cross, defense started off with, here we go, folks. This is the head of training. This is the guy that trains all the other cops what to do. And I'm not going to go through all of his testimony. He was on the stand for hours. What's the most important thing to glean from that testimony? That when you hear shots, you go towards the shots. Defense said in their closing, we still don't know what we were supposed to do. Yeah, we do. Yes, we do. We know exactly. You can ask any cop what to do when you hear shots. You go to the sound of the shots. You seek out the shooter. You gather intelligence. Your mere presence will stop it. You can look at the training. It's in that yellow folder. You can look through it all. It's all right there. You heard from Calvin Greenleaf, and I already talked about his testimony, but the most important thing is he's standing right next to the defendant when they're dropped off by Medina. And when those shots were shot into Coach Weiss and they ran away, he was standing right next to him. And his testimony was 1,200. That's the best vantage point. The best witness for us is he was standing, he said, within 5 feet of them. And you heard from Cardinale. You heard from Cardinale that his kid was in this building. The BSO officers are telling him to stay back because of Peterson's instructions. And his kid's in the building. And what does a real parent do? Not my kids, but a real parent. He said, fuck you. And he ran into that building. And he ran over there because his actual kid is in that building. And he is going to save his kid, not my kids. And lastly, you heard from Curcio, Detective Curcio. Now, his job was to investigate the shooter, not him. But one of the responsibilities is to talk to the first person on scene, and you hope they tell you the truth. Well, in this case, they didn't, because 2 to 3 shots, it's not just said one time. It's the whole transcript. It's 36 pages. Page 9. How many rounds do you think you heard? It wasn't many, 2 to 3. I can see down the sidewalk looking out west. I get a good dimensional of that whole building at that point. Why is that important? For the kids running out with the balloons and for when Cruz runs out the west side. His own words, 2 days after the shooting. right here, page 12. And what happens from there? He's talking about Tim Burton. No more gunshots. It's not that he says 2 or 3 one time. He says it 3 times. You're going to get a copy of the information. That's like the charging documents the judge explained. He doesn't say it one time, saying, oh, Curcio didn't ask me in chronological order. He backs up his lie. He says it 3 times. The other part about the kids coming out of the building, page 14. Right here. But we didn't see any kids. When I was there on scene, there were no individual kids running out. Okay, so there was no kids that ran out to say to you guys, hey, there's a guy up there or anything. No, you didn't see any kids until people started being evacuated by their police. Yes, that's a lie. That's perjury. It's that simple. And I could do that for all the defense witnesses. I'm just going to lump them, save us some time. You heard from a few witnesses who weren't on scene during the shots. And let's be honest, that's the important part. DeVita, who at BSO, who actually did something, he actually ran around the entire campus trying to be proactive and trying to do something even though shots are over. You heard from Oakley. What did Oakley say? He could have asked for a patch at any time. He's the first responder. Defense is trying to blame all this patch stuff. He just had to ask for it. Then you heard from Mines, Angela Mines, head of the regional communication. But what did she say? Throttling doesn't occur until they're at capacity. That means when all of BSO responded, yeah, there were radio issues. You heard from DeVita, defense witness, that when Captain Jordan queued up the first time, guess what? It worked. They weren't at capacity yet. The radios were working. You can hear it on the dispatch yourself. Was it a little staticky? Sure. Children were called to say they didn't know where the shots were coming from. Children. Kids. Who said, I thought a bomb went off. You heard Dylan Redshaw say, I was wondering where the cops were. These kids ran predominantly back to the 700 building, away from the 1200 building, mind you, because this was the most startling, scary moment of their young lives. You heard from teachers who, based on their training, their code red training that they all followed, that testified their responsibility to protect the kids. It's not their job to seek out the shooter. It's not their job to seek out the sounds of gunshots. It's their jobs to protect those kids. That's what they did. And you heard from cops who at the very tail end of the shooting got there. You heard from Kratz, who proactively was trying to save those kids on the bus line after he got information to set up a perimeter from him. Contrary to training, Kratz didn't know what was going on. He wasn't standing 10 feet from the building when the first shots were happening. So he listens, and he ends up helping Kyle as well. You had Miller. Yeah, he's the sergeant, but you heard from him. Rank doesn't matter at that juncture. When you're the first responder, you call out what to do. Miller's locking down the intersection. That's what he was told to do. You heard from Goolsby. Goolsby ultimately makes entry and gets up to the 1300 building. He's doing something proactive. He heard shots, not sure where because he's 100 yards away and he only heard a couple shots, but he tries to do something. You heard from Stombaugh, who when he went out at the radio, Overwatch on Sawgrass, he went to the Sawgrass. And you heard from Perry, who, I hate that I have to say something good about him, but at least he scanned the area to the football field. He wouldn't say they were his kids and he wouldn't say it was his school, but at least he did something. And let me remind you about all of those officers. They are not the SRO of Douglas. They are not the caregiver for Douglas. He is. You heard from Sandra Rennie that when she saw Peterson run, She thought he was doing something, investigating. Boy, was she wrong. Because it was the exact opposite. He was running to stand in a corner for 48 minutes. Now, I'm going to go back kind of what I was talking about earlier, about what the defense's theory is, about the 1,200. Even if it was just firecrackers, even if he just thought firecrackers, his job is to go and figure that out. His job was to go into that building. And once he determined, based on the dispatch, shots fired, that those are gunshots, his job is just mere presence. Now, obviously, we recognize that Scot Peterson did not murder the people in the building. Nicholas Cruz did. This isn't a murder trial. This is a child neglect, culpable negligence, and perjury trial. Why those charges? Because that's what he did. Once again, going back to the elements, it's a checkbox. That's what he did. Defense used an example about a siren. When you're on the road and you hear a siren, you don't know where it's coming from. But let's take that a little bit further. When you're on the road and you hear a siren, what do? You look, and you keep looking until you find the ambulance or the fire truck. And what do you do if it's behind you? You move. You take action. You do something. You look in the windows. You open up the door. And after it's all over, you go help with the kids that were shot. If you truly think, oh, it could be 1300 building, then you go investigate the 1300 building. If you hear shots fired from Kratz and you believe that, although you know better because you're standing 75 feet from where the shots are actually happening, then you go to the football field. You don't just stand in that corner. That's not what you do. He knew enough, Peterson knew enough to do something, but he chose to do nothing. There's another little theatrical thing I was going to do for you guys and play it downloaded now yesterday to show 4 minutes and 15 seconds. And I was going to stand up here and not say a word for 4 minutes and 15 seconds. But based on your faces right now, I'm not going to do that to you. But I do want you to realize when you take that evidence back, that in that 4 minutes and 15 seconds, all of those shots that were heard, all of the shell casings, in those 4 minutes and 15 seconds, where mere seconds matter. Joaquin Oliver was killed. Scott Eagle was killed. Jamie Guttenberg was killed. Meadow Pollock was killed. Peter Wang was killed. Carol Lochner was killed. Defense is argued 4 minutes, 15 seconds. What was he to do? It took SWAT 30 minutes, 10 minutes. Remember, SWAT didn't hear shots. SWAT didn't hear shots. He did. He knew where it was going on, and he chose to do nothing. The priority of life was not Kara. It was Scott. prosecuting a police officer is not a fun thing. Police officers take an oath, just like you guys did back a month ago, when you said to raise your right hand, said you're gonna follow the law. Police officers are given a badge, they're given a gun, they're given power. They can go into your houses, they can stop you in a car, they can arrest you for committing a crime. With that power comes responsibility. With that power comes duty. With that power comes what you heard from basically every other cop that took the stand, that said, I didn't want to go there. I don't want to be at a shooting, but that's my job. We're paid to do it. And on February 14th, 2018, that's what those officers did. Except for one, the guy sitting back there. He had the badge, he had the gun, he had the responsibilities. He had those kids to take care of as a caregiver, to watch out for their welfare, to make sure they were okay. I mean, you even heard it that day. He was meeting with someone's father about a fake ID. That's not what regular cops do. They arrest you. He was more than just a cop to those kids. He was their protector, the only one on campus. And when a madman came on campus and did the unthinkable, he chose his life over everybody else's. And like I said, this isn't fun. But just like those cops have a job to do, we have a job to do. No one is above the law. Not even a police officer, not even the SRO of the year, not even the deputy of the year. That when you break the law, you will be held responsible, because no one is above the law. Ladies and gentlemen, when you look at those jury instructions and you see those elements, you all know right now, I want you to go in there and read the instructions, but you all know right now, this case is a slam dunk. He neglected those children. He was responsible for them. And the worst thing imaginable to a parent, even Scott Beagle's parents, even though he was an adult, the worst thing imaginable happened. And he stood on the sidelines. And because of that, we're here. And because of that, ladies and gentlemen, he's guilty of every single one of these crimes you charged. Thank you.
Thank fuck for that.
Okay, Mr. Newland, thank you very much. Ladies and gentlemen, I'm going to give a quick restroom break, and then I'm going to read the jury instructions to you. Same admonition as always. Please don't discuss the facts of the case, the evidence, the witnesses, or the testimony amongst yourselves or anyone else. When we reach the end of the trial, we're almost there. If you leave those notepads in your chairs and step back one moment, I will be right back with you. Thank you.
Oh, the whispering at the end was just too much. Like, fucking hell. This is a slam dunk. Yeah, not guilty. I felt so sorry for him listening to that crap. Oh,
Okay, we're outside the presence of the jury. Real quick, 5-minute restroom break. We'll be in recess for 5 minutes.
right. We go here then. It was Geo. It's really. So we go here in chat then. Whispering was cringe. Jesus. Peterson's pissed off. Don't blame him. Right, I'm gonna start the other stream as well now, so there's gonna be 2 streams on the go. No one did. Yeah, I can stop it now, can't I? It's done now. So let me entertain you. I mean, look, anything but not guilty would be wrong in my opinion. 20 votes, 100% not guilty. That's quite substantial. Right, I'm gonna have 2 streams on the go. Um, just because, so we're gonna watch this here, but the other stream's gonna be running, so you know where to go. Um, go live, go live. So I'm live in the other one as well. We're 2 streaming it. Look at us go. Oh, hi, Kim. Didn't notice you there. You snuck in there through the back door. Oi, oi. Um, yeah, I think I just That's a long deliberation. I think it's going to be. Do you know what? I don't think it's a slam dunk. I just it goes back to what Marcy was saying this morning. Like they're playing to the heartstrings. So if anyone feels sorry for them and whatever, then they're going to vote guilty. But I'm certain there'll be some that were not guilty. Hello. It's just obviously who, when, how, all that. Right. Let me just get this one up. I've got 2 streams on the go. There we go. This jury instructions is going to be long because the state, the pricks, did not allow them just so basically reading every single one out, uh, or however many they are, identical because that guy there, the dick DA, didn't allow the defense the suggestions saying, well, why don't you just read it once, Your Honor, and just say it covers it's the same for everyone, so we just save a lot of time. State like, no, no, we want to read it for each and every one. Yeah, yeah. The jury are not going to be happy with that. So whatever. So yes, as I say, you've got 2 streams in the go. The description is in. No, no one's there. What's going on? Why is no one there? Um, so you can go over there and take a look if you want to. Take a look if you want to. Look if you want to. I'd look too if it happened to you. But that's where we're going to do verdict watch, and that's where we're going to do um, the Johnny Depp. The reason for that is, and I'm shutting this down, is 2 reasons. One, because I want to do playlists, and it doesn't make sense to me to put Johnny Depp here. So that's one reason. 2, people will say to me, you need to make like 2, 3 videos a day, not just one, because YouTube doesn't like it. So from now on, I'm going to start trying to do 2 videos a day, as in over lunchtime, take half an hour break and do another stream. So if he's not guilty, are the Jews going to have to move away for fear? I don't think so. I don't think so. I think when you got 20 people here, I wouldn't say that we got 20 sensible people in this chat, but when you got 20 people in the chat going not guilty, I think that speaks volumes. And I think there's other people in that area that will also say not guilty. Obviously, you're going to have people saying he's guilty. Um, I think this would probably be up there with the biggest travesty ever if he's found guilty because he's in jail for what, 100 odd years, whatever it is. That's going to be a dangerous precedent, I think. If he gets this for this amount, then the Uvalde one, bloody hell, all of them are going to be in jail for life as well. So I don't know. This is a tough one. This is probably the most scared I've been in a while over a trial because I can see the jury just thinking with their hearts rather than their heads. And it just annoys me the way they just I don't know how they can prosecute him and sleep at night. I just don't know. You gotta be ruthless to do that job. People say, "Oh, you defense lawyers protect, killers and all that." Yeah, well, they're entitled to a defense. But these guys, they probably know themselves, this is not really fair. one guy being accountable for it. So they're doing their jobs, but it's like, not to go into it. The police department trains all officers not to go into a dangerous terrain until backup shows up. Yeah, but what they're saying, Kim, is it's different for a shooting, that everyone is trained. You have, even if you're on your own, you just go straight to the danger, and they're trained to do that. That's what everyone's. That's what the training officer said. That's what everyone said. And I said, please let the judge sentence Conrad not consider. But it, but he's in. Well, I think that he's in jail for life, though. Whatever happens, if he's found guilty, I think he's done for. I think he's in jail for the rest of his life, from my understanding of it. But could be wrong. But no, I'm pretty sure it's the rest of his life. Um. So I don't know. This is a tough one. Tough one, just because I just think it's not guilty. And George ridiculous. Well, I think it's like much more than 100. I think, but it's like split down. I don't know. But anything in jail is, do you know what I mean? Is ridiculous. Yeah, it should never been a criminal charge. Marcy, you've not been here, but everyone says the same. Everyone said the same. It's just ridiculous. Judge is back now. Can I be on 2 streams at once? I think I can. So, welcome to the Johnny Depp stream. Just to let you know, I'm also streaming another stream at the same time. So I'll put a link at the bottom to say where to skip to with the Johnny Depp trial. But I'll stay on here we're covering the Parkland trial. So yeah, that's what I'm concentrating on right now. But it should be fine. Hopefully both sides can hear me okay. And they'll probably be able to hear both as well. So, and I'm on my own. Oh no, am I? No, there's a few more people over in the Depp one now. Hello, people. Oh, and they left again, you bastards. Why'd you leave? You and me were meant to be. You and me were meant to be. Yeah, yeah. See, Marcia. I just call you Marcy all the time. Marcy, Marcia. You are my fire, my only desire. For you and me. I want it that way.
Bring the jurors back in, read the final instructions to them. After that, I'm going to do a sidebar on the headsets, and without
Happy
raising any
days.
prior objections as to the jury instructions, I'm going to ask each side if they have any objection to how I instructed the jury. I'm then going to identify the alternates, which are jurors number 3, 8, 9, and 10. Ask them if they have any personal items in the jury room. If so, I'm going to have the court deputies assist them in retrieving all their personal items and bringing them back into this courtroom. I'm then going to have the 6 members of the jury retire to begin their deliberations. After that, I'm going to instruct the alternates that all the communication rules remain. I'm going to send them home with the instruction that I will call them and let them know when their service is complete. And should I need to summon one back here for some reason during the deliberations and order that jury to begin their deliberations anew, they will be available to me to do so.
Right.
And then I'll probably let them go, I would say, at least till 6 o'clock tonight. And they do not reach a verdict by 6 o'clock, send them home. Ask them to be back here at 9 o'clock tomorrow morning, and as soon as I have the jury back, they can resume their deliberations. State, any objection to proceeding in that manner or anything else you need me to address?
No,
Defense, any objection to proceeding in that manner or anything else you need me to address?
no, Your Honor.
Okay, please bring the jury back.
What are we doing? Why are they showing all that? Happy days, Dave. Okay, Dave, we got you. We got you, Dave. Go, Pack, go. Go, Pack, go. Kim, if he's guilty, he's got life. I don't see him seeing the daylight, any daylight ever again. Well, it depends which one the guilt.
Jurors entering.
Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, welcome back. Come on in. Once you're back to the same seat, you may be seated. All parties may be seated. Ladies and gentlemen, those of you that are using the notepads, should you choose, I'll give you a moment to get the notepads out. I will let you know that you should each have an exact copy of the instructions that I'm about to read to you. You will be taking those with you when you begin your deliberations. Besides all the evidence, you will have a copy of the jury instructions, you will have a copy of the charging document, and you will have the 11 verdict forms that I'm going to go over with you momentarily. Okay, so if you want to take notes during my instruction, you may do so. Obviously, if you do not want to, you do not have to. You all have an exact copy of what I'm about to read to you. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Scot Peterson, the defendant in this case, has been accused of the crimes of neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child, great bodily harm, permanent disability, or permanent disfigurement. Neglect of a child without great bodily harm, permanent disability, or permanent disfigurement. Culpable negligence, culpable negligence, culpable negligence, and perjury not in an official proceeding. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Anthony Borges with the care, supervision, and services necessary to maintain Anthony Borges' physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Anthony Borges from abuse, neglect, or exploitation by another person. 2, in doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Anthony Borges. 3, Scot Peterson was a caregiver for Anthony Borges. 4, Anthony Borges was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Kara Logren with the care, supervision, and services necessary to maintain Kara Logren's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Kara Logren from abuse, neglect, or exploitation by another person. 2, in doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Kara Logren. 3, Scot Peterson was a caregiver for Kara Logren. 4, Kara Logren was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Joaquin Oliver with the care, supervision, and services necessary to maintain Joaquin Oliver's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Joaquin Oliver from abuse, neglect, or exploitation by another person. In doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Joaquin Oliver. 3, Scot Peterson was a caregiver for Joaquin Oliver. 4, Joaquin Oliver was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing death, causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following four elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Kyle Lehman with the care, supervision, and services necessary to maintain Kyle Lehman's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Kyle Lehman from abuse, neglect, or exploitation by another person. 2, in doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Kyle Lehman. 3, Scot Peterson was a caregiver for Kyle Lehman. 4, Kyle Lehman was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following four elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Jamie Guttenberg with the care, supervision, and services necessary to maintain Jamie Guttenberg's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Jamie Guttenberg from abuse, neglect, or exploitation by another person. In doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Jamie Guttenberg. 3, Scot Peterson was a caregiver for Jamie Guttenberg. 4, Jamie Guttenberg was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following four elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Peter Wang with the care, supervision, and services necessary to maintain Peter Wang's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Peter Wang from abuse, neglect, or exploitation by another person. 2, in doing so, Scot Peterson caused great bodily harm, permanent disability, or permanent disfigurement to Peter Wang. 3, Scot Peterson was a caregiver for Peter Wang. 4, Peter Wang was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. To prove the crime of neglect of the child, the state must prove the following 3 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Marian Kabachenko with the care, supervision, and services necessary to maintain Marian Kabachenko's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Marian Kabachenko from abuse, neglect, or exploitation by another person. 2, Scot Peterson was a caregiver for Marian Kabachenko. 3, Marian Kabachenko was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. 1, Scot Peterson exposed Scott Beagle to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. 1, Scot Peterson exposed Stacy Lapel to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Meadow Pollock to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of perjury not in an official proceeding, the state must prove the following 5 elements beyond a reasonable doubt. 1, Scot Peterson took an oath or otherwise affirmed that he was obligated by conscience or by law to speak the truth during a sworn statement. 2, the oath or affirmation was made to Broward Sheriff's Detectives John Curcio and Jeffrey Curtis. 3, Scot Peterson, while under an oath, made the statement. Question: okay, all right, once you get closer and you hear those guys, how many rounds do you think you heard? Answer: it wasn't many. 2, 3. Question: okay. Answer: so I'm right there, I'm on the radio, I can hear the units coming. And the next thing while I'm keeping an eye on the door in the building, no shots, nothing anymore. It's quiet. Question: all right, what happens from there? Answer: and he, Officer Tim Burton, runs up by the tree, and I'm just telling him, you know what I heard? I heard a couple of shots. Haven't heard anything since. And he's just taking cover by, behind the tree. I'm taking cover here. And units are now starting, no more gunshots, and units are starting to come in. Question: okay, now did you ever see, while everybody is starting to arrive, did you ever see any of the students leave building 12 at all? Answer: yes. Question: which were they all the doors or? Answer: no, they were evacuating, and they were telling them they were taken out, and the kids were going out toward the parking lot. Question: okay, but that's when the officers. Answer: when the officers came. Question: inaudible. Answer: but we didn't see any kids. No, when I was on the scene, there were no individual kids running out. None. Question: okay, so there was no kids that ran out to say to you guys, hey, there's a guy up there or anything of that? Answer: no. Question: you didn't see any kids until people started being evacuated by the police? Answer: yes. 4, the statement was false. 5, Scot Peterson did not believe the statement was true when he made it. Knowledge of the materiality of the statement is not an element of this crime, and the defendant's mistaken belief that his statement was not material is not a defense to the charge. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusations have not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of neglect of a child, great bodily harm, permanent disability, or permanent disfigurement are neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, and culpable negligence. The lesser crime indicated in the definition of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement is culpable negligence. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Anthony Borges with the care, supervision, and services necessary to maintain Anthony Borges' physical or mental health, or Scot Peterson failed to make reasonable effort to protect Anthony Borges from abuse, neglect, or exploitation by another person. 2, Scot Peterson was a caregiver for Anthony Borges. 3, Anthony Borges was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Kara Logren with the care, supervision, and services necessary to maintain Kara Logren's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Kara Logren from abuse, neglect, or exploitation by another person. 2, Scot Peterson was a caregiver for Kara Logren. 3, Kara Logren was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Joaquin Oliver with the care, supervision, and services necessary to maintain Joaquin Oliver's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Joaquin Oliver from abuse, neglect, or exploitation by another person. 2, Scot Peterson was a caregiver for Joaquin Oliver. 3, Joaquin Oliver was under the age of 18. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. 1, Scot Peterson willfully or by culpable negligence failed or omitted to provide Kyle Lehman with the care, supervision, and services necessary to maintain Kyle Lehman's physical or mental health. Or Scot Peterson failed to make reasonable effort to protect Kyle Lehman from abuse, neglect, or exploitation by another person. 2, Scott Peterson was a caregiver for Kyle Lehman. 3, Kyle Lehman was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. 1, Scott Peterson willfully or by culpable negligence failed or omitted to provide Jamie Guttenberg with the care, supervision, and services necessary to maintain Jamie Guttenberg's physical or mental health. Or Scott Peterson failed to make reasonable effort to protect Jamie Guttenberg from abuse, neglect, or exploitation by another person. 2, Scott Peterson was a caregiver for Jamie Guttenberg. 3, Jamie Guttenberg was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. 1, Scott Peterson willfully or by culpable negligence failed or omitted to provide Peter Wang with the care, supervision, and services necessary to maintain Peter Wang's physical or mental health. Or Scott Peterson failed to make reasonable effort to protect Peter Wang from abuse, neglect, or exploitation by another person. 2, Scott Peterson was a caregiver for Peter Wang. 3, Peter Wang was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. 1, Scott Peterson exposed Anthony Borges to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to the consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Kara Logren to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of the persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Joaquin Oliver to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of the conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Kyle Lehman to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Jamie Guttenberg to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Peter Wang to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of the conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Scot Peterson exposed Marian Kabachenko to personal injury. 2, he did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, You may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged, or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. Ladies and gentlemen, I know it's hard to see from over there, but you have a one-page verdict form for each of the 11 counts. All of them have the state of Florida plaintiff versus Scot Peterson defendant with this case number, and then they're labeled. Count 1. We, the jury, find as follows as the defendant in this case. Check only 1. Let me read that part again. Check only 1. And then you have 4 choices. A, the defendant is guilty of neglect of a child, great bodily harm, permanent disability, or permanent disfigurement as charged in the information. B, the defendant is guilty of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement, a lesser included offense. C, the defendant is guilty of culpable negligence, a lesser included offense. D, the defendant is not guilty. So say we all this blank day of June 2023 at Fort Lauderdale, Broward County, Florida, and there's a place for the foreperson to print their name and sign their name. So once you come to unanimous verdict as to count 1, you will check the appropriate box. The foreperson will date the verdict form, print their name, and sign their name. Since the same crime is alleged in counts 1 through 6, the verdict forms for count 1 through 6 are identical. They each have the same 4 choices. You can match up the verdict form for each count with the copy of the information that you will have. The verdict form for count 7 reads as follows. It has 3 choices. We, the jury, find as follows as the defendant in this case. Check only 1. A, the defendant is guilty of neglect of a child without great bodily harm, permanent disability, or permanent disfigurement as charged in the information. B, the defendant is guilty of culpable negligence, a lesser included offense. C, the defendant is not guilty. So say we all this blank day of June 2023 at Fort Lauderdale, Broward County, Florida. Again, a place for the foreperson to print their name and sign their name. So once you have come to unanimous decision as to count 7, you will check the appropriate box. The foreperson will date the verdict form and print and sign their name. The verdict forms for count 8, 9, and 10 are identical as they all charge the same crime. They all read as follows. This is the verdict form for count 8. We, the jury, find as follows the defendant in this case. Check only one. There's 2 choices. The defendant is guilty of culpable negligence as charged in the information. Or B, the defendant is not guilty. So say we all, this blank day of June 2023 at Fort Lauderdale, Broward County, Florida. And again, a place for the foreperson to print their name and sign their name. So once you have come to unanimous decision as to the verdicts into count 8, 9, and 10, you will fill out, check the appropriate box. The foreperson will date it, sign their name, and print their name. The verdict form for count 11 has 2 choices. It reads as follows. We, the jury, find as follows as the defendant in this case. Check only one. A, the defendant is guilty of perjury not in an official proceeding as charged in the information. B, the defendant is not guilty. So say we all, this blank day of June 2023 at Fort Lauderdale, Broward County, Florida. Again, a place for the foreperson to print their name and sign their name. So once you have reached unanimous decisions to count 11, you will check the appropriate box. The foreperson will date the verdict form and print and sign the verdict form. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with anyone outside of the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction that I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. Excuse me. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Quick sidebar with the attorneys, please.
Get the fuck out. Get fucking done, man. I am pissed right now. This is like an hour. Started the fucking stream so that we can jump straight in there. That's over an hour.
Okay, ladies and gentlemen, everyone is feeling healthy, ready to deliberate.
What's the point?
Anyone's having a problem, raise your hand.
It's like half an hour to go.
Okay, I don't see any hands. Okay, ladies and gentlemen, again, we're going to do this by number, by the number that's on the back of your lanyard. Where is juror number 3? Juror number 8, 9, 10. Jurors number 3, 8, 9, and 10, you all are the alternate jurors. Just you 4. Do you have any of your personal items in the jury room right now? Okay, the court deputy is going to escort you back. The other 6 of you, please remain in your seats. And I'm going to have you 4 get those personal items and come right back here, and I will wait for you.
So there's only 6 jurors then. Yeah, number 3's got the boot. No, number 3 got the boot. She's just got the boot now. I'm not sure they knew who the jurors were. I don't think they knew who. You got to echo. Yeah, I have, because I got the other stream going. That's why, Shally. I'll just shut up. Right, once we press this, I'll end broadcast. Okay. Yeah, I don't even think they picked the jurors. I think they were all there, didn't know who was going to be the actual jurors. You hear what he's going to say, and then we're going straight to Johnny Depp. I thought we were going to start this like an hour ago. Amy, yeah. If this stream doesn't boot you over to the other stream, oh shit, I can mute the other stream, can't I? There we are. If this stream doesn't boot you and you want to come and watch Johnny Depp for a bit, the link is in the description box. Press that link. A juror, basically, well, I'm not sure how it worked. I don't think she was a juror. I think what they did was selected 10 people, and then they were saying out. He told us before, course, that with the jury. Sure. Yeah, so I just think that they didn't know exactly who was going to be alternates, who wasn't going to be alternates. So number 3 had an interaction with one of the witnesses, basically, and didn't disclose it, Lefty, and basically knew the person by their
Okay, ladies
name and
gentlemen, welcome
everything,
back. You can go right back to your seats.
and basically participated in the Parkland courts hearings and everything. So she knows everything about this
Okay, I've got everyone
case.
back. You have
She
all
never
your
said
personal
that.
belongings from the jury room. Okay, so the 4 of you, 3, 8, 9, and 10, if you will remain in your seats, I have separate instructions for you. The rest of you, ladies and gentlemen, which is 1, 2, 4, 5, 6, and 7, you may now retire to begin your deliberations. You can take the notepads with you. Momentarily, we will send back to you the verdict forms, a copy of the charging document, as well as all of the evidence. So at this point, you may retire to begin your deliberations.
For like 25 minutes. This is so pointless. Like, I'm a little bit annoyed now. So
Okay, we're outside the presence of the jury. Everyone can be seated. So ladies and gentlemen, 4 of you, your jury service has not concluded at this point, okay? You are going to be under the same communication rules, all the rules the same as I've instructed you throughout the entire trial for the following reasons, okay? Again, I place no time limit on the deliberations. The jury may take as short or as long a period of time, but, and it has happened in the past, sometimes things come up and we have an emergency with a deliberating juror. If that were to occur, and I had to replace one of the deliberating jurors, I would do that with one of you since you have heard all the evidence in the case. So I still don't want you to talk to anyone about the facts of the case. I don't want you to do any research, nothing on the internet, no newspaper, no television news, no social media. Momentarily, we're going to get you If BSO is going to escort you out of the building, I will keep your notes in the notepads. We're going to lock them up. I want you to keep the lanyards. Okay, I have your phone numbers. If the jury reaches a verdict, I will call you. And
Yes,
let you know
definitely.
that you're discharged at that point. And then at that point, you're free to talk to anyone you want about this case, or you're free to talk to no one about this case. That will
I
be
think
up
she
to
said,
each of you. But until
I
I
would get
call
to-
you, please operate under the same rules as I've been instructing you since all the way back on June the 5th. Again, I may need you, one of you, or more than one of you. And again, it has happened in the past. Does anyone have any questions about that at this point? So I'm not going to give you a specific day or time to come back. Resume your normal lives. Keep the lanyard. I will keep your notes. If and when your jury service is concluded, I will call you and let you know. And then,
No, it's not quite
if
right.
not, I
Let's
usually
see.
just ask the people to mail the lanyards back, and we always get them back. So I trust that you guys will mail them back to us. And unless you have any other questions, again, with the same admonition, please don't discuss the facts of the case, evidence, witnesses, or testimony. That would be included amongst yourselves as well as you're walking out. Again, with my great thanks for your time, effort, and energy throughout the entire process. And there's also a certificate and a thank you letter that my office will deliver to you, but that will be after your jury service is concluded, which isn't just yet, but hopefully will be.
All right,
soon.
Judge, fucking
So
get on
that
with
being
it.
said, I hope you all have a good night. I wish you a good return to your lives tomorrow, and then I will be in touch with you when you're going to be discharged. So at this point, have a good night. Talk to you soon.
So she didn't lie because she said to them that she had worked with the victims, but she didn't say to what extent. Not like she didn't say that she'd been caught and that she'd knew some of the witnesses by name, some of the victims by names and stuff like that. So she told them, but she didn't say the
Okay,
extent
we're
of it.
outside the presence of the jury. Everyone can be seated. So I'm going to do a quick recess, but then I'm going to need the lawyers to come up, take a look at the verdict forms, the dummy copy of the charging document, all of the state and defense exhibits and evidence. Then I'll go back on the record. I'll let C side if they have any objection to any or all of those items going back to the jury. Once you tell me that you don't, or I address any issue that comes up in that regard, I'll send everything back to the jury. Like I said before, I think I'll let them go probably to about 6 tonight. So then we would otherwise be in recess till we hear from the jury or until we resume deliberations tomorrow. So quick recess so you all can come up here, go through all the evidence, the verdict forms, and the charging document. Quick recess for 5 minutes.
So 9 o'clock.
And then I'll go back on the record when you all are done reviewing that.
We're done. So 9 o'clock Eastern tomorrow. I'll start streaming again. No, so they interviewed her and everything, and she promised that defense. She knew the case, but she could be fair, and she wasn't that involved in it. Um, so the defense let her in basically with the provision that she had an open mind to this case. Um, and that's how it went. But they didn't know how close, and she basically been to court every day with Nicholas Cruz, and she'd been to a lot of panels and stuff like that. That's what she had elaborated to essentially. So yeah, I agree. She should have said it, but she's not going to be. She's not going to be get any perjury, or she's not going to get anything wrong. Um, So well, I think that I don't know. Anyway, I don't know, guys. But at the end of the day, she's not going to be perjured. She didn't lie. She just didn't, you know, she didn't ex- expand on everything. But then, did they ask the right questions to her? I don't know. So, but essentially, she's now been relieved of her duties, and nothing's going to happen to her. Well, unless she gets called as an alternate. Um, but wherever. Anyway, right, guys, I'm gonna close this down then. Hopefully, it gets you straight over there. If not, please click the link in the description box. We're gonna be 9 o'clock tomorrow morning Eastern time. Um, streaming this one again with Johnny Depp. So I'll see you on the other stream if you make it. If not, I'll see you tomorrow morning. Cheers, guys. Ta-ra.